right.
And it's a weird way to teach it because there are no right angles.
I've stopped.
I don't know, I'm not.
I just
I was going through the same thing.
not in a little city. It depends on the mayor.
They just have discussion ladders for all the books and stuff.
We just had a meeting in his office. Yeah, kind of follow.
Oh, yeah.
No, I'm just giving them what I like.
Yeah, so I did the GPA land, then we might need to run out.
What I've noticed, or maybe it's speakers, but education.
I'm revising a paper on
Well, right in law firms, I mean, other than talking to their other people, don't like.
saying, I don't know, saying Second Circuit is wrong, which I think is correct. Yeah, Fourth Circuit is City of Baltimore and there's also what the police do.
People were used to being there.
Other than that, well, the defendants are trying to mix it all up. But ultimately, clear picture is important. So they have to argue if the claim only arises under federal law. And so then therefore it's placed, even though international paper versus US state, I mean, they have this whole perpetrated argument. I'm not doing it. So that's the most immediate thing. I also have to make sure my first panels, you're going to panel. Okay, there's the. You guys can go up there, I guess, or you can go around either way when I'm done. Either way, I just want to make sure you're all in the room. And I just have to make sure everyone else.
I'll just set up right here. No, unless someone's sitting right here.
Yeah, I was one of the ones on the line.
Or no, the keyboard is back to podium. Oh yeah,
Was an online participant. John was and he's taking classes with Soraya.
She says it's about 2 hours.
Mine was Ocean because we were passing.
You never know.
Yeah, most of it. Although it's not texting them, and immediately.
I'll follow you. I'm last, so I'll follow whatever you.
So do whatever you want. If you want to stay there, I will set the precedent and I will hand you the keyboard to advance your slides and then this the rest of that. Thanks for coming.
The insanity.
Good morning. It's great to see you all here. Welcome on behalf of the law school, on behalf of the Coleman Burke Center for Environmental Law. Welcome to our conference on the 50th anniversary of the Clean Water Act, the past, present, and future of our nation's primary federal law concerning surface water quality. It's in some respects appropriate to have this conference here. Some of you have heard me on this ad nauseum before, but our city has an interesting place in the history of water quality regulation and the history of environmental policy. It's not always a well understood story, although it's more understood now, I think, than it used to be, because events here certainly helped catalyze the political movement for a federal statute like the Clean Water Act of 1972. As you probably all know ad nauseum, this picture appeared in a 1969 issue of Time magazine, a story that reported on an incident in June 1969 when debris and oil and chemicals on the surface of the Cuyahoga River caught fire. Time thought that was sensational, a river burning, and published this picture in which it also talked about the sad state of Lake Erie and the environmental problems that were faced not just by Cleveland, but by many cities and parts of the country. But as you all probably know, there was a fire in June of 1969. This is not a picture of it. It's a picture that is, to this day, still often reproduced in articles and tweets and web postings and the like, talking about that fire, but it's not a picture of the 1969 fire. As best we can tell, this is the closest we have to a picture of that fire. It burned somewhat intensely, but was out within 30 minutes. It caused some damage to a railroad trestle. Was a minor story of only a few column inches in the local press. Where'd the picture come from? There was a really bad fire in 1952. A fire that, had it not been on a weekend, would not have only caused millions of dollars in damage, but almost certainly would have resulted in the loss of life had there been people working on the docks and the like that day. And if we go back in history, there are in fact lots of fires on the Cuyahoga River, samples of press clippings from Cleveland's history about the risks that fire posed in the early 20th century. We can also, though, find accounts of fires in, and this is important for those of us who are from Cleveland and get harassed by our friends in other cities, that there were fires in Columbus, and there were fires in Detroit, and there were fires in Philadelphia, and there were fires in Baltimore, and there were fires, in fact, on industrial rivers throughout the country. By 1969, we'd kind of forgotten about that. because that was a problem that had largely been addressed, not because of what we would today think of necessarily as environmental reasons. It was because fires destroy things and risk lives, and even the companies that were the source of those problems realized that liability, loss of employees, loss of valuable things was something that they should do something about. By 1969, though, we were concerned about other things. We weren't just concerned about property damage. We were concerned about the ecological health of our waterways. We were concerned about the effects that the accumulation of contaminants, the failure to control and treat sewage and the like had on us, had on the broader environment. And there's no question that the picture was a vivid image, and we know how important images are in politics to help catalyze political movement. And so if one goes back and looks at the history of the Clean Water Act, one certainly sees references to the 1969 fire here, even though it, again, was not the type of problem we were now focused on. It was a symbol of things that we cared about. And so it's appropriate that we're here in Cleveland to talk about the Clean Water Act and its first 50 years. It's also timely. I would in some way, I'd almost like to say I planned this, but I didn't. But it's very timely to have a discussion about the Clean Water Act this week, because the Supreme Court is certainly interested, it seems, in the Clean Water Act and could have an effect on some of the things we talk about today. It was already the case that the Sacketts, a couple some of you may be familiar with, who have been to the Supreme Court before in their tussle with Clean Water Act regulators, with the EPA and the Army Corps of Engineers, are getting a second trip to the Supreme Court to try and bring clarity, narrow, constrain, pick the adjective you like, the scope of the Clean Water Act's regulatory jurisdiction. And the way the court has styled the question presented in this case leaves the field open. We could get a narrow technical opinion about how circuit courts are supposed to apply the Marx rule when they're concerned, or we could get, here's in fact what the Clean Water Act means, period, for now and all time, or at least until Congress revisits it. And if that weren't enough, just a couple days ago, we had an order off the shadow docket, or the remote motions docket, or the emergency docket, or whatever we're supposed to call it, staying a lower court decision that had invalidated a Trump administration regulation, narrowing the ability of states to subject federal permits to, or narrowing the ability of states to raise their concerns about the environmental effects of certain permits under Section 401 of the Clean Water Act, and I know we'll talk about that today as well. The litigation in this case is continuing in the lower courts, and will presumably reach the court at some point. But the fact that 5 justices thought that a stay needed to be entered now certainly is an indication that 5 justices at least have some concerns about Section 401 and the way it has been understood and implemented and enforced for, now I'm going to embarrassingly forget what the year of that decision was, but for about the last 30 years or so. So there's potentially change on the horizon, lots to talk about in terms of not just the past of the Clean Water Act, the present of the Clean Water Act, and given that we still have water quality problems that we are concerned about, the future of the Clean Water Act. A few other quick words. Things like programs like this would not be possible, certainly were not for all of you, the speakers and moderators that are here today, students of the law review that are helping with the logistical stuff, our AUV folks, Eric and Patty who do the work supporting the centers, the law school, which has been incredibly supportive of programs like this. And I should also say to Coley Burke, who 3 years ago gave the law school $10 million to create an environmental center and to create programs like this, to allow discussions like this. Coley's no longer with us, but I think he'd be proud to see that we're carrying on investigating and examining issues that mattered to him and trying to put those resources to good use for the students, for the study of environmental law, for the broader community, and we certainly appreciate that he made things like this possible. That's it for now, so I will turn it over to our first panel. I'll ask our moderator and first panelists to come up to the bench. And again, thank you all for being here. I think we're gonna have an exciting day, and I'll look forward to the conversation.
While we're getting organized, let me take a quick minute to ask you all to read the bios of the speakers, since they're all distinguished and eminent professors and scholars. So I will just very quickly note, and hopefully you can see who is who, but we have here Nina Mendelsohn, professor of law at University of Michigan Law School. Please look at all of the publications, books, etc. for everyone. Also, Professor Robert Adler from the University of Utah College of Law, and Professor William Busby from Georgetown. And really, truly, we want to get to what they're going to be talking about, so.
Can you all hear me? Okay, all right, wonderful. Thank you so much for the invitation to participate in this great day. And as Professor Adler mentioned, it's especially fitting that Case Western is hosting because of our proximity to the Cuyahoga River and, of course, so the Clean Water Act is one of our great public interest statutes enacted during that public interest era that also gave us the Clean Air Act amendments of 1970, of course the Endangered Species Act, the Occupational Safety and Health Act. Okay, thank you. All right, that's the kind of feedback I'm grateful for. Okay, so the Clean Water Act is one of our great public interest statutes, right? This came from an era that also gave us the Clean Air Act amendments of 1970, the Endangered Species Act, the Occupational Safety and Health Act, the National Environmental Policy Act. I would even include the Voting Rights Act and the Motor Vehicle Safety Act of 1966. And of course, the Clean Water Act gave us ambitious water quality goals. So let's see if I can get the slides to work. What's the best way to get the slides to work?
The space bar or the down button?
Excellent. Thank you. So the enacted purpose, of course, of the Clean Water Act is well known. It's ambitious to restore the integrity of the nation's waters, including ending pollutants discharged into the waters by 1985 and achieving the protection of fish, shellfish, and wildlife even earlier by 1983. And of course, as you all know, the core jurisdictional term in the Clean Water Act is waters of the United States, the definition of the term navigable waters. And as you all know, and this is the focus of my remarks this morning, the Supreme Court has been changing its approach to interpreting that term, that core jurisdictional term, and that change is linked importantly to the rise of textualism as the dominant mode of interpreting statutes. So the point I want to make this morning is that textualism, as applied in the particular setting of the Clean Water Act, gives us some important lessons about that interpretive method. And in particular, textualism has some significant and negative impacts on Congress, and in particular on a Congress that is trying to enact public interest statutes. So these are some of the core claims for textualism. The theory here is the text is the law, and the idea is that judges are most faithful to Congress when they take that position, that they focus on the text constituting the law, rather than say the law's spirit or the law's goals. On this theory, judges are most faithful to Congress when they take this approach. But of course, the text is not always clear. It can be ambiguous. It can be fuzzy. Categories can have fuzzy boundaries. And so textualism has its preferred interpretive methods for resolving those difficulties. rather than looking at legislative history, textualists try to extract the most meaning from text by using things like dictionaries and canons or even corpus linguistics. The theory is this makes interpretation, better approximate what Congress is trying to communicate with its text, and it's more constrained on judges. It's less easy for judges to manipulate the statute and come out with a result that they prefer. So with respect to Congress in particular, the theory is this is more faithful, and Congress knows how its statutes will be interpreted and can adjust accordingly. So we can learn some important lessons about textualism from looking at how the court has handled this key issue under the Clean Water Act, waters of the United States. And again, of course, that phrase affects the major operative portions of the statute. They don't have any application if a water body is not within waters of the United States. So this is Riverside versus Bayview homes. This is actually this is one of the earliest Supreme Court cases on waters of the United States. This is actually a photo of Lake St. Clair, Michigan, my home state, which is the focus of this case. This is not, as far as I know, the waters involved in the case, but it is similar. And the court in this case unanimously decided wetlands adjacent to Lake St. Clair, whether or not they had a surface water connection to the lake, qualified as waters of the United States. The court stated, its ruling affirming the inclusion of these marshes was consistent with the Act's approach, which was a kind of a broad, systemic view of protecting water quality, including, and the court recognized, the Act took an ecosystem approach and was focused on controlling discharges at the source. So the court said it was reasonable for the Army Corps of Engineers, which was the acting agency in the case, to take a rule-based approach and generally to include adjacent wetlands because, in general, wetlands were likely to have a broader impact on the quality of water across the entire ecosystem. And I know there will be many people speaking to the function of wetlands today. But the point is, the court was willing to take an expansive approach in response to the Army Corps of Engineers. But later cases shifted to textualism, and the effect was to downgrade both these kind of overarching goals and deference to the views of agencies tasked with implementing the statute, whether that's EPA or the Army Corps of Engineers. So this is Solid Waste Agency of Northern Cook County versus Army Corps. This is a 2001 opinion where we start to see the influence of textualism. I want you to know that I spent a lot of time looking for this slide. This actually is the water body in Solid Waste Agency of Northern Cook County. I had to get it out of municipal archives. You can see that despite its origin as a sand and gravel excavation site, it has become, by the time of the decision, a fairly sizable water body that is now pretty integrated with the neighboring wooded area. And as you know, the agency took the position that this is important habitat for migratory birds. So the majority rejected this. Justice Rehnquist, for 5 justices, said, look, this is an abandoned sand and gravel pit that the municipalities in the case want to fill with their garbage. But we need some meaning for the word navigable in the statute. And at the bottom of the slide, this is a quote from the opinion. Justice Rehnquist said, look, this is a far cry from the term navigable waters. Now, certainly, you can see from the picture, you can put a boat in this water body, right? It's more navigable in the boating sense than the marshes that the court found appropriate to include in Riverside, Bayview, but the court rejected it as just too distant from, some kind of core meaning of navigable, and, thus began a pattern of deploying canons to reinforce the court's textual approach. So the court references the avoidance canon, but the one I particularly want to mention is the federalism canon. One of the interpretive moves in this case is the court says, look, we don't want to entrench upon state prerogatives over land and water use. The federalism canon had not been devised by the courts until the 1970s and 1980s. It was devised in connection with state criminal jurisdiction. This was the first case in which the court said, we're going to expand this canon to put a thumb on the scale in favor of state autonomy over land use planning. So it's a newly devised textual canon that gets used in the Swank case to bolster the court's textual approach. But it's really Rapinos versus United States in 2006 where we see assentive textualist methods in this area. Professor Adler alluded to the Sackett case being back on the Supreme Court's docket. I think it's very likely we'll see some of the moves in particular in the Scalia plurality in the Rapinos case, return in the Sackett case. So I'm going to focus on the Scalia plurality since that's where I see the most traction being gained by use of textualism. So this case involves lots and lots of acres of wetlands, again in Michigan, with a surface connection to tributaries, to navigable waters. The slide on the upper left is an overhead view of the wetlands and in proximity to the tributaries. So you can see that in the red circle, it's a fairly large area and it's proximate to tributaries that drain to the Pine and Saginaw rivers in Michigan. The right-hand side is the drain that Rapinos built to drain all those wetlands. So that's actually what was done to eliminate the water in those areas. The picture on the lower part of it is the berm in the related case, Carabel in the Rapinos case. So the question here is this covered under the Clean Water Act? And here we see classic textual moves. Justice Scalia's focus is the term "the waters" in the statute. So he says, well, that's not just water in general, it's the waters. That has a connotation of permanent standing, flowing bodies of water. And a classic textualist tool is to invoke the dictionary. But the dictionary picks is the 1954 Webster's Dictionary. This doesn't sound like a big deal, but of course that predates the Act by decades. And in fact, it's an old edition. Webster's has come out with a new edition. The third edition has come out in 1961, more proximate to the Act. It's not the one that the justices choose to use. So this dictionary is really about conforming to Scalia's intuition of the term's meaning. The dictionary mentions streams, oceans, rivers, lakes, and bodies of water, and so forth. And so he says the inference we draw is it doesn't apply to intermittent flows, ephemeral flows, what he calls wet meadows. They just seem too much like land, just as Scalia says. Okay. Again, this is an example of a term having a core meaning, but also fuzzy meanings at the boundaries. And of course, it's hard to draw a boundary between, if you will, the core of a water body and its edges. Scalia's textual approach allows him to focus just on the core. Okay, so this is sort of a, kind of a greatest hits of waters of the United States cases. What can we learn from this? So, application of textualism in the context of the Clean Water Act affirms several critiques of textualism that I and others have talked about elsewhere. So one is the choice of the question you're going to answer. Are you going to look at navigable waters, or are you going to look at waters of the United States? The choice to use your own ideas about what one would naturally think a phrase would mean. You wouldn't say, according to Justice Scalia, that the waters includes waters that flow only sometimes. Or a distant wetland. Picking dictionaries without explanation. Why pick a 1954 dictionary for a 1972 statute, especially when there's another edition out there. And the development of new interpretive methods. So the use of an expanded federalism canon in the Swank case is one example of this. At a broader level, in 1972, if you look at the Supreme Court decisions at the time Congress enacted the Clean Water Act, intentionalism was the dominant strain in the courts, with a heavy reliance on legislative history. There was barely a hint of dictionaries or canons in use in 1972. It's fair to say Congress could not have anticipated these developments or drafted around them. Okay. So these are probably familiar critiques of textualism to some of you. What I want to add here is that textualism has a great potential to distort the public process, and in particular to undercut public interest legislation like the Clean Water Act. So textualism emphasizes judicial intuition about word meaning and old dictionaries over something that we know about these statutes. Justice Breyer has pointed out, and Justice Scalia acknowledged this as well at times. Congress's choice to legislate broadly, to use a phrase like waters of the United States, rather than listing oceans, rivers, marshes, and the like, communicates an expectation that the statute would last and would be applied over time in a flexible way to respond to modern issues and understandings that Congress knew it could not envision. So one of the things that's clearly driving the waters of the United States cases is a worry about checking agency power. And I worry that is one thing that we will see in the Sackett case, and perhaps people will raise this over the course of the day. But the impact on Congress is also a significant one. To see this, we just really need to recognize that the statutes that empower agencies to respond are regulatory statutes. If they work, regulated entities have to bear the full cost of their activities rather than externalizing the costs to the environment, to water resources, and to society as a whole. So wetlands cases are about regulating builders and industry who want to fill those wetlands. The insights of the public choice theory of legislation tell us how difficult it already is to enact public interest statutes. Because in these statutes, benefits are diffusely spread among lots of people, across society as a whole, even wildlife, and costs are concentrated. Concentrated, well-funded interests are already overrepresented in the legislative process. That's well documented. They're also overrepresented in the agency process, as data on rulemaking confirms. So it's very easy to halt legislation because of the large number of procedural hurdles. We know a well-funded, well-organized interest group is usually well able to slow down legislation that might target costs upon it. But this kind of textualism, which responds narrowly and without regard for purpose to broad statutory language, effectively also rewards regulated entities. So when wetlands are held not to be covered, those who want to construct buildings or factories can benefit. If you will, they get a few extra exceptions, a few extra deals in the language without having to go through the deliberative process of legislation. So we're going to protect the nation's water resources, if you will, except for those that home builders might want to use. This is hard for Congress to correct because it means organizing specifically in a way that will impose burdens on a well-organized, well-funded set of interest groups. And overall, it's a lot easier for Congress to correct a statutory overreach, if you will, if an agency goes too far and is too protective of society, or a court goes too far and takes too expansive a view of a statute. It's a lot easier for Congress to correct that and create an exception to broad operative language. It's a lot more difficult for Congress to deliberate to correct a court decision that creates an exception that narrows a statute's coverage and that benefits regulated entities. In short, this textualism in the name of checking agency power also undercuts legislative deliberation and reinforces distortions of the legislative process. So where might this take us? As we continue our debates on the right way to interpret statutes, the right way to interpret the Clean Water Act in particular, and with Sackett round 2 looming on the horizon, we need to take account of the burdens that textualist imposes on the legislative process. So rather than being faithful to Congress, it undercuts the deliberative process in the ways that I've been talking about. The use of legislative history statements, which was the problem that textualism responded to, I think was rightly criticized at the time. The questions that we should be asking now are whether the choices that textualism opens up are any more constraining on judges or any more faithful to Congress than a kind of more nuanced approach to purpose or intent to resolve ambiguities in statutes or kind of fuzzy boundaries. So, as we celebrate the Clean Water Act's 50th anniversary, statutory interpretation ought to support and not distort, a public regarding process such as the one that led to the Clean Water Act. I think that should mean less of this sort of textualism. All right, I look forward to the comments of other panelists and to the discussion. Thank you.
Good morning. And when my slides, while my slides are coming up, let me add my thanks to my brother, Professor Adler. Actually, he's not my brother, but my real brother is Jonathan Adler as well. So I kind of want to here. So it really is remarkable to me that a half century into implementation of the Clean Water Act, we still don't know what one of its most foundational terms means. Right? That's pretty remarkable in terms of what Professor Mendelson has talked about. And I want to thank her as well because we didn't coordinate at all, but her talk actually flows perfectly into mine. So here's my basic thesis. A couple of years ago, a student co-author and I wrote an article in the context of the County of Maui case about whether or not a discharge through groundwater into a navigable water is jurisdictional water, in which we argued that the courts have atomized the Clean Water Act. That is to say, they construe the act by reference to individual terms in isolation from the whole text and structure of the statute and all of the statutory terms. So the WOTUS debate, the Waters of the United States, debate, actually, I hate that acronym, I'll try not to use it again, has focused narrowly on the meaning of two terms, navigable waters and waters of the United States. I'll try to demonstrate how that's been done in isolation from other key statutory terms and provisions. Second, there are really multiple lines of cases on overlapping issues. So what is a water of the United States? What is an addition of a pollutant to waters of the United States? And that includes the issue of whether or not a transfer of pollutants from one water body to another is a pollutant. And I'm trying to read my slides up there. Oh, and can the Maui issue, can an addition occur through another medium rather than directly to a water body? So any construction of these terms, navigable waters, waters of the United States, has to answer all of those questions in a consistent way. And that's not something that the courts or actually the agencies have done as well. Now, in 15 minutes, I only have time for the first part of that analysis, so I'll do the first part. And you can read the second part in the written analysis of setting up the sequel here. So Professor Mendelson did a great job of talking about this, so I'm just going to summarize the existing interpretive approaches that the Supreme Court has taken. Justice White in Riverside said, we need to defer to agency scientific expertise on complex scientific issues of where the land ends and the water body begins. Chief Justice Rehnquist in Swank said we need to pay better attention to the statutory text and also this principle of constitutional avoidance, not getting too close to a constitutional line, which, as I'll talk about later, I think is a somewhat spurious argument in the context of regulating water. Justice Scalia in Rapanos said, just read the dictionary. Justice Kennedy, in his, what is to most courts the controlling opinion, came up with a judicially derived scientific text, which is something that I think is perverse for courts to do, and I'll critique that later. My proposal after my analysis kind of surprised me, which is to actually blend the Rehnquist and the White approaches, which is to say we do need to pay attention to statutory texts. Of course, we have to do that, but we also need to defer to agency expertise where it's appropriate. My caveat is that there are anomalies in the Clean Water Act that are really hard to reconcile. And the reality is that the statute was written over a number of amendments over a number of years by different members of Congress and different congressional staff. And there are flaws. I mean, there are clearly flaws that are hard to reconcile. So we need to do the best we can with the statute, but recognize that. So this is the Orwellian reality of the Clean Water Act. These are most of the terms that Congress has used to define various water bodies. And there are a lot of them. So we need to try to find a way to reconcile them. Now, not all of them are definitional. right? And I'll talk about that in a minute. And many of them are there for particular statutory purposes. So, for example, the term estuary is there for purposes of the National Estuary Program. But I divided it, I tried to categorize it. The nation's waters is the overriding term. I'll talk about why in just a minute. I divided these into water, waters, and water bodies. So water includes freshwater and surface water and groundwater and so forth. Water bodies lists all sorts of different types of water bodies for different purposes in the statute. And then the term waters, you can divide into navigable waters, waters of the United States. Interestingly, navigable waters of the United States, which is a seemingly circular analysis, which I think we can actually recognize in legal and historical context. So I couldn't do this for all of them, but I tried to sort out what I think are the core jurisdictional terms. And those are the nation's waters, waters, groundwater, which has, I think, surprising importance, and then waters, navigable waters, waters of the United States, and navigable waters of the United States. And what I did was, with the help of one of our law librarians, Suzanne Reyes, did a statutory word search. It was somewhat laborious and identified every place in the statute where each of these core terms are used and in what context. And it came up with, I thought, some surprising insights. So question number one is, what are the nation's waters? Notably, this core term, it defines the statutory objective, is used a single time in the entire statute. But it's used in the opening provision of the statute. So you can interpret this language one of two ways. You can interpret the nation in the nation's waters narrowly to mean the federal government, the national government. So perhaps waters that are subject to the navigational servitude or subject to Commerce Clause control. I think that's an implausibly narrow interpretation of that, because then there would be no way to distinguish between the nation's waters and waters of the United States, and when Congress uses different terms, another canon of statutory construction is that we have to assume different meanings. I think a more reasonable interpretation is that the nation means the entire country, which is the geographic boundaries of the United States, and means all waters within the geographic reaches of the United States, augmented by the fact that it's a term used only once at the beginning of the statute. Okay, so then what are waters? And we find this interesting distinction in the statute between water and waters. And one that has perplexed me for many years is that opening objective provision says restore and maintain the chemical, physical, and biological integrity of the nation's waters, which makes sense if you view waters as water bodies or aquatic ecosystems. The definition of pollution is the man-made and man-induced alteration of the chemical, physical, and biological integrity of water. That may be a drafting mistake. I don't know if that was an intentional distinction, but if you think about it, it makes no sense whatsoever to talk about the biotic integrity of water, right? It makes sense in the context of the biotic integrity of aquatic ecosystems. So if we look more closely, and I don't have the time to talk about all these in detail, so I'll categorize them. If you look more closely at the places in the statute where Congress used water and the places in which they use waters, it begins to make some sense and to explain some of these difficult jurisdictional issues. So water quality-based effluent limitations in Section 302A apply to a specific portion of the navigable waters. All the provisions in the statute that require states and EPA and the default of states to identify impaired waters, so 303D, 304L, 319, talk about water bodies as components of aquatic ecosystems. So one implication is that the unitary waters theory that EPA and the states have proffered, I think doesn't make any sense structurally in the context of the Act. Water clearly can't mean all water. It can't mean water in this cup. Congress didn't intend to regulate that in the Clean Water Act, but if you look at the provisions in which Congress talks about protecting recreation in and on the water and enhancing the quality of water, the logical distinction is that that means water within water bodies, that is, water within aquatic ecosystems. So, what about this curious distinction between waters of the United States and navigable waters of the United States? And the circularity is that Congress first defines navigable waters as meaning waters of the United States, and then it talks about the navigable waters of the United States. And the only way to really make sense of that is to understand that before the Clean Water Act was written, there were actually 4 separate definitions of navigability for purposes of constitutional law. And the 2 key ones are the navigable in fact test for historically navigable waters under the Daniel Ball test, and the broader test for navigability that the Supreme Court articulated in U.S. versus Appalachian Electric Power, saying any water bodies, the use and effect on which might affect a navigable water or jurisdiction. So the places in the Clean Water Act where Congress used the term the navigable waters of the United States are typically those waters over which the Corps of Engineers regulated or dredged for purposes of traditional navigation. So it makes sense in that context. There's this very curious provision that came up, 33 U.S.C. 1293A, which is not actually part of the 1972 Clean Water Act, but it's codified along with it. And it was adopted 2 years earlier by Congress, and actually a year before Congress actually wrote the Clean Water Act in 1971 when the committee hearings and markup was going on. And it refers to a dredge spoil program for all navigable waters and other waters of the United States, which clearly means that Congress, a year before it wrote the Clean Water Act, understood this distinction between traditional navigable in fact water bodies and the broader notion of waters of the United States, supports the notion that waters of the United States is in fact broader, and it reflects that existing case law. So what about groundwater? How is groundwater relevant? So I think the debate about groundwater has been mischaracterized very often as whether or not the Clean Water Act applies to groundwater. Well, of course it applies to groundwater because Congress invoked the term groundwater in many places in the statute. The more precise legal question is for what purposes. So it's possible for water bodies to be covered by the Act for some regulatory purposes, but not others. Section 208 is the original planning and non-point source provision. It's somewhat defunct as a matter of implementation, but it's alive and well in the statute. Congress did not repeal it when it wrote Section 319. Section 304A, which governs EPA promulgation of water quality criteria guidance for the states, talks about groundwater. So EPA's water quality criteria are supposed to govern groundwater as well as surface water. And this is a somewhat complicated analysis. I don't have time for it, but if you parse the language of 303C, the provision governing state water quality standards or EPA authority to write water quality standards if the states don't do so properly, it appears that states have full authority to write groundwater quality standards under the Clean Water Act, which makes sense given that the water quality guidance address groundwater, but that EPA, the federal government, does not have that authority. So groundwater is part of the nation's waters, but not necessarily part of waters of the United States for purposes of some subsidiary goals and implementing mechanisms. Okay, so this is the set of provisions that I think are almost most telling. It's provisions where Congress combined multiple terms of scope in the same provision. So Section 102 refers to comprehensive programs for preventing, reducing, or eliminating the pollution of navigable waters and groundwaters. And then there are other provisions that do the same thing, navigable waters and groundwater in the contiguous zone and oceans and so forth. It makes no sense for Congress to have called for comprehensive programs of water pollution control for groundwater, but only a subset of navigable waters, right? Why would it have done that? It clearly envisioned the much broader sense of all surface waters and all groundwaters, but then perhaps parsed which provisions of the statute apply where. So here's a summary of my synthesis. My students, especially in civil procedure, will tell you that I love Venn diagrams, so I'm going to use Venn diagrams. This is a somewhat simplified view of this because, number one, my PowerPoint Venn diagram skills are lacking to get much further, but in part due to time. So the nation's waters is the umbrella term. It's the broadest term of scope in the statute. Everything else should fit within it. The term navigable waters, as defined by Congress somewhat incongruously in the Clean Water Act as waters of the United States, Congress intended the Commerce Clause, meaning the U.S. v. Appalachian Electric Power, meaning of navigable waters, and not the narrower navigable, in fact, test from the Daniel Ball, because Congress used a separate term, a narrower term, the navigable waters of the United States. And again, if you actually look at the provisions in which Congress tended to use that, which I'll do in the written version of the article, are water bodies that are appropriate for the navigable, in fact, test. So now the trick is to fit all those other types of water bodies into that. I don't have time to do all of it. I'll do it for groundwater because I think groundwater is most telling. So option number one is that groundwater is part of the waters in the United States for purposes of Commerce Clause, are fully subject to Clean Water Act regulation. This is the argument that Mike Blum makes in an article that he and a student published a couple of years ago. I would like it to be that way from an environmental perspective, protection perspective, but I don't think that's right because I think that would leave little, if anything, in that blue zone of what's within the nation's waters, but not the navigable waters or waters in the United States. There are all of the exceptions in EPA's regulations. It was clarified in the Obama Clean Water Act, Waters of the United States regulation. So there are some waters that might fit there, but I don't think this is a particularly correct interpretation. The other extreme is that groundwater is part of the nation's waters, but not at all part of the navigable waters of the United States, but with the caveat that we get from the County of Maui case, which is that if there is a discharge of pollutants through the groundwater into an otherwise navigable water, that is subject to regulation under the permitting provisions in Section 402 and 404. I think that's a plausible interpretation. I actually think that this is probably the most accurate interpretation if you look at the Act in context and its purposes, and that is to say that groundwaters are part of the waters of the United States where they are clearly hydrologically connected to an adjacent surface water. And I know that's a fine line. It's a hydrogeological fine line because all groundwater, unless it's a completely segmented aquifer, is eventually going to be connected to waters of the United States. It's something we deal with in water law all the time, as well as in Clean Water Act law. But why is adjacent groundwater, which is immediately contiguous to a surface water, any different from a non-navigable tributary of a navigable water for purposes of what the waters of the United States are? Right, so I think some groundwater, I think this is a reasonable interpretation, fits within the waters of the United States. Others remain subject to that County of Maui test. And I could do this, of course, for all the different categories of waters that we've talked about, and I'll endeavor to do that in the broader analysis. So with that, here's the implications for, and my critique of the different Supreme Court approaches that Professor Mendelson talked about. And I kind of surprised myself here in who I agreed with and didn't agree with for what purposes. But we need to come to resolution here. right? So we need to get away from the complete extremes and to try to come up with a resolution that makes sense in the context of the statute and works for everyone. So the White-Stevens deference to the agency scientific expertise approach. Given this huge proliferation of undefined terms, there's no way around deference to the expert scientific agencies to whom Congress delegated the authority to interpret and implement the statute. But we can't avoid the statutory text and context altogether. I don't read Justice White or Justice Stevens as having argued for that. Justice Scalia's just read the dictionary approach, I agree. You can't use the 1954 Webster's Dictionary definition of waters, but in a more nuanced way. In isolation from all those multiple nested uses of water and waters and water bodies in the statute, relying on a definition of a single term in the context of all those terms doesn't make sense. But my further critique is that by using that term in the way Justice Scalia did, he took an entirely hydrologic approach. Are these continuously flowing surface waters? Do they contribute to the flow of navigable waters? Thereby ignoring important parts of statutory text, which are the parts of statutory text that talk about ecological protection and referring to waters as water bodies as in aquatic ecosystems. So if you're going to be a textualist, fine, but pay attention to all the words of the statute and not just to some of them. The Rehnquist statutory text and constitutional avoidance on text. How am I doing on time, by the way? Oh, I'm already over, I'm sorry. Okay, so I'll finish really quickly here, sorry. Number one, he made a move here which I think is not talked about enough. It's one thing to say that Congress left the word navigable in the statute, but then he alludes to the navigable in fact test and not to the Commerce Clause test in U.S. versus Appalachian Electric Power. So it is possible to give meaning to the word navigable, but to get a much broader interpretation of the statute than Chief Justice Rehnquist did. Justice Kennedy's significant nexus test, it is correct to link it to the overriding objective of the statute, chemical, physical, and biological integrity, but Congress used that word to apply to the nation's waters, not just to navigable waters. He also uses the narrower Daniel Ball test, which I think is incorrect. And the concept of significant is nowhere in the statute, right? It was made up first by Chief Justice Rehnquist and then by Justice Kennedy, seized upon it. So if we want to be a textualist, we shouldn't be adding words to the statute. If you talk to EPA scientists, and I talked to Lori Alexander, who's one of the EPA scientists, who did the synthesis report before the Obama rule, she said that word drove the scientists crazy because it's not a scientific term, right? Scientists characterize the nature and the magnitude of connectivity between water bodies, but significant is a value judgment term. It's not one that scientists use. So my closing comment is that judges should not make up the science. Lawyers should not make up the science. We should defer to the scientists. And that's a broader issue that I plan to write about because there are other parts of environmental law in which we've done this. So thank you.
Those are great comments. I'm glad I didn't invest a lot in PowerPoint because basically 2/3 of my paper was just presented, and that's terrific. So what I'll do is I'll sort of maybe jump a little bit to some of my distillation of key points and also what can be done in light of these problems that Professors Adler and Mendelsohn mentioned. And I'll start off by saying one thing that I've looked for, which is just a curious aspect, to try to understand any statute. Obviously, reading the statute is essential, right? Everyone agrees with that. And for those who are not deeply into the world of statutory interpretation, some interesting literature that you should all be aware of is in the last few years, people have gone back to track what statutes look like in the U.S. Code, but then looked at the actually enacted statutes that is the public law versions, and found often dramatic differences. That is, Congress, when it passes laws, structures them, numbers them, drafts them differently, sometimes even with different language. And then there's a whole professional staff in Congress that takes those enacted laws and decides what to put in the U.S. Code, sometimes burying whole provisions. So, for example, by the way, I should say the payoff of the Clean Water Act is almost nothing, but for other statutes, it's really quite significant. But what's interesting here is that very often it turns out for formalists in textualists, a key underpinning of textualism is you have to think about what is drafted, is presented, signed by the president, okay? And so therefore, statutes have primacy, legislative history is secondary and illegitimate. Well, it turns out very often what people thought was legislative history has been put in the statute, in findings provisions, or in the package presented. So there's an array. So for all of you who might get caught in high stakes battles, you need to look at the public law and also look to see if there was anything else in the package presented, because there are instances they found where even legislative history reports are part of what was shipped to the White House. And so you actually have the argument that the legislative history is part of the enacted passage. Okay, all that said, apart from some renumbering and shifting around, the 72 Clean Water Act was enough of a framework establishing statute that it's not dramatically different in the Clean Water Act in the U.S. Code from what it was in 72 when presented. But there are some numbered provisions, and so before I tell you about my paper, reading through it, there are a few things that struck me. One is, if you read it as enacted, cover to cover, first, even more than my articles, sleep it's a terrific way to get a good night's sleep. But it's assuming you can get past that problem. Reading through it, it's so clear, it's so much clearer, I would say, when you read it in the sequence written and drafted as Congress put it together. It's just anti-pollution is everywhere, as are the integrity goals, repeated references to aquatic, fisheries, breeding, and wildlife, which I have to look up and see what wildlife meant at the time, because that is just all over the statute and is less aquatic in its descriptive kind of innate nature. But the idea that this statute is really focused at all on navigability in the sense, just discussed in the sense of navigable, in fact, with shipping being a goal, it's really just very clear as you read it end to end. It's anti-pollution legislation, and it just says it from beginning to end, and very focused on effects, okay? And then the other thing that jumps out, consistent with the points just made, is the other thing that leaps out is the statute is very clearly a strong delegation of policymaking authority to EPA and then slightly lesser to the Army Corps. That is, the provisions, including grant provisions, research provisions, funding provisions, educational provisions, operative provisions, effects provisions, pollution technology, it is laden with clearly maybe more than any statute I'm aware of, express delegations to expert agencies to make sense of the statute. So when you pull back and there's arguments about meaning, there's also these fundamental questions about who should be the decider, who should have primacy, and what's clear when you just look at the 72 Act is it is laden with this focus, anti-pollution, science effects, and strong repeated delegations right across the board to EPA primarily and to a lesser extent the Army Corps. And so then to go forward, so what is my paper about, or what will it be about? So I've become really interested in what I call the anti-regulatory arsenal. That is this array of moves that now are assembled collectively in mutually reinforcing ways to attack regulation. And it has been central to the revamping of waters of the U.S. battles, but also some of the key waters cases, especially the Swank case, which I will not review in depth, but also to a lesser extent Rapanos. They also have become foundational to this anti-regulatory arsenal. And so what I'll do with most of my remaining time is kind of talk about the roots of this anti-regulatory arsenal, and especially the mutually reinforcing effects. I really think that the previous two talks said a lot of what I'm going to say, so I'm going to try to kind of just jump to the distillation. So first, in the area of waters, if you haven't gone back to read the Riverside Bayview Homes case, which is the Justice White opinion for a unanimous court in 85, 86, I can't remember which year it is. But it reflects a wholly different frame. That is, if you read that case, it's not just that it comes out allowing the Army Corps and the EPA regulations to apply to adjacent wetlands, to navigable waters, but the entire framework is one that reflects a sort of partner mentality that the court should be trying to figure out how to make sense of the statute in partnership with the expert agency's judgments about protections. It refers to, in that case, there were constitutional arguments made and constitutional avoidance arguments made, as they have been made recently, but with focus on takings. And the court basically just swats them away and calls them spurious and just says, these don't make any sense. And then it goes forward and says, okay, so here are the questions, and it points out correctly, as scientists will tell you in the waters area, that waters aren't a continuum. There's hydrological cycles, there's expert judgments. You have to look at the nature of waters and decide where in the continuum to say land and water begin. And it goes through all this, and it's very sympathetic to what Congress was trying to do. It's thinking about the effects. It's deferential to the agencies. It acknowledges expert judgment, not of the court, but of the agencies, and that Congress chose them. All of that shifts. And so I think the most problematic case, not just for waters, but included in battles over climate, is the Swank case that you all alluded to. And I won't. The Swank case is the isolated waters that Nita gave us the excellent picture of, and much of that case's power hinges on this one long, illogical, and seemingly typo-ridden paragraph written by Justice Rehnquist. I say typo-ridden because it has several logic leaps that it's like, did I just miss something? And if you look at it in case books, at least when I first saw others' edited versions, I assumed that they had cut language out because there's missing logic. But no, it's just the way it's written. But importantly to that language is, here you have, just to be clear, you have what had been commercial gravel pits. Okay, just to be clear, this was a commercial operation created the gravel pits. Okay, then you had their extensive use by migratory birds, which is of vast significance, plus their statutory protections, and previous cases had said migratory birds and related activity are kind of laden with commerce, so that was part of the understanding. And the proposal was to create a new waste handling operation, also commercial. Okay, it's hard to figure out how there was any issue whatsoever about there being a problem with a commerce link to these waters. But what does the court say? It says, respondents argue that the migratory bird rule falls within Congress's power. They note, okay, that these activities supposedly substantially affect interstate commerce and that there's a natural interest in migratory birds. Arguments raise significant constitutional questions. For example, we, the court, would have to evaluate the precise object or activity that in the aggregate substantially affects interstate commerce. Okay, now we're waiting. So what do you, the Supreme Court, say? This is not clear. Okay, for all that they say this, they now argue, post litem modem, they focus that this is a municipal landfill, which is plainly commercial. Okay, in your resolution? But this is a far cry indeed from the Navigable. That's it. Okay, so just to be clear, that language, thank you, has created a big problem in West Virginia and climate, because if you look at it, it's not, there isn't a clear constitutional problem. So it's really just a waving of the hand at a possibility of a constitutional problem, and then it takes a turn and creates what Dean Manning at Harvard has called a clarity tax. expecting a clearer statement of intent to reach the waters and says not clear enough. It ignores the fact that it's a defined term. It doesn't go to the definition, it goes to the term and gives way to navigable. You put that package together, it is a powerful move in any statute, because any broad statute will have first, a national statute always overlaps with state law, always, okay? All national statutes have major effects. That's undoubtedly the case, okay? And then if you add especially pollution laws, they always will intersect and overlap with land use. That is, it's not just waters law. Land use law always overlaps with environmental laws. And so you work your way through it. If you can just wave your hand at a constitutional concern, demand greater clarity, and if you don't find it, cut back on federal power, it is extremely judge empowering. Okay? So what's been said here, I think importantly, is this shift analytically from Riverside, Bayview, Homes to Swank, and then Rapanos, and now Sackett, is a move from Congress choosing to hand the power to expert agencies to choose, to a new framework which is extremely judge empowering, where judges are coming up with the key lines. And the Sackett, this new case, the Supreme Court case that was mentioned earlier, Jonathan alluded to, the Sackett case, it just says kind of what should the test be for how a wetland is a water, which either reflects a mistake by the court, since the issue of waters is far more than just wetland, or is the belief that the court should be ready to step up and define it itself. And so it's quite consistent with what Swank and the others have mentioned Rapanos does, which is judges grabbing power. So the question then is, what do you do? So what can be done? Okay, so one possibility is Congress can draft more clearly. During times of partisan gridlock, that doesn't happen much and probably will not happen. But let me just distill the arsenal and just give you a few suggestions, both as lawyers, policymakers, and especially before agencies. So what do we have? So one aspect is anti-federal skewing in a number of ways, you see here. Also, not mentioned by any of this till now, when you look at the language, these more recent cases are filled with language of accusations of agency overreach. Okay? So there is a concern that agencies are abusing their powers, and that's very evident, especially if you look at Justice Scalia's Rapanos opinion, where he thinks he establishes by citing a few litigated cases over waters disputes, and then says that establishes overreach. Now, without going into courses in logic that surely are taught at Case Western, you can't prove that something is unsound if you look at cases where people are alleging things are unsound. Okay, that is, the denominator is wrong for that kind of proof. Very importantly, these cases downplay any actual evidence or any actual respect for actual science. Okay, that is, the Clean Water Act is filled with language about integrity, aquatic effects, wildlife, and the rest. But you look at Rapanos, you look at Rapanos, you look at Swank, and what you find is there's virtually no attention given to what programmatically the Clean Water Act achieves with its overall effort. So it's a kind of what you have. It's not just the atomization of language. It is a focus on particular alleged instances of abuse and no attention to broader programmatic benefits. And that's really quite striking. I agree completely with Professor Mendelsohn about the textualism, and I won't go into that. That was going to be most of my paper. But but this idea, I think one way to think about it is the current mode in these cases, I call it microtextualism, is this tendency to really look at a word and decontextualize it. And for those looking for the best scholarship attacking this, Vic Nurse, spelled Norse, a colleague of mine, Kevin Tobia at Georgetown have also written about this. Bill Eskridge has a new piece talking about this need to contextualize language to make sense of it, and they're really quite powerful counters to this acontextual mode of reading. So I'm down to 0 minutes, so I'll just say, so what do you do? So a couple things which have been said, I'll just emphasize. So I think the most important thing is to take statute seriously. I think that especially a statute like the Clean Water Act, if you really emphasize its many, many provisions in their mutually reinforcing goals, but also their intertwined functioning. If you look at some of the Affordable Care Act decisions, the Supreme Court does have a majority that sometimes will look at how statutes work and give weight to that aggregate integrated functioning of statutes. And so if we look at the Clean Water Act through that lens, it's a strong counter to this acontextualizing, microtextualist move. I think similarly, something that Dave Owen and others have written about, and I try to, many others here actually, all of us, and that is partly when it comes to federalism, similarly, federalism concerns should not be decontextualized. Statutes make particular choices, and the Constitution does not solely protect the states. It is, also as Professor Manning has written about, it both creates a powerful federal government and creates some areas of turf for the states. And if Congress chooses allocations within its power, the court should not re-skew them in some preferred direction. And then the last thing, which maybe in the Q&A, I hope we'll get into this. I think that there's a need to very directly take on the Supreme Court, however you can do it politely, which is in the following way. This is a very powerful and hungry court that is eager to remake things in its preferred modes and preferred direction. But judges don't know much, okay? That's not to say judges aren't smart, but judges just don't know, okay? There is no one on the Supreme Court who is an expert in hydrology and connectivity and waters. None of them are expert in technologies. None of them know really on the ground what happens around the country between regulated entities and state and local and federal regulators. You know, their knowledge is at most derivative before what's presented or comes to them through what agencies do. And so I think what really is important is people emphasize as much as you can what the actual evidence is, what the actual data is, counter tales of overreach and abuse with actual things like cost-benefit analyses that often really try to break down effects and try to show what the actual data shows and what the science shows. For anyone who wants to see a brief that does this effectively, not in the Clean Water Act area, in the West Virginia case, the big climate case, the power companies surprised many people by arguing in favor of EPA's power to regulate greenhouse gases from power plants. But the reason was they were really afraid of the court embracing a view that would fundamentally disrupt the complex energy markets. And so their brief, and their oral argument even more, was saying, don't mess things up. You don't know. And that was the heart of their argument. You, justices, don't know what your language might do to a complex area of markets, and, federal, state, local market, competitive markets, different energies, pollution streams, technology, all the rest. And they said, we're juggling a lot. Don't mess it up. And so I think that's, to the extent there's a counter, it would be before agencies, and then as well as before the courts, really emphasizing what actual science and data show as an effective counter to what may be anecdotal and frequently erroneous claims. So I have more, but I'll stop there, in part because just try to make it so we all say something different. So thank you.
Well, get your questions ready, but I want to actually start by saying there was a lot going on here. It seems like a lot of agreement, but I think that there's a conversation going on between the three of you, and I invite you to reply and respond to each other.
Okay. Well, this has been just a pleasure to participate on this panel with my distinguished co-panelists. I'm very intrigued by the different approaches that each of you take to statutes. Professor Busby, I think, would say we should look at the Clean Water Act and its overall thrust. It's an anti-pollution statute. We should look at how all the provisions function together and draw some inferences from that. And I think Professor Adler, I actually thought the slide on Water, waters, and water bodies was just brilliant because it shows the kinds of terms that get used in a statute when you pay extraordinarily close attention to the language. But one question I have for my co-panelists is whether one implication of a presentation like that might be, rather than saying that we have to be extra careful in how we read these provisions, we could draw a different inference about how statutes are drafted that might point us in a different direction for interpretation. The different direction might be, these word choices are not actually all that carefully thought out. I actually, for years, Professor Carl Levin used to come and guest lecture in my classes. He's a senator from Michigan for many years and passed away in the last couple of years. And my students would ask him, so do you read the bills when you vote on them? And he would say, well, my colleagues consider me to be much more in the weeds than they are. Yes, I do sometimes read bills, but I could not possibly read them all and still get my work done. It would be like reading every piece of mail that arrived in my mailbox. So one question I have for my co-panelists is whether the inference ought to be, look, the wide variation in word choices just tells us that it's not that carefully thought out, and interpreters instead should be seeking to kind of smooth the operation of the statute rather than reading these distinctions as meaningful.
So that's a really good point, and one that I struggled with because, as I mentioned, I didn't have time to talk about the anomalies in the statute. But I'll just give you one example. If you read Section 304L, which is the toxic hotspots provision of the statute, there's this interspersing of navigable waters and other jurisdictional terms, and it's really hard to make any sense of that provision. And I think part of what's going on is that when Congress wrote the statute in 1972, it was pretty well integrated, as Bill talked about, but then you had congressional staff and members of Congress in 1977 and 1987, the major amendments, and then there were minor amendments in between, and since throwing in terms without thinking very carefully about them. So I think that's a problem, but the reason I struggle with it is that we do have canons of statutory construction in which we have to make the assumption that if different words are used in a statute, we need to give them different meaning, and that's why I said that we need to kind of do the best we can with that. But it's also why I think we need to pay attention to the text of the statute carefully, but in the context of the overall statutory purposes and structure, more importantly. I think we need to avoid, frankly, relying on too much legislative history given this debate. And the argument that I made in the Maui article I wrote was that you don't need to rely on legislative history to get to this result. But if you look at the legislative history, it supports it, it confirms it. So it's not an approach that relies primarily on legislative history, but one to confirm what the logic of the text and the statute means. So that's kind of my response to that.
So I agree with all of that again. I guess I'd say, I think your question goes a slightly different direction, which is thinking about both courts and agencies. So you do have right now, at least half of the federal judges and a majority of the Supreme Court shun legislative history. Okay, they also are wary of any arguments that are a purpose of argument, unless, and this is the important thing, unless anchored in text. Okay, and so, and the Clean Water Act is an example of a statute that has its goals and its text and its operations do all reconfirm each other. That is, this is clear, this is not a statute that has some vague goal. This is a statute that chooses exactly what the means are, different programs and ways to achieve them. And so my sense here is that I would probably focus, I think actually what Dean Adler, do you still like to be called Dean? Former Dean.
Bob.
But what he points out is that there are these different uses, and most of the statute, when I was reading through it, the different uses kind of make sense in context. So I'm not sure they were mistakes. On the other hand, if you link them to the particular goals, I think what you find is they aren't terribly different in their goals, as stated. That is, there are different kinds of water and waters, but they always come back to this presumption against pollution, always come back to protecting a aquatic ecosystem, reducing pollution, and you have this language. And the fact that it's expressed, I think what lawyers, to be effective before agencies and courts, need to do is to really weave these powerful statutory arguments, weaving things together in their mutually enforcing message. And I think they are quite uniform. So I'm not sure in the end operationally it's different, but I think it makes some sense.
So, questions?
Yeah, thank you so much for this elucidating. Thank you for the elucidating history on the interpretation of the Clean Water Act jurisdiction, first of all. But considering the evolution of the history, starting from a point of some deference principle being applied to seeing a more activist role of judges in Rapanos, and now we're having SCOTUS that may be indicating that agency overreach will be seriously examined and possibly expanding the scope of the major questions doctrine. I'm wondering if you can briefly touch on Chevron's treatment in this evolution and what, if any, what role should it have in this statutory mayhem?
I'll go first, so I'll be quick, which is, so first, the current majority on the Supreme Court, I'm not sure, I think they've only cited Chevron in one of their decisions, and that the majority has joined. And so Chevron itself, while not being overruled and the court hasn't gone that route, it's heavy reliance on Chevron is not the way for people to win, and so people are arguing differently. However, what I think is important is that if in the area of waters of the U.S., when you get to issues of the effects of the functions of waters, the effects of pollution in certain waters, the rationale for protecting, that's not language. That tends to be the other side of deference, which is quite consistent in the administrative law world, which is when you're looking at assertions that rely on effects, that's reasoned decision-making review and deference. And so I think that what you see people doing is shifting the analysis to saying, our judgments are reasonable in light of what the statute says, but especially our finding about effects. So they're not just saying language power, they're saying language and here's what we find on the ground. And so I think that's the way people need to argue it. That said, the underpinning of Chevron, which was an agency delegated power, that is the heart of Chevron, but that's also been the heart of cases going back to the early 20th century. And so that should be central. And I actually think, I don't know about Justice Gorsuch, who I think would like, and Thomas, they might like to have no administrative state at all. But so putting them to the side, I think the rest of them accept the idea that agencies are delegated important roles. And I think that that's also a pre-Chevron conception that lives on.
It was a really interesting and to me funny question because we had a faculty job talk this week, someone who's applying for a job at Utah who gave a talk about Chevron. And I heard it after I had completed this presentation and sent the slides in, and it dawned on me, Chevron has played a surprisingly little role in the Lotus cases, and I wonder why that is. I don't know if you have any comment on that, but you raised the question that I had on the airplane, and I was thinking, why is that? I need to go think about that more.
Was your question whether Chevron still has any application in this area?
I was curious about the past treatment and why it played such a little role, but also your views on if you have any conceptualization of how it could play. Or if should it play?
Yeah, so I agree with the comments that have already been made. In some ways, the Clean Water Act is a best case for the application of the Chevron doctrine because because the terms, although varied, are broad, right? There's not a list of oceans, rivers, streams, and the like that are to be regulated. Instead, we have these broad terms, even with slight variations. And each of them, of course, has their distinctive history. And that's a setting where we think of an expert agency as really having something to offer, both because of its scientific capabilities and because it functions within the executive branch, which can be expected to be responsive to people's policy preferences via presidential elections. That said, the environmental area generally and the regulatory state generally in recent years has been the target of great suspicion by especially the conservative members of the court. And I think Professor Busby alluded to this. I had the quote in my notes, but I was running short on time. In his Rapinos plurality, Justice Scalia says, look, the agency's acting like an enlightened despot in this case. Right? That's clearly a motivating concern. And so I think the court, not just Justices Gorsuch and Thomas, I would include Alito in that group as well now, are very concerned with making sure that they check what they perceive as a potentially overreaching regulatory state. And that means a much more aggressive application of the statutory framework that they have, much more use of textualist methods, much more use of the major question doctrine to say, well, that's all well and good that the agency was given a very broad delegation of authority, but we have to hesitate that Congress really meant this much authority. So I think we're going to see a lot less role for Chevron and a lot greater role for the court in drawing boundaries on the administrative state.
Yes. We have to defer.
This is a question for Brother Adler, but any of the panelists certainly can address it. What happens if we assume, or the court assumes, that the AEP case represents an overly broad interpretation of Congress's power under Article 1, Section 8? What does that do to, do we just shrink the analysis accordingly, or do we bring something else to the table?
Yeah, and I hope you know that coming from Utah, the term Brother Adler has a particular... I don't know if you intended that or not. So, you know, of course there are constitutional limits, but the question is where the lines are and where they're drawn. And what I think has been missing in the context of the Clean Water Act debate is that there is nothing in this room which was likely manufactured and traded in interstate commerce, which wasn't made in some way with water, right? And the Supreme Court in Sporhayes said that water is an article of interstate commerce. So we don't need to find a channel of commerce to regulate water, right? And Congress regulates pollution of groundwater in Superfund, and that's been upheld constitutionally, and in RCRA, and the Safe Drinking Water Act, and other statutes. So I think there's been this kind of shifting of the goalpost in the Clean Water Act, where to find constitutional authority, you need to find a navigable waterway and a link to a navigable waterway. That may be a question of statutory construction, but Chief Justice Rehnquist's argument was that we needed to take a different approach to statutory construction to avoid a constitutional limit, which was, I think, a phantom, right? Because the constitutional authority over water is much broader.
Else? In the middle, and then.
I guess this is for Professor Busby. You mentioned evidence, and I'm an engineer, so I'm interloping on this whole thing here, and it's fascinating. But one thing I wonder is what kind of evidence works. So we work for an agency here in Cleveland, the Northeast Ohio Regional Sewer District, and we are under a long-term control plan. Would the results of that control plan, for instance, and the interpretations that we had to make along the way that weren't argued about, they were just sort of our interpretations of things, would those constitute evidence that could be used potentially? Not just wastewater, but other types of evidence like that?
I think, frankly, any actual evidence of the effects of what efforts are achieving or predicted to achieve are one of the most powerful counters to courts stepping in where they don't know. So it might be that, it might be evidence of what's happened under permits, it might be analysis, that is involved in federal rulemakings, but people present expert reports about what should be done, what the effects would be. EPA connectivity report post Rapanos that tried to look at all the different kinds of river streams and waters and how they worked, and then use that to inform the judgment and the Obama regulation. That was an attempt to do kind of the same thing. It was an attempt to try to say, this is actual peer-reviewed science, the best science we can find, and they even did that as a notice and comment process of sorts. They said, this is our draft connectivity report. Have we missed anything? And they didn't finalize it until they confirmed that no one said, oh, you've missed something. And so any of that's a powerful counter, but it doesn't mean it will be respected. I mean, that to the extent the courts look at it just as a language game and they just fix on saying a word in isolation, and then they say it's for the courts, they may just disregard it.
We have one back.
Erin.
Yeah.
Thank you. Thank you for these wonderful presentations. So I have a question about, in the vein of managing ambiguities in statutes like the Clean Water Act. Certainly all of our problems would be solved if Congress and the agencies could just speak flawlessly and with no ambiguities. But since that's never been true in humankind, we rely on courts to help. And you've been talking about ambiguities in the meaning of central terms like waters. It's a fantastic presentation, Bob, about all the different terms. But I also wanted to ask you with regard to the waters of the United States question, there's so much ambiguity on like higher order interpretive questions like default rules and burden shifting. And if we're in the gray area, my question is going to be about what should our theory of judging be in terms of how judges should manage these questions of higher order ambiguity in terms of legal architecture and infrastructure default rules and so forth, and also how should advocates pitch their arguments. And to ground this in something concrete, I'll go to the Rapanos decision where I'm so obsessed with this point that I wrote a paper about it a few years ago, so forgive me my weeds here, but it seems like the Kennedy opinion that Bob, you critiqued for the use of significant nexus as a non-scientific word was nevertheless sort of the best effort of a layperson to try to get at what Justice Kennedy thought the agency was trying to get at in terms of how to accomplish the goals of the Clean Water Act through some delimiting means of which waterways are we going to count and which not, is in some respects the mirror image of the dissent's position, which was to say we're going to let the agency be the one that determines which of these waters accomplish the goals of the Clean Water Act. And they're mirror images in that they both had a way of opting out. Justice Kennedy said, we're going to assume no nexus unless the proponent shows it, and the dissent said, we're going to assume there's a nexus, but of course, if the opponent can show that there isn't, they can get out of it. And so it really became an exercise in burden shifting. Who had the burden of proof? And I thought that was a really interesting feature. And I thought that the waters of the Clean Water Rule that followed tried to kind of capitalize on that insight and specify that. But this may all be obsolete in the direction that we're headed, but I wondered if you could distill from this insight that it's not just about interpreting the meaning of words, but also interpreting how to handle ambiguous features at that kind of infrastructural level of legal architecture. Who has the burden? Which is the default rule? When do we trigger it? What insights could you offer us about that?
So first of all, I read that article. It was a great article and a great analysis. But I thought your article actually highlighted another perverse shift in Supreme Court jurisprudence that's along the anti-regulatory lines that Bill was talking about. And that's from shifting from an administrative law mode to a litigation mode, right? So the whole concept of who has the burden of proof, ignores the idea that when you delegate rulemaking authority to agencies, they get to interpret the statute and write a rule which is administratively efficient, right? And one of the really challenging things, I think, for EPA of this whole area of law is the notion that you have to have scientists on the ground, demonstrating what a significant nexus is on so many case-by-case, situations, and the agency does not have resources to do that, right? So when you shift from the administrative law framework to the litigation framework, you really hamstring the agency in doing its job. So I think that's a big problem.
To go completely geeky scholarly on this, there's a great article published in 2021 by Anya Bernstein, who's a professor at Buffalo, I think, where she takes on legal corpus linguistics, which I'm familiar with. And this is this new move that you try to interpret disputed statutes by looking at all of the uses of the term in kind of usually more common parlance, and she's someone who actually knows linguistics. And so the reason I mentioned her piece is her answer to that is you always have to put language in the context of how it language never works by itself. And so her whole last section kind of gives a linguist distillation of what sound reading is in the statutory area, and it ends up, and I can't do justice to it because it's both trenchant and fun read and really much more sophisticated than I am in this area, but she basically says you look at the words, you look at the immediate structure, you look at what they're trying to achieve in the language, because language always has a purpose to it, it's always doing something, and only then do you make sense of it, and if you decontextualize it, what you tend to do is to go astray. And so my sense there is, in some sense, maybe there shouldn't be as big a difference, that is, whether agency or court, if you really try to be clear about how all the words fit together to do something, it might mean an agency in some settings has less power, but I think that's probably correct. In other words, but it also will other times very much affirm power. And so, like in the Clean Water Act, I just look at it, for me, which I didn't get into, Section 404, the dredge and fill provision that's at issue in Sackett, explicitly refers to Section 403C, that says, in figuring out what's protected under 404, you use rationales comparable to ocean protection, which then has a whole litany of environmentally protective goals that are to inform those judgments. And so that's an example. So I would never say you look at 404 and waters by itself. You have to look at 404 waters in light of what Congress said provides the criteria. That's 403C.
Do I have a minute to you asked a great question with a lot of subparts, and I think my colleagues here on the panel have responded to a couple of parts of that. I want to just chime in on one last issue. You said, what should be the theory of judging and how should advocates approach these cases? And I think one of the things I'm taking away from this discussion and my own thinking about it is that courts should, in a perfect world, courts would downgrade canons and downgrade dictionaries, in part because they're contextual, in part because they have been coming up with new canons and applying them in unpredictable ways. I actually have some empirical work on the canon use in the first 10 years of the Roberts Court myself that suggests that they're not being consistently applied despite claims for that application. So do we have to make sense of the language that went through bicameralism presentment? Absolutely, but a better way of judging and more faithful to Congress would be a contextual approach that is sensitive to what Congress was actually trying to accomplish. And word meaning ought to be anchored in what Congress was doing rather than what the board of the American Heritage Dictionary thought was the right way to define the term. What about advocates? I think advocates right now are stuck in this world of dealing with the way courts have been working with language, which has been way too much attention to tiny inconsistencies across the U.S. Code, varying definitions and corpus linguistics. But I'm hoping we'll evolve towards what I hope will be a more nuanced approach to judging that is more sensitive to Congress's primary role in drafting the legislation.
So thank you to Professors Nelson, Adler, and Busby. It's been a really fascinating discussion, and we will move on.
Thank you for that. And I forgot to introduce our alum, Jay Pendergrass, who moderated our last panel, Vice President at the Environmental Law Institute. We're now pleased to be able to take a break from our academic perspectives on the Clean Water Act and get a perspective from the folks that actually have to enforce and implement and administer it in the face of all the challenges that the Clean Water Act faces. And so I'd like to introduce Ms. Elizabeth Caesar, who is Special Assistant to the Administrator in the Office of Water, on loan from the Joyce Foundation, where she has overseen their environmental programs. And for those of us in the Great Lakes region, we know that water quality in the Great Lakes in particular is a particular concern of the Joyce Foundation and has been a particular concern of Ms. Caesar's throughout her work at EPA, at the Joyce Foundation, and before. So without any further ado, I'd like to turn the podium over to Ms. Caesar.
Good morning, everybody, and I will have to start by saying I'm excited to have our colleagues here from NEORSD. If EPA had a Twitter feed like yours, I really think we would be in a very different place. Highly recommend for people who care about water, the NEORSD Twitter feed. So as Jonathan said, I'm a senior policy advisor to Assistant Administrator Pfas, and I'm there on an interagency personnel agreement from the Joyce Foundation, and that's important because that means I'm not a political appointee. But also just want to remind everybody, with all of the current litigation and the rulemakings that are in front of the agency, there are going to be limitations to my comments that will probably frustrate everybody. And I'm going to really be focusing more on policy issues. Jonathan asked me to kind of talk about what are the opportunities and challenges we're facing at the agency right now, how are we approaching them, and the panel we just heard probably in a nutshell capsulizes many of the challenges we're facing sort of across the board, both on the regulatory and litigation front. I think one of the things I'll start with is I don't know of a time in my career where I've seen the Office of Water tackling such a broad range of issues proactively, whether that's regulatory, permitting, or in the litigation context. As well as, frankly, managing what we hope to be is a transformational investment in water infrastructure through the Bipartisan Infrastructure Law. And given the breadth of this work that was facing the administration, both the administrator and the assistant administrator really have had to identify some initial areas of focus. And I'm going to touch on a couple of those, and then we'll have time for Q&A. And again, I just want to say, because of all the litigations we're facing right now and the rulemakings that we're undertaking, there are going to be limits to the kinds of things I can address either in my remarks or in responses to your questions. And as I reflected on what I was going to talk about today, especially with the importance of the Clean Water Act at 50, I wanted to talk about a couple of cross-cutting priorities that you'll see reflected in the Office of Water's work. First, Administrator Regan and Assistant Administrator Fox take very seriously their responsibility to make sure that the protections of the law and the resources that federal government has at its disposal reach everyone. You'll see that reflected in the actions the agency took in 2021 and those that we're going to be taking this year and beyond. The agency is also increasing its enforcement activities under Title VI of the Civil Rights Act, which I'll speak more about in a minute. Second, science is back at EPA. The agency is looking hard at public health and environmental data, and policy decisions are being driven by what the data tells us. Now, as our colleague, Brother Adler will tell us, there was a lot of room for healthy debate about what policy actions one might take based on the available data, but there's really a strong emphasis on restoring the scientific integrity of the work being done by EPA, but also making sure our career scientists feel comfortable talking transparently about their work and its implications. So let me give you some specific examples about how these values are playing out across our work. So the first thing I'm going to talk about is the Bipartisan Infrastructure Law, also known as the Infrastructure and Investment in Infrastructure and Jobs Act. So as many of you know, the Bipartisan Infrastructure Law delivers more than $50 billion with a B to the EPA to improve our nation's drinking water, wastewater, and stormwater infrastructure. This is the single largest investment in water that the federal government has ever made. More than $43 billion of that money will flow through the state's revolving drinking water and clean water funds. That means that the states will set policy largely on how that money flows. Nearly half of that money must be provided as grants and forgivable loans. Last month, EPA issued an implementation memo for those funds that will flow through the SRFs. And in that memo, one of our top priorities is ensuring that disadvantaged communities benefit equitably from this historic investment. These communities are found in rural, urban, and suburban parts of our country, in every state, in every territory, and on tribal lands. And they often include low-income people and communities of color. And as you know, disadvantaged communities really are on the front lines of our biggest environmental challenges, experiencing disproportionately high levels of exposure and pollution in air, land, and water. I will also add, because they are low income, that means that challenging troubles and difficulties in infrastructure have largely been left unresolved because states turn their back or can't find an answer because there are just not the resources to cover the cost. So one thing to keep in mind is both the Safe Drinking Water Act and the Clean Water Act gives states the ability to decide which communities qualify for additional support through their SRF programs by giving them the authority to define the term disadvantaged community on the drinking water side and to set the affordability criteria on the clean water side. And while states work to roll out these funds, EPA does expect them to evaluate and revise their affordability criteria and definitions of disadvantaged community to maximize the impact of these funds in addressing urgent water challenges that are facing communities. EPA also recognizes that many communities are going to require more assistance to access these funds. So we have been requesting and urging states to use the 2% technical assistance set aside to help disadvantaged communities complete their SRF funding requirements. The agency is also going to be rolling out a robust technical assistance strategy of its own to help support communities that face challenges in accessing these state revolving loan funds. So another way that the agency, particularly under Administrator Regan's leadership, is working to ensure that EPA is delivering legal protections and federal resources to every community is to bring EPA's enforcement of Title VI of the Civil Rights Act in line with the enforcement activities of our sister agencies in the federal government. As you know, Title VI prohibits recipients of federal funds, whether they're states, local governments, or private entities, from discriminating based on race, color, or national origin in any program or activity. Title VI prohibits not only actions that are intentionally discriminatory, but also actions that have an unjustified, disproportionate impact on the basis of race, color, or national origin. The threat of withholding federal funds afforded by a civil rights law has been a powerful tool for driving change to address discriminatory practices. But in the past, EPA really hasn't been fully engaged as other federal agencies in ensuring compliance with Title VI obligations. The agency's Title VI approach is really rooted in its history. When EPA was created in 1970, several years after the passage of the Civil Rights Act, civil rights enforcement really took a backseat to other priorities. And the agencies really struggled to recognize that environmental statutes on their own don't address racial disparities in exposure to pollution, nor do they address disparities in the way people are treated based on their race, color, or national origin in environmental decision-making processes. In 2020, the EPA's Inspector General found that EPA is not providing the oversight needed to ensure that organizations receiving EPA funding are complying with Title VI. The Biden administration and Administrator Regan are really committed to ensuring that EPA steps up to its obligations, and we're taking both internal and external actions to catch up with our sister federal agencies in this area. For example, in the Office of Water, you'll see that new guidances for states, including the implementation memo for the Bipartisan Infrastructure Law that I just mentioned, explicitly references Title VI obligations, and you'll see that consistently in our program and funding documents going forward. I'd also note that EPA has accepted jurisdiction over a civil rights complaint filed on behalf of the residents of Providence, Rhode Island. The complaint alleges that Providence Water's water main replacement and rehabilitation program and its general policy and practice of private side lead service line replacements disproportionately increase the risk of lead exposure for Black, Latinx, and Native Americans. And if you all are not like fully versed in how lead service line replacement and are interested in this, I'm happy to get into that during Q&A. So while not prejudging, and because of this is an open investigation, this is really all I can say. The EPA will be looking at the following question: whether Providence Water Supply Board discriminates on the basis of race and national origin through its water main replacement and rehabilitation program, and whether its general policy and practice for private side, and through its general practice for private side lead service line replacements. I'd also note that many cities implement their lead service line replacements in the way that Providence Water has. Jonathan asked me about suggestions for research, and this might be an area that would be interesting to examine. Are there areas where EPA should be looking with particular care at Title VI compliance by recipients of federal funding from us? The third example I'd like to share kind of falls at the intersection of our interests in ensuring EPA's water work benefits everybody and the importance of the Clean Water Act enforcement as we approach the 50th anniversary of the Clean Water Act. And I'm afraid this is going to perk up the ears of my friends at NEORSD. It's about the financial capability assessment guidance. It's pretty wonky, but since I'm talking mostly to a group of lawyers, I feel pretty comfortable getting kind of wonky. So the financial capability assessment guidance currently out for public comment outlines a set of factors that EPA will consider when setting a schedule for a municipality to address Clean Water Act violations. It describes the information and the formulas that the agency intends to use to assess the financial resources that a community has available to implement control measures when municipal discharges cause violations of the Clean Water Act. This is particularly relevant. There are lots of Great Lakes cities that have consent orders with EPA that are coming up for review. So this is an area where we know there will be a lot of attention. The proposed guidance tackles head-on the challenges of protecting clean water in every community in America while aiming to ensure that water services remain affordable to all. So for the first time, EPA will be asking municipalities seeking schedule extensions and certain water quality standard revisions to affirmatively demonstrate the actions they've taken to help ensure that low-income customers can afford water services. It isn't sufficient to just present data that a system has a significant number of low-income customers. The agency will be asking what affirmative steps the system has taken to assist those customers, particularly at this time where there's so much money moving through the SRFs that is available for as either grants or 100% forgivable loans. There's never been a better opportunity for communities to take advantage of these resources, particularly to protect their lowest income customers. This more detailed analysis will help communities and EPA get a clearer picture of a community's financial capability and strategies we can use to protect low-income residents and achieve timely and equitable clean water protections. Together with the Bipartisan Infrastructure Law, this guidance will support lower-income residents having more rigorous Clean Water Act protections. And the guidance is also an example about how the administration and the Office of Water are really looking carefully across policies to try to ensure that the agency is meeting the end goal of environmental protections for everybody, no matter their income or zip code. The other cost-cutting priority I want to talk about briefly is, as we reflect on the agency's opportunities and challenges at the 50th anniversary of the Clean Water Act, we really are emphasizing this sense that science is back and that scientists feel comfortable raising to political leadership. Here are the implications of the data that we're seeing, regardless of whether that's a comfortable analysis or not. And one place you're going to see that is the agency's work to address PFAS contamination. Our PFAS strategic roadmap, released in October, outlines a whole-of-agency approach that will be taken to PFAS. And a key commitment to that, in that roadmap, is to propose a drinking water regulation for PFOA and PFOS, and potentially other PFAS by the fall of 2022, and to promulgate a final regulation by the fall of 2023. We're currently conducting the economic analysis and consultations required to propose a drinking water regulation, including seeking input from our state co-regulating partners. The second example of this administration's commitment to following the science is the lead and copper rule. The science of lead is settled, there's no safe level of exposure to lead. In December, EPA announced that the agency is working to strengthen the lead and copper rule to be more protective of public health. The agency concluded our review of the lead and copper rule revisions and have identified more opportunities to be proactive and embed equity in this work. We reached these conclusions following a really robust public engagement process between April and August of last year, where we actually sat down with 10 communities that had direct experience with lead exposure in their water, roundtables that included residents with agendas set by those residents. And the regulatory staff that worked on the rule were actually the people who led and helped facilitate those meetings. And that one-on-one interaction, I think, really helped inform in a different way, based on lived experience, how the regulation was working and not working for communities. So the lead and copper and rule revisions that were drafted under the prior administration have gone into effect to really help support near-term actions that will reduce lead in drinking water while we work on the next rule. One of the most significant of these is the completion of lead service line inventories, and at the same time, as I said, we're embarking on another rule to further strengthen the protections that this rule can offer. We're in the active process of developing the rule and remain committed to following the science and the law. And we're on track to have that final rule before the end of the first Biden administration. The work on the lead and copper rule is just part of a holistic approach at EPA that we're taking to address lead. And so I'm going to just stop there. I think the thing I really wanted to focus on here is we're really trying to look holistically at both high-profile things, guidances and implementations and funding documents that are very far in the interstices of the agency, to identify places where we can institutionalize and make more durable allegiance to science, the capacity of career staff to identify and document issues, so that as we move forward, we can try to address some of the ping-ponging we've seen in recent years. You know, we'll see if that's something we're able to accomplish, but that is very much something the administrator cares deeply about. So I'm going to stop there, talk long enough, and look forward to your questions.
Thank you for that. Appreciate it. I'm Eric Luckage. I'm the Chief Legal Officer at the Sewer District, actually. So we really appreciate hearing what you have to say. And it's a lot of the continuing dialogue that we've been having with the agency, certainly. And I appreciated hearing the holistic approach to things. We hope that from the overall regulatory standpoint that there's a holistic approach to that as well. And what I mean by that is that when we're talking about money, and we're talking about $43 billion for the country, our district has a $3 billion consent decree for combined sewer overflows just for our community. And so we appreciate the $43 billion, and we look forward to more.
Yep, 100% in agreement with that. Let's talk about it.
And certainly more grants than loans, because our community is paying back those loans, and we appreciate them as well. They're very helpful because of the low interest. So we at the district are also very laser focused on environmental justice issues. It's a very big aspect of our community. And so when we're looking at trying to solve those problems and trying to focus on environmental justice communities and all of that, we're also sort of staring straight ahead at Pfas, right? And what's coming down the road. And what are those regulations going to look like, and what are the costs going to be associated with those? We're also hearing quite a bit of discussions about nutrients and phosphorus and lowering those limits to really low levels. And what's the cost going to be on that? So as we look at all of these problems holistically, we like to talk about, integrated planning with respect to how is a community like ours going to address all these very important issues and address the environmental justice aspect of it and pay for it. And we take a lot of heat for our rates already. And we want nothing more than to clean up more of the problems and do even more. But there's a real balance to be found there. So I would just like to emphasize the importance of the ongoing funding and the ongoing understanding of how all these pieces fitting together, particularly on the PFAS and the phosphorus issues, are coming together at the same time and to be gentle with us. I'm
No, I couldn't agree more. It's a tough balancing act, right? Like, which is your favorite child? Or your least favorite child, maybe. I think the EPA issued a nutrient policy memo this week. And one of the things we talk about is NPS program permitting. And we're going to be doing some rulemaking and some guidance to make it clear to states that integrated planning, watershed-based permitting, these are all appropriate approaches for permitting, because these upstream, downstream challenges, especially around phosphorus, especially in this part of the country, it is way cheaper to deal with that stuff outside of the fence line. And really trying to make it clear without creating some crazy market of credits that isn't going to work. To be able to make sure facilities like yours have the ability to write into their permits upstream and downstream controls. So I hear you, and I think that's one of the things that's really tricky right now, is that a lot of the regional staff that have the capacity to help states and utilities work through some of these complex questions about, like, where are we going to focus? We got limited dollars, we've got a host of issues. A lot of those folks have retired. And the challenge that we have as an agency of rebuilding our capacity is a really significant one.
Thank you for that, and thanks for the shout out on the Twitter. Rick's actually building really cool tunnels. They're probably even better than the Twitter account.
I mean, as good as Wisconsin's tunnels or Chicago's? I don't know, gotta talk about that. Smart sewers in Mayor Pete's town are also pretty cool.
We have 7 of them, though.
To build on that, 43 billion, 50 billion sounds like a lot of money, a huge investment, but as you just demonstrated, it's nowhere near enough to deal with all the problems across the United States. Are you able to go beyond the specific loans and guarantee, say, if they're issuing a bond to use, or can you allow the SRF to use the funds to guarantee that, which would greatly expand the reach of the funding?
So states have that authority now, and many of them use it now, use it very well, very creatively. We don't have the authority to make them do it. But I think one of the things that can be done is really highlighting the value and the way that those kinds of approaches stretch that money. But what we're also seeing is a lot of states have a whole bunch of money in the bank that they haven't gotten in the ground. And that's where we're really trying to lean in, because one of the problems is the pipeline of projects to the communities that need it most. Those communities don't have the capacity to develop the infrastructure plan, to get the resources, and then put it in the ground. And that's a place where we're really trying to lean in. Go ahead.
Sorry,
Thanks. I may be wrong about this because it's not my particular field. I thought the problem with using the Civil Rights Act for environmental justice was you needed to show intent.
Nope, not under Title VI.
So the intent is only Title VII.
Yeah, this is an unjustified disproportionate impact. So in the case, what's alleged in the case in Providence is that when you replace a lead service sign, if you replace only half of it, the quote-unquote public side, a partial, you actually increase the risk of exposure. And so if the way the program is laid out is you only replace the full line if the resident can pay for it, the impact is that if people who can't pay are now exposed to more lead. And so, this analysis has 2 parts. There has to be a disproportionate impact that's unjustified. And so this is the question that we'll be looking at.
Please join me in thanking Ms. Sarford. I guess it'll be about an 8-minute break. We will reconvene with our second panel at 11. So there's coffee, refreshments, extra legs. I'm sure it's bright and sunny warm outside like it always is in Cleveland. So see you in a while.
disgusting cat that I have. It's totally unrelated to COVID. It's sinus issues. And my apologies.
Yeah, I just know from my own experience writing on it that
teaches classes here on climate law and land use regulation, and an awesome course that goes through the fascinating and perhaps, I guess, a little bit depressing permitting process for Lake Erie wind. And we certainly love having an alum like her back to do that. So I'm going to turn it over to Beth and our second panel.
Great, thank you, Jonathan. Good morning, everybody, and it's a pleasure to be here with you and to have a all-star panel here. I'm going to introduce them and then we will launch the panel. First, Professor Robin Craig, University of Southern California School of Law, whose title is I specialize in all things water, but also has a PhD in English literature with a specialty in how English Romantic poets use science to explain social change. So I think we'd like to hear a little bit about that also. And Professor Annie Brett, University of Florida School of Law, who works on ocean policy and is also an accomplished mariner and the youngest female vessel captain to operate in the Pacific, and still going on ocean expeditions. So, also, we are fortunate that we have the technology when the airlines fail to bring Sheila Olmstead, who will be brought up on the screen when she is speaking, but is listening in now, from the University of Texas School of Public Affairs, and also a fellow at the Resources for the Future, who will be talking about her work on the environment and resource economies. So thank you, panelists, and I think we'll start with Professor Craig.
All right. Well, good morning, everyone. My thanks to Jonathan for inviting me to be here. This has been a very illuminating conference so far. So I'm going to talk about has the time come to distinguish between Section 402, the NPDES permit program, and Section 404, the dredge and fill permit program or wetlands permit program, depending on how you want to look at it, and can the agencies actually do it? And so, just a starting note, when I first proposed this topic, I thought it was going to be a hardcore administrative law riff on what you can do in the wake of Maui County. But I think the Supreme Court is about to do the heavy lifting for me, so I will be focusing on Sackett as well as Maui County. So why even think about separating the permit programs legally? I am a 402 fan, I will say that from the get-go, and all of the WOTUS litigation has been putting pressure on the 402 program in ways that upset me. So that's why I came up with this topic. But the two permit programs actually came in the drafting history from different places at different times. Section 402 was the pollution control problem. Buzz emphasized wanting to get a handle on pollution control. And they actually resonate in very different legal webs, if you think about it that way. So if you think in terms of what does 402 stop, it really protects the public against bad actors, against polluters. It protects the public interest, resonates with public nuisance, protects aquatic ecosystems, protects against private nuisance, protects those public use aspects of waterways, and it really is hard to frame in a negative connotation when you're thinking in terms of who's being protected from what. Not so 404, as we've all become very well aware. What does it stop? Private property use, development, profit, land use planning, all these things have been named. It resonates very differently, and like I said, it came from a different place. It grew out of the Army Corps' ability to protect actual navigation, and then got put into a much broader definition. So we have basically the same jurisdictional terms controlling both. If you want further proof that they resonate differently, I direct you to Justice Scalia's opinion in the Rapanos decision, which, after waxing excoriatingly against what the EPA and the Army Corps are doing under Section 404 in the style only Justice Scalia could do, he he actually backs up and tries to protect Section 402 at the very moment he's contracting the waters of the United States definition. Like I can give you no better proof that they resonate very differently than what Justice Scalia was trying to do in that opinion. They also have been different timing legally, so this is just a rough and ready when has the Clean Water Act reached the Supreme Court. As you might expect for the complicated new regulatory program, a lot of decisions at the Supreme Court in the first decade, a lot of those directly NPDES decisions. And then kind of evened out if you look at the Act generally or NPDES in particular. But 404 bucks the trend, and the cases addressing 404 have actually been increasing, and a remarkably high number of those are jurisdictional in one sense or another, particularly with respect to WOTUS. And our first panel went through these decisions, so I'm not going to reiterate them in what they decided, except to emphasize that all of them came out of the Section 404 program. There is none of these decisions are addressing the scope of Section 402, and I actually would make an argument in Swank that the justices didn't even recognize they were simultaneously addressing 402 in the Swank decision. That had been clearly pointed out to them by the time of Rapanos, but not in Swank. All right, so Sackett versus EPA. Like I said, I didn't think I was going to be able to rely on yet another Supreme Court opinion for the argument. But once more into the breach, this is Priest Lake. It's a clearly navigable, in fact, commerce navigation, whatever traditional navigable waters definition you want to use, it's got it. Nobody's arguing about Priest Lake. What everybody's arguing about is this parcel of property that the Sacketts own. Has been mentioned. They are on their second trip to the Supreme Court about developing this property. It's now largely filled in, but I show this picture because it's not that far from the lake. All right, you would think it would be relatively easy to connect this to a navigable water of the United States. The Ninth Circuit actually unusually included photos as part of its opinion, showing some of those connections. They're taken from 2007 and 2008 because by the time of the Ninth Circuit decision in the second version of Sackett, the property was largely filled in. But I gotta love the Ninth Circuit. This is the actual logic the Ninth Circuit used to connect the Sackett's property. Now remember that photo, okay? The wetlands were adjacent to an unnamed stream 30 feet away and on the other side of road that's tributary to Kalispell Creek, which flows into Priest Lake, a traditionally navigable water. Those wetlands were part of one of the 5 largest complexes on a 62-mile long shoreline, and these wetlands in combination significantly affect the integrity of the water quality of Priest Lake. That's the Ninth Circuit's significant nexus analysis. I really wouldn't want to be defending that in the Supreme Court myself. And in fact, the United States brief relies heavily on the district court opinion, which much more simply said, yeah, the wetlands are directly connected to Priest Lake through a subsurface connection. All right, so that's what we're dealing with. Now, the cert question has been mentioned, whether the Ninth Circuit set forth the proper test for determining whether wetlands is, that's the Supreme Court, not me, waters of the United States under the Clean Water Act. What I think is significant about the way they phrase this, it actually changed from the requested cert question, which is basically what opinion in Rapanos controls. And they switched it around at the Supreme Court to emphasize the wetlands. So I think a little bit more than which Rapanos opinion controls is going to be an issue in Sackett. We might be revisiting a footnote from Riverside Bayview that said we're only talking about directly adjacent wetlands. We leave all other wetlands up for further discussion. So I think that's on the table. And of course, we now have a new justice, so we've got at the time I did this slide, she was not yet confirmed. That happened yesterday, all right? But we now have a new justice to add a little bit more uncertainty to the decision. So, what is in the context, or in the wake of Sackett, or what I think Sackett's going to do? What can we do to leverage Maui County? To remind everybody, April 23rd, 2020, Maui County's decided that is an NPDES decision. In the NPDES context, the Supreme Court went out of its way to find jurisdiction. And it invented, and it was an invention, the functional equivalence test, that we hold that the statute requires a permit when there is a direct discharge from a point source into navigable waters, or when there is the functional equivalent of a direct discharge. In this case, going into an underground injection well through groundwater, roughly 83 days later, showing up off the coast of Maui on a very nice coral reef that shouldn't have treated sewage dumped on it. All right. So, what that opens up is a way of getting to a direct discharge that doesn't require immediate waters of the United States. And I think that is important for what the agencies could do. So this is just a rough outline, somewhat simplified, but I don't think distortingly so, of what the December 2021 proposed rule redefining waters of the United States does. We have the traditional navigable waters, and what I could call uncontested waters, waters no one has ever contested that can be regulated under a federal statute. The territorial sea, the ocean, waters that hit the Commerce Clause test, ebb and flow of the tide test, interstate waters. Everything else is basically using the either-or approach from Rapanos. If you meet either Justice Scalia's test or Justice Kennedy's test, you're in. Like I said, it's a little bit of a simplification, but not that much. And then two exemptions for waste treatment systems and prior converted copland. So that's the proposed rule as it's set up. Mostly goes back to the regulatory definitions that we had in the 1980s with what I call the Rapanos adjustment.
Robin, what is TNW?
Traditional navigable waters, sorry. Traditional navigable waters. The agency, EPA uses a different definition, but yeah, traditional navigable waters. Sorry, that was to keep the text boxes from getting way too small to read. All right, so what could you do with what I'm predicting Sackett will do, plus a Maui County definition? And I think you end up with an effect that's not all that different from what the proposed rule would do for 402, but maybe very different for 404. So you get the discharges into those traditional navigable waters. Again, ocean, territorial sea, things that trigger the commerce definition, the ebb and flow test, and interstate waters. Whoops. There we go. Plus, you get discharges directly into the adjacent waters. Riverside Bayview Homes is still 9-0, so the directly adjacent waters are probably going to stand up, although I predict that will be a direct surface water connection and not an underground connection after Sackett. And then with Maui County, you get the functionally equivalent discharges, which, like I said, is going to, in my humble opinion, anything that can pass the significant nexus analysis under 402 is probably going to be able to pass the functional equivalent discharge analysis. Maybe some timing, maybe some distance constraints, but that's going to be mostly the same category. I think it's going to be very different for Section 404, and so I think that's going to be the prong that could distinguish those two permit programs in a way that could be significant. But I think, like I said, if Sackett does what I think Sackett is going to do, the agencies could promulgate this sort of regulation, be perfectly in concert with the Supreme Court decisions that are out there, and very successfully have a much broader 402 program than a 404 permit program. Whether that's good, bad, or indifferent, I leave to discussion. Like I said, this is a reaction to the fact that Section 404 has been driving the scope of Section 402, and I'm attempting to say, hey, if you wanted to reverse it, could we do it? I think now we can. So I'll just leave you with the thought. In other words, if what I suggest actually comes to pass, we'll care less about what water the pollutants are going into and much, much more about where they actually end up. And so with that, thank you very much.
Okay, great. So I'm going to take a bit of a detour from waters of the U.S. here and talk about the total maximum daily load program. So let me just start with a bit of context here. So I just pulled this off of the EPA website a couple of days ago. And just, you know, there's, I think, a few interesting things about this particular look at the overall health of waters in the U.S. First of all, we're still only assessing about a third, give or take, of the water qualities throughout the U.S. This is not a new number, but interesting to see that 50 years on, or maybe 20 years on since TMDLs and the associated programs were actually starting to be implemented, we still have huge gaps in the data we have about the waters of the U.S. The second piece is there's a lot of impaired waters, right? So the red numbers are quite high. As I was actually pulling this out, I was quite surprised by how different the numbers of impaired waters are across different types of water. So rivers and streams versus lakes, very different percentage of waters are being found impaired. So a few different reasons for that. That is not what I want to talk about today, but I think important to know that the number of waters that we have in the U.S. that are listed as impaired is very high. And so for these waters, we are developing total maximum daily loads, as you all are familiar with. So this number is up to around 74,000 right now, approved total maximum daily loads throughout the U.S. Note that this number doesn't really go down because once a TMDL is issued, it for the most part stays in place, which is in fact EPA's advice to ensure that the water quality for these bodies is maintained over time. So with this large number of total maximum daily loads, which are intended to improve the health of these impaired waters, the big question is whether or not total maximum daily loads actually work. So looking at the evidence that's out there for this particular question, there's been existing studies, but they tend to focus on how far along the TMDL program is in its implementation process. And so a lot of EPA's work and kind of general congressional reports answer this question of TMDL implementation status. Suffice it to say, there's a lot of gaps in that implementation process. But that's not what I wanted to focus on here. I want to actually think about what impacts we're seeing on water quality after TMDLs are implemented. So there's also been a number of more individual studies that look at, in specific water bodies, how implementation is being done well and in what cases we start to see improvements in water quality over time. The larger question of whether or not we're seeing TMDLs improving water quality across the US after implementation is largely unanswered at this point, and so that's what I'm trying to tackle with this particular study. Suffice it to say, it's a very big question, and so I've kind of chunked this into a couple of different parts, and what I'm reporting on today is what we'll call chunk one, which is some initial data, but there are several chunks to come, so I'm happy to talk about each of these different pieces. Also worth noting that I've simplified this data a good bit, so if you have methodological questions or more in-depth questions about the data side of it, I'm happy to dive into them, but I didn't want to make this too technical for today. So one of the questions that I'm looking at here is basically, there's a very easy indicator of whether water quality is improving over time, which is looking at whether its status changes from being impaired and listed on the impaired list to moving off of the impaired list and being listed as good, right? And so this is relatively easy to track with the EPA's water data portals, which incidentally have gotten much better in recent years. So great to see the efforts that EPA is making to improve that type of mechanism. Okay, so these are waters that are moved off of the impaired list over time. It's a significant number if you look at it, several thousand a year usually getting moved off of the impaired list, and there's not really any trend associated with this over time. What I did is looked at the reasons for these delistings. So why are waters being moved off of the impaired list? And you'll see the vast majority of the time it's because there's been a TMDL approved and put into place. And so In some cases this happens, in some cases it doesn't when there's a TMDL approved, so this makes the data analysis a little bit odd. But this is a big reason. Another big reason is that there's a change in terminology in terms of how standards are being developed and what baselines are, or if there's resegmentation of the particular waters. There's a very small percentage, so 1%, where we're seeing water quality standards that are being attained for one reason or another. So about 1% of our waters that are no longer on the impaired list is because there was some notable improvement in their water quality over time. But I was really interested in this segment where we have TMDLs being approved, but we don't really know if that means that their water quality is getting any better or not. So what is happening in this particular category of waters? So in this category, do waters that have been taken off of our 303D lists but still have TMDLs in place, do we see improved water quality over time in those particular waters? And so what to think back, right, there's about, this is about 35-65 breakdown, where 65% of the TMDLs are remaining on the impaired list. So those ones we pretty much know that they're remaining impaired, right? They're still on the impaired list. There's a good reason to suspect that they're still impaired. 35% are removed from the impaired list, and these ones there's a question about, right? There's a question whether or not their water quality has actually improved, even though they're not on the 303D list anymore. And so after doing a pretty intensive random sampling of this group, so this is 74,000 TMDLs, right? So there's about 24,000 in this list that have been removed from the impaired list. So obviously I can't look through all of those in a lot of depth, even with an army of RAs. So we did a random sample here that at this point is pretty extensive, but working to make that sample larger as well going in the future. And found that in about 1% of the cases, we see improvement in the waters over time. So this is not a super optimistic picture of what is happening with the total maximum daily load program, I'm afraid, and I wish it were more optimistic because it's the kind of thing that doesn't necessarily strengthen the case for why the Clean Water Act is important. But I think this is a very important data point as we analyze where to go, particularly when it comes to non-point source pollution, which is such an important factor in determining nationwide water quality. So here, right, we're seeing that in about 1% of cases, the total maximum daily load program, we've seen waters that have TMDLs improve in water quality. And so these ones actually, we're looking both at whether or not their status has changed from impaired to good, but also on a more granular level, whether we're seeing actual numerical improvements in water quality within those rivers. So some evidence that it's working in some cases, but the vast majority of cases, there's not a significant improvement in water quality in these bodies as a result of the TMDL program. So a couple of takeaways from this, right? Mostly these TMDLs have not led to significant changes. There's still a lot of data gaps in these particular studies, looking at whether or not certain types of data is available has a large impact on the quality of these results and the robustness. So I think for this project, there's a few next steps and places that I plan to go with this quantitative research. And the first is looking at not just with these TMDLs that have been taken off the impaired list, but with a broader category of TMDLs, looking at more in-depth information about those waters and looking at whether or not there's been an actual change in the underlying water quality, as opposed to using this impaired, not impaired as a proxy, because there's some problems with that. Unfortunately, this step is much more time intensive and requires significant resources to look through each TMDL in depth and understand why they're being listed, what the deficiencies are in their current status, and then what their current water quality is. With some states, it's much easier to find that information than with others. And then there's a lot of heterogeneity by states, both in the number of TMDLs enacted, but also in how these TMDLs are being implemented. So this, of course, has a big impact on what states we're seeing more success with TMDLs versus less. And so next steps for this project are certainly to look more at that heterogeneity and understand better where and why TMDLs may be implemented more successfully. And the last is there's a few areas where I've begun to identify essentially paired TMDL and non-TMDL waters to try and come up with a way of getting to a statistical understanding of not just in the same water body whether there's water quality improvement over time, but if you can see if there's a TMDL on one water and not a TMDL on a very similar water, whether or not you can control for all the necessary factors to really understand whether or not that TMDL has led to any significant improvement. Because it's not just the TMDL that's at a clean rate, but also the surrounding water quality. So if there's stressors, it may be that the TMDL is working better than having nothing, but it's hard to say that without these controls. So that's another piece, but that's one that's much more resource intensive as well, so longer quantitative projects to look at. But I think this initial data gives us a good understanding of, at least at a broad scale, how effective the total maximum daily load program has been. It's been roughly 25 years since it's been kind of meaningfully implemented around the US, so a significant amount of time and a good place to take stock of how successful this program has been. I don't think this result is particularly surprising if you look at the studies that have been done and the literature by other academics. There's a broad understanding that the TMDL program has fatal flaws in the fact that it doesn't have as many teeth as we would like to see. But I hope that this work helps to highlight perhaps the extent of the issues with this program. And my goal here was not to point to solutions. There have been many, many papers, many by people in this room, about how to potentially target non-point source pollution in a more productive and efficient way. The TMDL program right now is perhaps not doing that. It's also very costly, right? It's hard to get exact numbers from EPA on how costly it is, but it's certainly in the billions of dollars according to estimates. So something that requires significant resources, and we're not necessarily seeing the changes on the ground that we might want to see as a result of that.
Thank you for joining us by Zoom. I'm sorry that you were not able to join us in person, but
me too. Yeah, so it's a pleasure to be here. Really interesting presentations by the first two panelists. So I'm excited to engage in some discussion afterward. So I'm the first non-lawyer on the panel, so you'll forgive me for focusing on benefits and costs, like economists do. But I think one of the things that's an interesting connection to some of the prior talks is that you'll see that some of the kind of economic downsides of the CWA are related to jurisdictional questions too, not so much over which waters are covered, but over kind of which sources of pollution can actually be regulated. And this also links to some of the comments that Professor Brett just offered. So should I share my screen, or are you? Does that make sense? Or is someone going to click through my?
Sure.
I can do it either way. Okay, so let me share. Can you guys see my slides?
Yes.
Can you both see them? Yep. Okay, great. All right, so the problem I'm going to focus on today is the problem of nutrient pollution, because I think it's kind of a classic example of a case in which the Act is maybe not kind of perfectly designed to address an important pollution problem in terms of thinking about where the actual causes are and what the costs of, and benefits of, might be of addressing it. And so that is the problem of nutrient over-enrichment. So again, forgive me if folks in the room already are quite familiar with this, but the idea is that nutrients like nitrogen and phosphorus run off of land, it could be agricultural land, urban land. Sometimes they make their way into waters from atmospheric deposition. That's an important cause in some places. And when that happens, those nutrients create good conditions for plant growth, but if it's too much, you get an overgrowth of algae. As they die and decay, they use up oxygen, sinking to the bottom, and then you end up with areas that are hypoxic, areas where aquatic organisms can no longer live. Some of those organisms can move out of the affected areas, and others can't, and so you end up in some cases with dead zones, which are really prevalent around the world, but also here in the US, we have a lot of challenges with this particular pollution problem. Places, that you might spend time, the Great Lakes are not coastal in this map, but the Great Lakes certainly, have challenges with eutrophication and hypoxic areas, as do much of the kind of US Atlantic and Gulf Coast and increasingly the Pacific Coast as well. So there are some challenges to addressing this important pollution problem. The first is that I think economic analysis is just beginning to monetize the damages from this type of pollution. The second is that agriculture, which is often but not always the primary source, is only partially regulated under the Clean Water Act. The third is that sources of nutrients that create these damages are often far upstream and very often out of state, of the most direct damages. And then finally, the kind of regulatory temptation in this setting is to, right, when everything looks like a hammer, or when all you have is a hammer, right, everything looks like a nail, right, toward more stringent controls on point sources, which are both costly and potentially questionably effective when we look at kind of where the problem is coming from. So I'll show just a little bit of data on both of those points. So to the first challenge, I think, because historically, sort of nutrient pollution has been emerging over time as a really important pollution problem. There's good understanding of impacts on commercial fisheries, especially in the Gulf of Mexico. There is emerging evidence of health effects from harmful algal blooms, which are related to nutrient over-enrichment. For example, there's a nice paper by Ben Jones at the University of New Mexico showing a causal effect of harmful algal blooms in Gull Lake, Michigan on low birth weight. So those health effects can have quite large economic consequences once you start to see those, similar to what we see on the air pollution side, but of course the scale is much larger for damages on that side. And then there are also occasionally water utility closures, like the city of Toledo sort of famously had to close its, prevent people not only from drinking the water, but you can't even boil it, right, once these organisms are in the water. It's very dangerous to human health. And there are costs associated with those kinds of impacts as well. But to my knowledge, not quantified, not well quantified. There are also recreational damages, and those are beginning to be quantified, and I'm going to focus on that for just a minute. And then also other property value impacts of these increasing kind of areas of nutrient over-enrichment. And then there also is new evidence of climate damages from this, because eutrophied lakes emit methane. Methane is a potent greenhouse gas, and so there is this kind of climate water pollution link that I'm interested to talk about in the discussion as well. So just as an example of the kind of pollution I'm talking about, in Tampa, Florida, where I've just completed a study with several colleagues, you can sort of see these, algal blooms and, sort of the effects of nutrient over-enrichment from satellite photos, looking at that kind of greenish fringe around, where the nutrients are running off the land. You can also see it as, macroalgae mats, at the top of the water. This happens in the Great Lakes, happens in coastal areas in the United States when blooms are significant. And then sometimes as the tide goes out, you can leave these mats kind of stranded on sandbars and areas close to cities. Tampa had significant challenges with this through the 1970s, 1980s, and into the 1990s. So when we think about valuing the damages from this kind of pollution from an economic perspective, one of the things that has been a real challenge is moving over a lot of the damage estimation techniques that have been used for air pollution into the water pollution case. And one of the ways in which I think we've gotten this wrong in the many past decade or so has been to really just kind of import those methods. And just as a very broad sense, one important tool that we have is looking at the impacts of pollution on property values using what's called a hedonic property approach. And just as a basic idea of this, you sort of look at people's residences and you kind of draw a circle of varying radii around those residences, and you measure concentrations of pollutants within those radii. And you look at changes in pollution due to something like being in non-attainment with the Clean Air Act, and then you use statistical analyses to estimate the impacts of those pollution changes on property values. And again, the focus is very much on your exposure kind of in or near your home. And in the water pollution context, some new work that I've done with colleagues suggests that that's maybe not the best approach when we think about water pollution. That people don't necessarily sort of experience water pollution very close to their home, and in fact the data bear that out. When we look at studies that have been done on kind of water pollution impacts on property values, those tend to go to zero very close to people's residences, so within say 2 to 3 kilometers of people's homes. So just to kind of give you some intuitive sense for why I think this has not been right, this is a map of the city of Boston, so where sadly I am today instead of up there in Cleveland. This is my house, marked right here, very close to our Kirby Lane. And so I'm an aquatic recreator. I kayak and I swim outside, and I try to do those things at least a couple, 3 times a week. And if I just showed you this map, and I asked you to guess where it is that I spend most of my time in the water, it would be hard for you to figure that out, right? Not only my preferences or patterns of my own behavior. Really close to my house, there's this Shoal Creek, which is an ephemeral stream, like most streams in Austin, a semi-arid region. And I care about water quality in Shoal Creek. You know, I walk there with my dog and my kids. We step on the rocks. We don't get in the water. I care about it. If it smelled bad, you know, that would bother me. If it looked bad, it would bother me. But mostly, I care about where I spend time in the water and on the water. And my two spots are here. So there's my house. Here's Sculpture Falls, which is also on Barton Creek, which is also that's an intermittent surface water flow there. And then there's Barton Springs, which is a sort of famous Austin institution, 68 degrees year round. It's a little chilly, but when it's 105 outside, it feels really good. It's right downtown, it's an eighth of a mile long, and wonderful water quality for most of the year. So I care very much, right, about water quality in these places. And if you were to draw a circle around my house, even if you drew a really big circle, and you said, hey, right, these are the places that Sheila might care about and value, you probably wouldn't capture those. And even if you did, you would also capture a whole bunch of other places where I never go, I have no idea what the water quality is, and I probably don't value the change in that water quality very much. So we take a different approach in some recent work, and we say, hey, let's actually look at people's patterns of recreation and see kind of how that influences these estimates we might get of the value of water quality improvements from this property value approach. And we show basically that these estimated property value impacts are mostly recreational. Again, that's not necessarily true in all places. This is for Tampa, Florida, where there are a lot of kind of large, charismatic water bodies, lots of recreational activity in and on the water. But at least in this case, you really need to know where people go, right, in order to get this right, in order for those estimates to kind of to be even close to, to what we think their true value might be. And so in this particular case, the benefit from just from increased property values of cleaning up Tampa Bay, which is something that the city accomplished over a many decade period, likely exceed the cost. And that's not something that we see very often in benefit cost analyses of ambient water quality policies. The other thing I would mention is that, again, this recent work kind of with the climate change link, that methane emissions from eutrophic lakes worldwide have a climate impact that's about 20% of that from fossil fuel combustion and production. For Lake Erie, this is the case that we examined in this paper. The climate change damages from methane emissions may exceed all of the previously monetized recreational damages from eutrophication. So our sense from this case study is that those damages in the US context could be quite significant, right? That doesn't mean maybe we've just done a poor job estimating the recreational damages, right, from fishing and beach closures and so on. But in any case, the climate piece is potentially quite important here when we think about monetizing damages. So the second challenge that I mentioned is that agriculture is often the primary source of this kind of nutrient runoff into water bodies that creates these damages. And I'm just showing you a couple of pictures here on the left-hand side. This is just looking at nitrogen, the nitrogen inventory in the United States, going back to 2012, but it's a 2019 paper, so some of this kind of inventory data is not collected very often. And what you can see is that these are the contributors over here, right, to the inventory of nitrogen in the United States. And ag fertilizer, biological nitrogen fixation by crops and livestock waste together, those three contributors are the lion's share of the contribution of nitrogen, one of these important nutrients. And almost equally as important, if you look at the bottom of the list, things like treated and untreated human waste, urban fertilizer, are very, very small contributors. Now that's not true everywhere, and it depends whether you're talking about nitrogen or phosphorus, right, in which basin, which watershed. Just on the right, this is the study of the Great Lakes, and what you can see for Lake Erie is that agriculture is a big part of the story for total phosphorus. This is something that's well known and is playing a large part in public conversations about what can be done about eutrophication in Lake Erie, but maybe less so for nitrogen on the bottom, right? And again, that you can see that those contributions from different sectors vary a lot over space. So how do we think about that? Another big challenge is that the sources of nutrients are often far upstream of the ultimate location of damages. And that's not to say that the runoff of these nutrients into local waters doesn't create local damages. It does. But one of the bigger concerns one might have, especially when you think about federalism and the nature of the Clean Water Act and where it might have come from, this kind of concern about cross-border pollution problems and so on. This is on the left a picture of just the geographic extent of the dead zone in the Gulf of Mexico from summer 2021, and on the right is a map right from the U.S. Geological Survey showing the states that make the kind of primary contributions of nitrogen and phosphorus that contribute to that problem every summer, right? The sort of growing concern about hypoxia and dead zones impacts on commercial fisheries and other outcomes. So what you can see is that, right, the states that are immediately neighboring the Gulf of Mexico really are not big contributors, right? The big contributors are kind of in the upper Midwest. This is something that's widely understood from a scientific perspective. And again, it creates a real challenge for regulation. And then the fourth and final challenge is that, regulation as it's currently set up under the Clean Water Act really can't harvest the low-hanging fruit, right? The low-hanging fruit are these agricultural sources in many cases, right, that have not been adequately addressed. And so if we don't focus on those, then the effectiveness of regulation altogether is impaired. So if you have that kind of nitrogen mapping in your mind and you think about where the big flows are coming from, and we say, well, we're just really going to hammer on urban stormwater, right, or kind of urban fertilizer use, which is not uncommon in some of the TMDLs that Professor Brett was talking about a moment ago. What you understand is that that's a really tiny slice of problem in many places, right, where the kind of agricultural contribution is so large. So even if you entice farms into the system through water quality trading or other means, right, with a really tiny slice of the problem, actually engaging in the reductions is really very hard to affect the problem. So economists, again, this is something widely known for a long time. Economists at the USDA showed back in 2008 that among watersheds that are nitrogen impaired in the US, point sources contribute less than 10% of nitrogen load in 2/3 of those watersheds. Another thing that happens when we kind of can't access those low-hanging fruit in agriculture is that the costs are really quite excessive. So just to give you one example, you don't need to read anything on this graph except the scale of the vertical axis, right? So on the left, this is taken from a study of the potential for nutrient credit trading in the Chesapeake Bay watershed, which is governed by a TMDL that combines 92 different smaller TMDLs. And on the left, what you can see is the cost of several common agricultural best management practices, right? Changes in land management practices that could reduce the flow of nutrients and other pollutants into the bay. And on the right, what you see is a set of urban stormwater best management practices, which are in urban settings a similar way of reducing flows. And this is just for phosphorus for the Chesapeake Bay. And what you can see in the scale of the vertical axis on the left is that those agricultural best management practices are really cheap relative, right, to the scale of the vertical axis on the right side, where on a kind of pound per pound basis, the costs of controlling these pollutants in an urban setting are an order of magnitude or larger, than the cost in agricultural settings. So just to sum up, as a primary cause of impairment in U.S. rivers and streams, nutrient pollution causes really significant economic damages. The focus on already heavily regulated point sources is both costly and may be marginally effective in some places. The TMDL process does reveal the extent of agricultural contributions. So that is to say that there may be some benefit of going through this kind of holistic budgeting process of the TMDL and saying, right, we think this much of the contribution is coming from agriculture, this much from urban and other sectors, right, industrial sources and so on. But, right, how much does it reduce nutrient loading from crops and from livestock, right? This is similar to the question that Professor Brett posed earlier, but a little bit more narrow, a little more specific. And then finally, I would say, right, states do work on this as well. And in some of the even predominantly agricultural states, there's increasing attention to the local damages from nutrient pollution. And so many states have adopted, with encouragement from EPA, numeric nutrient criteria. So I think there are really interesting questions to talk about in the discussion about whether these state-based approaches can do any better. Because of that map, right, where we sort of can understand that for many of these the hypoxia problems, the sources are way upstream of the ultimate destination of those nutrients. Right, this sort of state-based approach is never going to solve, right, that problem. But right, there might be progress, right, based on kind of damages, local damages within state borders. So that's all I have for now.
Well, I want to thank all the panelists for some really thought-provoking presentations. I think they've all raised some very interesting questions about, can a 50-year-old statute confront the challenges that we're facing today with water quality, given changes in land use and practices? And so I'm sure there are going to be a lot of questions. I see some hands already. Let's start. There?
First of all, just thanks for the presentations. I learned something from each of them. That was great. So Annie, of the 1%, I realize there's a lot of heterogeneity within the states. I mean, I have sort of my hunch of which states you'd see more success with the TMDLs. I'm curious, have you had a chance to look at the data in which states seem to be be able to take the those water bodies off the list successfully?
Yeah, so I haven't done a full analysis of this yet, so I don't weigh too much into what I say, but it actually has been surprising. It hasn't been the usual suspects in the sense of what I would think. It reflected in where the TMDLs are being most effective, which suggests that it's maybe not something about how the program is being implemented as much as it's some characteristic of the water bodies in that state, or at least that's my initial thought on the matter. But that there's much more to do on that front, and I think that, some places there is, some of them are not surprising. I think the states where there are relatively positive progress, but there's many where you wouldn't necessarily expect it based on what their state reputation for environmental protection is. So I think there's more to unpack there than just a simple look at state EPA action.
So also a question for Annie. First off, I think it's really cool that you're doing this study. It's something like this I had thought about doing in the past, and then I thought about the data needs, and I got scared and I ran away. And I'm wondering if this may be too early, but I'm wondering if you were seeing differences for TMDLs for water bodies that are heavily influenced by point sources, where there's more of a mechanism for turning the TMDL into real controls.
Yeah, that's a great question. So I actually read your paper that was calling for something similar to this after I started the study, and it was a great confirmation that this was something useful to put out into the world. So thank you for that. And understandably, being scared off is I'm surprised I haven't been yet based on how it's been working with this data. But that isn't something I've actually factored for yet, but I think it would be a really interesting addition to the further, more in-depth look that's coming in the second piece of this study. So I agree that anecdotally, early on, there's been a difference between, it seems like, waters that are more remote versus ones that are in more urban or concentrated areas. So I would expect that point sources may be a part of that distinction, but that's certainly something that in the further, more specific parts of the study I'll look at.
Look at that technique. So first, thank you for great presentations, all three of you. I guess this question is mostly, or a two-part question, partly for Annie, partly for Sheila. So first on Annie, in looking at your data, have you had any sense about increased intensity of uses? In other words, TMD results can be static, yet still reflect effective use. And the only reason I asked that is I was involved in some early TMDL litigation in the Southeast, and that was what was going on. There was more intensive agricultural and urban growth, both. And so there was this, so basically there were redoubled efforts, but as far as showing improvement, not necessarily, but yet it was improving results because of redoubled effort. So that's just a question for you. And then the question for Sheila is, you had that one slide where you said something like you can't, or that the law doesn't allow. And I guess my sense is that when you look at the TMDL and water quality relationships in the Clean Water Act and a case called Michigan versus EPA, which basically creates a default rule allowing for cost-effective regulation, Supreme Court case called Homer, which allows for cost-effective cross-border pollution trading, and then the general federalism provisions within the Clean Water Act, that actually people within the TMDL process, states and sources, and also I should say the Chesapeake TMDL itself, which is approved by the Court of Appeals, there is this ability to effectively for states and or sources to go upstream and find cost-effective trading strategies that would achieve results. And so I guess I wasn't sure if you were saying you can't or it doesn't directly mandate it, but I think there's I'd be very surprised if any court would these days find that to be a prohibited strategy to achieve results?
Yeah, so I'll answer quickly and then let Sheila jump into that second part. So this very question is, I think it's true nationally. It's where we see great increase in use that causes increased pollution. So looking at whether TMDLs are effective over time, you can't just be looking at whether the water quality in those bodies is improving over time, which is why I'm really interested in this idea of essentially comparing water bodies where TMDLs are in place and where they're not. And if you can get ones that are geographically similar, there can be some and I'm working with some colleagues who are more statistically savvy than I am, and water quality savvy as well on this piece of it. But because there are so many waters that are impaired but don't have TMDLs in place, there's actually a number of examples where you can see impaired waters versus impaired waters that have TMDLs and see if there are significant changes. So that's the way I'm trying to address that question, but I think it is a big one.
Yeah, thank you so much for the question. So the first thing I would say is that, yes, it's true that in the Chesapeake Bay, TMDL, and others, you see, right, these water quality trading programs where even though there's no cap, if you think about it in kind of policy instrument choice terms, right, on the agricultural sources, the realization that that's where the low-hanging fruit is encourages, right, policymakers to design the TMDL approach so that, you know, if I've got, you know, caps on urban stormwater and on industrial point sources and on municipal, you know, waste treatment and so on, wastewater treatment, then, you know, that you can set up systems where, right, those, you know, the kind of regulated entities can sort of purchase, right, agricultural BMPs, you know, upstream and so on. I think the biggest challenge to that, though, is that where you have you know, a large majority, right, of phosphorus and nitrogen coming from agricultural sources, if the cap is only, right, the kind of official regulation is only covering, you know, let's just pick a number, 10%, right, sort of 10% that's coming from urban stormwater and municipal wastewater treatment and other point sources, where, you know, you can have an PDES, you know, the tool, right, they can only go down to zero, right? If you go down to zero, you're still not solving the problem, right? So even if they're purchasing, right, their kind of required reductions from others, right, leaving all that, right, that fruit on the tree is not going to solve the problem. So there may be places, right, where that water quality treating can reduce the costs of, you know, and that was the point of that study by George von Hoppen and his colleagues that I showed those estimates from, where you can, you know, take a significant chunk out of the problem, you know, just by engaging, right, in water quality treating. But with where those sources that are, you know, kind of under NVDS permitting only contribute a small part of the problem, right? It's just it's going to be very minimal, right? What you can actually achieve. And then the last thing I would say is that, you know, I think Professor Brett's study about TMDL effectiveness, it kind of couldn't be more important, right? If this is the way, right, to sort of you know, reduce impairment and move forward, I think understanding how effective it's been is really critical. What I would point out, though, is that there are important, you know, reasons why you might see that really small sliver, you know, that 1%, one of which, right, and both of these have to do with what I call endogeneity, right, or concerns about kind of underlying heterogeneity and confounders. The first is that, you know, it could be very, very small because maybe places where, right, you know, you anticipate future increases in pollution are also likely to be listed, right, and also likely to have a TMDL put in place. And so what you're seeing is, you know, you've got this increase, right, the TMDL is put in place, maybe it continues to increase, but maybe increases at a less steep rate. So I would be kind of holistic in thinking about what those impacts are, right, and how you might control for these kind of confounding factors. You could also tell the opposite story. Maybe the sliver is too small because, you know, places where, you know, you mentioned kind of places that aren't super dense, right, and places where there's not a lot of competing development, are places where you might see improvement. Well, it could also be that it's politically feasible to kind of complete and implement, right, and enforce the TMDL where the costs are fairly low, right, and where we don't see, right, that, you know, kind of that future trend of increasing pollution as much, right, there's just not as much compete. So there, maybe the 1% is even too small, right, because you'd be attributing these pollution reductions to the TMDL, but really it's, you know, simply because of the nature of the place. So you hinted at that, Professor Brett, when you talked about, you know, thinking, well, maybe this is something about the nature of the places, you know, more so than the TMDL itself. And I think that's a really important hint, right, that you're kind of gut feel that you have. And statistically, I would say that's definitely something that one would want to worry about. But I think it's a super important study, and would love to talk more about how you can handle some of those challenges.
My question is also for Professor Brett, but I first want to give a shout out to Professor Craig about those awesome graphics with the webs. That was fantastic. The question I have is more the word water quality, and I'm not trying to be a textualizer, which is a word I learned today, but it's an elusive definition, and I wonder how it is defined and whether, how is it being measured? What does an improved water quality mean? I mean, because it's just such a broad term in many ways, can be subject to interpretation, and that's something we struggle with sometimes too. So.
Yeah, that's a great question. It's obviously one that the states also struggle with in determining what their ideal uses and water quality standards are for these water bodies. So I've really been looking at letting the states essentially determine what the water quality goals are for each of these water bodies and then measuring based on those state determined goals, right? So each state has its definitions of what designated uses are and what water quality standards are for those, and EPA obviously provides guidance on all of that. But yeah, I've been really deferring to the states to answer that specific question because it is a loaded one, and certainly many different legal interpretations of what that could mean. But I've been very much basing my analysis on those water quality standards that states are using.
So I'd like to step in for a second and step back and ask all the panelists a question, because I think what we're sort of skirting around here is a similar question I think about a lot with the Clean Air Act, which is we have a very old statute. We have some very new problems. Non-point source pollution is newer than point source pollution. Climate change is newer than NOx and SOx regulation. And when you think about, is the Clean Air Act, is the Clean Water Act up to the task of solving the problems that we're facing today? And if you don't think it is, should we be looking at other approaches? And because we have an economist here who can address it, should we really be focusing also on using markets more than we maybe have talked about? And or do you think the regulations are going to serve us well? So I'm gonna.
Well, I'll jump in. Some of these are not new problems. Non-point source pollution in particular, Congress knew exactly that it existed at the time it wrote the Clean Water Act, and it wrote the Clean Water Act in a way to leave most of that to the states. On the recognition that a lot of non-point source pollution involves land use decisions and regulating actual use of land, among other things. So, like I said, that was a conscious political decision, conscious, what we want Congress to be doing, deciding what to go after first and what to leave to later or to other regulatory bodies. I think the real question is, 50 years down the line, when we've plucked the other low-hanging fruit that the point sources gave us, and we're dealing with interlinks between the statutes. So I deal a lot with ocean acidification. You can't deal with ocean acidification through the Clean Water Act. The sources are wrong. You just can't get there. And so, do we need to rethink those initial decisions 50 years ago for new realities? Like, okay, we took care of the first cut. Now, do we think about, and nutrient pollution often comes from air sources as well, so do we need that link? Do we need to think about, well, we definitely need to think about how climate change fits into all of this, but like I said, it's more of a, we need to reboot, and we haven't had a real rethink from the ground up of these statutes in a long time.
I don't know if Sheila wants to jump in on the market mechanism side. I don't have too much to say about that as not the economist here, but I agree with what Robin has to say. I think certainly on the non-point source pollution side, the Clean Water Act has not been up to the task, and that's a recognition. But maybe, as Professor Olmsted did point out, there is value in going through the process of certainly monitoring these waters and then doing in-depth analyses of where nutrient loading is coming from. That provides a solid foundation for something to happen. It's just not happening yet. So there are ways in which I think there are important pieces of what we're doing now, even though it's not ultimately maybe leading to the change that we want to see on the ground. There are pieces that are very important foundations of whatever might come next, which I'm not entirely sure what that should be.
Yeah, I would say I agree wholeheartedly with Professor Craig and Professor Brett on these points, and that a reboot would be really smart. I think I mentioned in a podcast earlier this year on the quota discussion, but you could sort of, like, the Congress could address a lot of these issues if it clarified its language with respect to waters of the United States, if it considered what the sources of pollution are, for important problems that people care about, and tried to match those a little bit better with what it's possible to regulate. And whether some of these linkages between the Clean Air Act and the Clean Water Act ought to be, kind of more explicitly stated. I think on the market side, I have a couple of comments. The first is that, and this is, I'm going to state this, but I don't necessarily think that it was a good thing, so I'll state it. That, I think one of the things that Professor Busby talked about in the earlier panel is that, the CWA is a kind of muscular, right, when you read the text of it, is a kind of muscular from a scientific perspective of kind of what it is that it's trying to achieve. But it's also pretty muscular from an economic perspective, right? It says we're going to go to zero emissions by 1986, right? Clearly that didn't happen, right? And that's not where we are. But when even the Clean Air Act, where we say, we shouldn't be considering costs when we set the NACs and those kinds of things, there are still kind of places in the Clean Air Act where you have a sense that that costs can matter for in certain deliberations. I feel like the Clean Water Act is less friendly, right, to kind of consideration of costs. Maybe that's that's just my kind of high level impression. And again, I'm not a lawyer, but it strikes me that the starting point, right, is pretty strong, right? The sort of statement that was made in the 70s is pretty strong, and the question is whether if you went through, by a process in the Congress today, whether you would get something equally strong, and I think the answer is no. So I think we would worry, and one question I would have, is, if we're concerned about these pollution problems, whether that would be a productive process or not, right, at this point in time. The other thing I would say is that the focus on using markets, I think EPA has tried to encourage this for years, maybe decades, right? This realization that, there are the kind of lower cost approaches and in some particular pollution problems, and, kind of continuing to ratchet up, standards for point sources is not a new one. The weaknesses, and obviously, right, as an economist, I think markets are great. They can do many things. I think there's a couple of challenges in the water context. The biggest one is this problem of, you still, right, if you're only capping the sources that are, explicitly regulated with NPDES permits, and they don't contribute anymore a lot of the pollution, right, in some places, you can't through markets, right, that's the amount you're going to get, right, is that small amount that's coming from those sources, even if they're paying, right, for reductions elsewhere. You're not going to be able to sort of charge them for pollution below their, right, their baseline of zero, right? There's just only so much you can do through markets at this point for some of these pollution problems. The other thing that I would note is where markets have been used and used well, the challenge of non-uniform mixing and the challenge of having to set up effective systems of trading ratios is just a more significant challenge than it's been in the air quality context. Talking about something like carbon, that's really easy, it doesn't matter, right, where it comes from. SO2, NOx, we could be worried more than we have been about those, and there are good studies suggesting that, right? There could be big improvements in kind of the welfare gains from trading if we worried about, the particular damages at individual locations. But in the water context, we really can't get away from that, and it is complicated. And when you look at these water quality trading systems that seem to be working well, they've addressed those questions, and those are kind of scientific, economic, and political questions, right, all kind of folded into one, and they have to be made at the time that the thing is set up, and then they have to be flexible in response to scientific information that comes across the bow later on. And that kind of iteration, considered scientific deliberative process is just not one, that happens that often in the context of pollution control, because, right, it is so charged and it has so much to do with these kind of land use constraints and other things that happen in the locations where these systems are implemented. So that's my thoughts.
Great, thank you. And one last comment? Sure. And on that complexity, water's just a different animal than air, and so I did a lot of work in the Pacific Northwest. There are a lot of streams and rivers in the Pacific Northwest that are on the impaired waters list. They're on the impaired waters list because the designated use is salmon, and until the big hydropower dams come out, they're never going to be in compliance with the Clean Water Act. And so when you're dealing with that kind of holistic picture of what's going on with the water body, again, what a single statute that was really thinking about industrial sources piping pollutants into the waters can do about it needs a redesign.
Okay, I think we had some.
I had a question for Robin. My question is for Robin. Robin, you were so disciplined with your time that I think you didn't have a chance to do what I want to ask you to do, which is to take your proposal about the questions you raised about distinguishing WOTUS between Section 402 and 404 and react to the first panel, especially maybe the study that Brother Adler gave us about vocabulary. And I just wonder how what we heard in that first panel impacts or changes your thinking, if it does at all, about your proposal.
It actually confirmed a lot of what I was thinking, which particularly the acontextual approaches to waters of the United States. And one thing the debates over the 2015 and the 2020 rules brought out was you were hearing, I'm going to pick on the Farm Bureau because a lot of the arguments came from the Farm Bureau, but you were hearing arguments that this one definition of waters of the United States, which is one part of a 5-element test for Clean Water Act jurisdiction, was suddenly going to subject huge areas of land to regulation. And I thought it was particularly ironic coming from farmers because it's like, yes, but you're never going to be a point source and you're never going to be this, that, and the other thing. And, your return flows are specifically exempted somewhere else in the Act. And then you got all the 404 exemptions. And it was that decontextualization of what that definition was doing that drove a lot of the controversy that was largely unnecessary. And so when I started this project thinking it was going to be mostly an administrative law project riffing off of County of Maui, I was thinking in terms of, hey, stop defining waters of the United States in isolation, back it up and think more in terms of when does Clean Water Act jurisdiction exist. And particularly with Maui County, that gives you a lot of room to think less about what exactly the water of the United States is and more about what a discharge of a pollutant as a whole is. And that also, I think, leaves a lot of room in context to think about the real differently resonant legal webs that those two permit programs operate in, and to think more holistically about, like I said, what a discharge of a pollutant is rather than whether a puddle should be a water of the United States or not. So.
Thanks. Thanks so much for the presentations today. They were great. And I had two questions for Sheila. Sheila, I don't know if you can see me. This is Dave Kaiser. Had two questions for you. One, I was curious about, I really enjoyed your paper on Tampa Bay and nutrients, and I was curious about what your thoughts are for how the large benefits you estimate there compared to the costs help inform our understanding of benefit-cost ratios in other water quality policies and programs, and if we can think a little bit more about that. And then second, I don't want to bore people about questions about economic methodologies, but I was curious about your comment on hedonics, and was curious if you could talk, and we can talk offline too, but I was curious about your thoughts on the appropriateness of hedonics as they relate to measuring the benefits of water quality. And it made me think a little bit about Nick Kumanoff's work comparing the benefits of the Clean Air Act using hedonics as well as value statistical lives and dose response functions, and he finds very different benefits with hedonics versus using the value statistical life, but it still seemed like there was a role for hedonics to play in air quality, so I was curious about your thoughts on those two questions. Thanks.
Yeah, thanks so much. So I'll be really quick. So the first, hi Dave, first of all. The second, in in Tampa, so what we did was really kind of pilot this new approach where we try to, understand where people recreate and then incorporate that into the property value impacts of water pollution. And we got these very big numbers relative to not worrying about that. And, on the one hand, right, Tampa is like the kind of aquatic economy there is huge, right? So we're talking about second biggest coast, city on the Gulf Coast. Houston is the next one, but Houston's not really right on the coast, right? So you have lots of coastal property, super active housing market, tons of recreational fishing, right? So, I would hesitate to say, right, that the result there, generalized elsewhere. But if you look, right, at the location of all those kind of hypoxic areas on the U.S. coast, it's pretty ubiquitous. And a lot, as you pointed out in your own work, a lot of the U.S. population lives close to coasts and rivers, right? So, on these important, kind of waterways. So, my view is that we should think about this, right? We kind of need to get it right because it could be the scale of that difference, right, for accounting for these recreational behaviors could be really large. And then to answer your second question, it's funny, I think, if we think about the context of damages that are estimated from pollution in the air context, the absolute lion's share is health damages, right? So, if you look at, the PM 2.5 NAC standard or something like that's 95% or more, right, of the damages, from PM 2.5 that economists estimated are about premature mortality, morbidity, and so on. And in the, I think I would expect to see, property value studies, and like in theory, those could be picking up health impacts to the extent that people understand them, right, and really understand kind of what that exposure means. But, you might ask questions about that. Do they really, right? And, so the property value, maybe those are, picking, up more things like visibility and, kind of amenity values and so on and so forth. Whereas in the water quality context, in a place like the US where our water quality on the whole is good, taking aside, right, all of the impaired water statistics that Professor Brett was showing and so on, those are important numbers. But if you, think about the lion's share of damages from water pollution in the US context are probably not those health effects. And there, I think, like, the hedonic approach is a good one, right? So, like, a lot of what people care about, with respect to, to water quality is recreational opportunities, what the water looks like and smells like, how they experience, kind of the environment when they walk out of their house and so on. Again, that is not to say that there aren't important health effects. If you're talking about drinking water, that's a whole other story, right, with lead and those kinds of pollutants. So I actually think it's pretty appropriate in the water quality context, and we could capture a large share of the damages from pollution using those methods if we get them right.
Thank you. I have a question for Shayla, which is gonna, I think, be a slight follow-up to David's question on economic methodologies. And I am wondering, within the context that the Biden administration has directed the OMB to, in one way or form, suggest or recommend ways for the economic methodologies to account for distribution and distributive concerns, can the hedonic property model has enough wiggle room to maybe account for some distributive issues, or maybe it already does it? For instance, like based on location of property and disproportionate exposure and the relationship of both?
That's a great question. What I would say is it can. I don't think that we've used it very well to do that, right? To look at those kinds of questions. Certainly in my own work, I haven't. But you can look at, right, once you understand what the impacts are on property values, you can look at that by neighborhood, right, by, SES by neighborhood, by race by neighborhood, and so on and so forth. So it can be used for that purpose. I mean, I think one of the challenges is that if we look at property values, and this comes up in contexts like, flood buyouts and, kind of floodplain buyouts and, all kinds of other environmental contexts, which is that, my house in Austin, right, is located in a neighborhood that has very high property values and didn't when I got here, but it does now. And so, if I'm looking at property value impacts and I'm looking sort of in absolute terms, right, property value impacts of water pollution in places where property values are high and water pollution is low, right, you could get these significant impacts relative to neighborhoods where, property values are low from a starting point, and maybe get a smaller absolute number. So if you're using you could miss, the picture of, hey, this neighborhood has been, really strongly impacted on a percentage basis, right? Of sort of thinking about a share of the value of the property. And we don't really see hedonic studies that do that kind of work. And I think it's a great point because we could do a much better job at that.
Thanks. And I just want to say this panel is like a feast. I mean, there's like so many things I want to talk about that I can, but I just super, super appreciate it. I think the conversation about hedonic modeling, I think, is very important. There was an analysis done of the impact, the economic benefits of the Great Lakes Restoration Initiative here in this region. And what we hit hard was the only, quote unquote, acceptable analysis was a hedonic analysis. And the challenge with that is the only values that count are the people who own real estate. The economic impacts to others are never accounted for. And so, one of the things I've seen in the economic analysis for setting human health criteria in water quality standards is looking at health impacts for people who have disproportionate exposures. And I think that's something we really need to continue to push ourselves, is how do we account for the impacts that are not affected by real estate? Because so many times we are baking into the system these impacts that never get addressed. So I think it's a great conversation and really appreciate it. And the other thing I can't help offering in the TMDL context is, as you look at those, how many of them were driven by litigation by environmental organizations? Because many, and I'm saying this in my context as a funder, right? Getting a TMDL is a pelt on the wall. The impact of that TMDL is much less significant. And so it's another thing to look, I'm really curious about, is when does a TMDL, is it driven by a water quality concern that's locally driven, and when is it a pelt on the wall for a funded advocate? So sometimes there's overlap, but sometimes there's less, so thanks.
So I guess this is mainly a question and comment, I guess, for Robin, but I've waded through, I think, all the major briefs so far filed in the Sackett case, and I guess, and there's one, in your slide, you indicated, I think the way you highlighted it, it was significant that it was across the road or something, I can't remember the exact phrase, and just, I think one big target of the people pushing the Sackett case is to throw out a long-standing aspect on the Clean Water Act, which is human-built impoundments, blockages, roads, drains. None of them change something from being a water. And that's been in the regs since at least '86, and I think it might have been earlier. And so that's a big part in the brief, because the Sacketts and others keep emphasizing that, saying, and there's a road. Well, that has for about 50 years been completely irrelevant. If it's a water and people build a road, they build a tunnel, and the same thing is true for piping, which came up in the Rapanos case, and Solicitor General Clement said to Scalia, the fact that waters are piped cannot destroy jurisdiction because every city has rivers piped at some point, so that can't be, and Scalia flung himself back in a very frustrated look. But so I guess I just would be careful about, I don't know where you go with that, but I don't think that should matter unless you're going to say that long-standing legal irrelevance of because otherwise it's like Maui. Otherwise, you just build a barrier, you sever the connection, no more jurisdiction. And I don't think that should be so. I think that shouldn't matter.
I agree that it shouldn't. My point was rather the Ninth Circuit had a rather lengthy and somewhat convoluted explanation of why there was a significant nexus. Particularly when you compare it to the district court that just said, yeah, it's directly connected by subsurface flow, we're done. And I guess I would frame it more of, not that I disagree with you, and I hope we don't get rid of the barrier, but facing this court, how many of these fights do you want to be fighting at the same time? In terms of what counts and what doesn't, and maybe they end up having to fight all of them, and hopefully that long-standing interpretation will stand. But I think a lot of people would count it as a win if you just got the court to say there's a subsurface water connection and that's good enough. as opposed to what they might say on every step of that analysis. So, like I said, the point wasn't that I don't disagree with you. I do agree with you that has been the rule and should remain the rule. But in the context of litigation before this court on a question focusing on wetlands, what battles are not predictably the way they've always been, and I think that might be one of them. So I hope not, but I can count to 5, so
All right, I think that we are prepared to.
Awesome.
Oh, do you have a question?
We got a couple more minutes. I'm gonna ask a question. So I have an answer to this question, I think, but I'm curious what any of the panelists would say to this hypothetical. We look at the various federal environmental laws, and I think there's a fairly broad consensus that, at least as measured through cost effectiveness and cost benefit studies, the Clean Air Act is at the top of the list. Multiple Clean Air Act regulations are identified as the most cost beneficial federal environmental interventions in the nation's history. There's some recent work, David's done some, other folks have done some, suggesting that at least based on what we've done and what we've been able to measure, we're not so sure about the Clean Water Act in terms of its cost effectiveness or how cost beneficial some of the interventions have been. And certainly that may be a limitation, as has been discussed, with what we can measure. But I'm curious what the panelists how they would respond to someone who just looks at some of that research and says, maybe the Clean Water Act should look more like the Clean Air Act, and maybe the way we try and enlist state and local governments and the way we try and deal with high numbers of dispersed sources that overall contribute to quality levels that we are concerned about, maybe that figuring out how to make the Clean Water Act look more like the Clean Air Act would be a way to make it be more effective at achieving its goals. And I'd be curious what any of the panelists, how they would respond to that suggestion.
Okay, I'll take a first crack. I'll go back to my point. Air is more similar place to place than water is. And so if you were going to do a strict analogy and set ambient water quality standards for the entire country, that means the pristine mountain stream in Idaho and the Mississippi River have to have the same water quality, and they never did. They never will. They can't in their most natural condition. So I think that's just a reality of the two media, that you can't think about water the same way you think about air. And pollutants don't travel as ubiquitously through water. I mean, water goes certain places as it does through air. So I don't think you could do it rationally. But I also think when you're thinking about the costs of the benefits of the Clean Water Act in economic terms, it suffers from the fact that we also have a Safe Drinking Water Act, and the linking of those two, and I'm going to pull on the recent Iowa cases where it's the water quality treatment plants that are suing mostly agriculture pollution because of the increased cost of water treatment. If you don't get that link in the mix of doing the economic benefit analysis of the Clean Water Act, that you are actually saving money in drinking water treatment if the water's cleaner going in to begin with, you miss a lot of what the Clean Water Act is doing. And we also forget that it took a lot of raw, untreated sewage out of our waters as well, and that's really, it's difficult to quantify, but it is a huge economic and health benefit both. So I personally think that's what's been missing in a lot of the economic analyses of the Clean Water Act, is it does, done right, pre-treat our drinking water, but all the benefits of drinking water tend to be put on the Safe Drinking Water Act, and oh, look, it's doing this great thing of improving our health. And it's like, well, yeah, but some of that is because it was cleaner water going in. So, my waxing poetic.
I'm happy to take a crack too, but Professor Brett, did you want to go first?
I'll let you go ahead.
Okay, so just I think this is a great question. I think it's an important one. I would give you 3 reasons to kind of maybe withhold judgment about whether you know, on the whole, this is a true statement or not, right? That, you know, the water quality regulations, ambient water quality regulations tend to have you know, lower benefit cost ratios than air quality regulations do. The first is that I agree 100% with Professor Craig's statement. I would also just add that it's likely that a lot of the you know, kind of mitigation measures one might put into place to reduce some of those drinking water impacts, like in the Outlet case, are a heck of a lot cheaper to do in ambient, right, to sort of prevent that from going into ambient water, you know, water than it is once you get to the drinking water treatment stage. So, right, even thinking of more creative ways of sort of linking the 2 acts, right, in a sort of cost-benefit framework would be smart. 2, I do think we have a kind of mismeasurement challenge, and that economists just haven't focused on water pollution for very long. I mean, there's some old contributions in the 70s and the 80s, and then there's a long period where there's this very heavy focus on air pollution. And so Dave's work and others, right, kind of really trying to hammer on understanding this is so important, because we don't have a great understanding, I think, of what those the damages are, conversely what the benefits of control are. And the third is that, you know, given the left out sectors here, right, primarily agriculture, but others, atmospheric deposition, as Professor Craig pointed out, you know, a lot of those reductions that have been achieved are excessively costly, right, because we've only targeted on the, you know, on sort of reductions that are quite costly. So it's a little unfair to sort of put that on water pollution itself, right, and say, oh, look, it's really costly to reduce water pollution relative to the benefits. Well, that's because of a set of choices that we've made and continue to make, right, about what sources what we require to control. And so it's not about, right, something inherent in water pollution itself in comparison to air pollution. So fix those problems and then we can talk. So then one last quick point, because I don't think we fully addressed the question about environmental justice that came up, and I think it's important. I would say that the point about economic analysis, only looking at improvements for property owners, 100% agree with that. We have lots of valuation tools in economics, and many problems require the use of more than one, and water pollution is put in that boat. It's super important, and maybe even a little worse than what you stated, because as property values go up, that's really good for property owners. It's not so good for renters, right? So there's a lot of, you know, focus on environmental gentrification and what the costs are for disproportionately exposed communities. So that's a great important point, and that's it.
Nothing to add? Okay.
Those are great responses.
All right, well, I want to give a big round of applause for this. Can you tell us where we're going from?
Lunch should be out in the hall. We are on break for lunch until 1:15.
It basically says housing prices.
You know, sort of
you can film it all at once and then just like space it out. You know, so like if I could get down with maybe a day or something, and be like, here it is. You know, it's like my goal is until
That's awesome.
and I've been vocal about this.
Till 9, we're not ready.
That's true. Yes. Yeah.
So yeah, I would know what you know.
Yeah, was doing farming, and then like proposed to the like National Science Foundation, like they're going to do this commission that's like the limits of comedy and children's comedy and science, and it's yeah. So I mean, I was thinking about like we could do things
Grass might be a good personality. Grass, Kentucky bluegrass like this.
Or, I mean, we could even have, you know, Chris Linnell, project manager of Hewitt and Orleans.
Oh, first one. Another. Oh, I'm sorry.
Both of them were, and usually they're. Obviously, they lived through it, and they also described things that weren't, so working or whatever. So you can see it down there. It's right here. Stop. RPM stops. Because Andrew said this giant, and I have the question. I mean, this is T1. Yeah, so he said lake, and he said actually you're really worried about that. It's
speculating for me now.
Anyway, I should kind of serpentine heavy stuff plus the wind hitting it. So we
Sure, yeah, that's
so many times I say they deserve to use this case.
So I go our readings in 10. I'll make it, I bet.
Yeah, one of the teaching jobs.
Alrighty, welcome back. We're set for panel 3, and so I'm going to turn the podium over to another alum, Andre Monette, who is now a water resources attorney in Washington, D.C. at Best and Krieger, and a 2006 graduate. And Andre, the dais is yours.
Excellent. Thank you very much. I just want to say thank you to Professor Adler for having me. I'm just moderating, but still an honor to be here. And I want to comment on how amazing the conversation has been this morning so far. I'm learning so much, and just it's a great sharing of ideas here. So really spectacular so far. So with me today, we have Professor Bonnie Keeler. She's the Associate Professor and Co-Director of the Center for Science, Technology, and Environmental Policy at the University of Minnesota's Humphrey School of Public Affairs. We have Professor David Kaiser. He's a professor in the Department of Resource Economics at the University of Massachusetts Amherst. We have Professor J.B. Rule. He's the David Daniels Allen Distinguished Chair of Law at Vanderbilt University School of Law. And he also serves as the director of the program on law, innovation, and the co-director of the Energy, Environment, and Land Use program. And certainly not least, we have Professor James Saltzman. He is the Donald Bren Distinguished Professor of Environmental Law at UCLA School of Law and at the Bren School of Environmental Science and Management at UC Santa Barbara. And of course, I want to reiterate the comments from this morning that the biographies are available in the materials online, and there's much more, obviously, that I couldn't mention here. So please take a look, and you'll see the credentials we have. So with that, I'll hand it over to the panel. I think we're starting with Professor Kaiser. No, sorry, excuse me.
Great, thanks.
So good afternoon, thanks, it's lovely to be here. I was telling Elizabeth over lunch that it's been a long time since I've sat in a room with really smart people listening intently to things that I care a lot about. So thanks for that experience. So I teach at a policy school, and I'm really motivated by a very pragmatic desire to inform water policy, to assess trade-offs, to ensure that we're making a good return on investment, that we're using the resources that we have available to achieve multiple objectives. And so my focus here is to do a bit of a retrospective and look back at how we've done that in the past with respect to clean water policies. How have we evaluated if these are good investments? What kinds of methods have dominated that assessment? And what values have we assessed? And what values have we not assessed in that? So I'm going to be focusing on economic analyses that we use to determine regulatory review. So for these kinds of major federal rules or regulations, what do we know about the costs and benefits? And I'm going to start by drawing on the work of Dave, and Sheila and others mentioned this. This is a paper that was talked about earlier where Dave really nicely summarizes how we spend a lot of money on water quality. We spend a lot of money on water quality policies. And his analysis has revealed that we're not always able to demonstrate using our traditional economic tools that those investments have yielded a positive return on investment. Not just in the US, but economists evaluating the EU's Water Framework Directive similarly did not find a positive benefit to cost ratio. So I think many people find this surprising, and I give a lot of credit to Dave and his team for raising awareness of this issue. It also presents a really important sort of dilemma, I think, for those of us who care and believe in the kinds of water policies that we're talking about today. So, of course, we are not done with our water quality challenges, and this uncertainty in benefit cost analysis comes at a time when we're debating many different kinds of implications for water quality at the local, state, and federal level. And as others have mentioned, there will continue to be a need for regulatory review of the Clean Water Act, as well as all the programs ranging from the Farm Bill to infrastructure expenditures, and of course all of the ongoing Supreme Court battles about the extent of the Clean Water Act. At the same time, we also face ongoing threats to water quality. So we no longer have rivers that catch on fire here in Cleveland, but we have many second-order water quality problems, including new contaminants. People have mentioned PFAS, microplastics, pharmaceuticals, agricultural contaminants. These are expensive to remove, they're expensive to prevent, and the benefits of further investments in improving and addressing these water quality impairments are often quite uncertain. So that raises the question, do we have a toolkit, a policy analysis and economic analysis toolkit that's fit to purpose for what we see coming at us in the future? And I'm actually approaching this from a very personal level in that I have the ability as an academic to decide what kind of things I want to work on, and I want to do work on the methods that matter the most, that are going to really elevate what are good, strategic, important clean water policies. So to that end, I'm motivated by these research questions. What have we learned about the value of clean water based on our existing tools of policy analysis? What values have we captured? What values are underrepresented? And what gaps need to be addressed for next generation water valuation. So this comes against the backdrop of what people have mentioned of a couple of memos and guidance from the Biden administration. The first day of office, this Modernizing Regulatory Review memo, which directs the OIRA to think about how they can fully quantify regulatory benefits that are difficult or impossible to quantify, and also account for distributional consequences of regulations, including qualitative and quantitative analyses, and looking at how regulatory initiatives appropriately benefit and do not inappropriately burden disadvantaged, vulnerable, or marginalized communities. And then shortly after, we've seen a lot of movement around the administration's commitment to the Justice 40 initiative, which is a whole-of-government approach dedicated to delivering at least 40% of the overall benefits of federal investments to disadvantaged communities. So these kinds of recommendations around equity and distribution have been in place in the past. It's not like this is a completely new requirement, but I think we all know that this sort of guidance has been not really well implemented in practice. So there's a clear case right now to pay a lot of attention to distribution and equity considerations. And I don't think this is just a fad. I think there's been a fundamental shift in our awareness of the role of race and class on environmental outcomes and the disproportionate delivery of benefits and burdens. And public is demanding this, policymakers are demanding it, my students are demanding it. I think we really have to speak to these issues, and that means applying methods of policy analysis that address these issues of equity. The other case that I want to make is that water is really special, and I think we'd all agree about that here in this room, but I think there's some particular aspects of water quality that mean that we can't use climate change policy or air pollution policy as a direct parallel. So first, water quality affects a diversity of values. So if you look at this slide, there's recreation, there's human health, there's property values, cultural values, waterfowl, a whole bunch of different ways in which water affects human well-being that are material and immaterial, their use, their non-use, their health, recreation. The second is that there's a diversity of endpoints. We've talked about that also. Groundwater, surface water, lakes, rivers, streams, wetlands, coastal areas. Third, there's a diversity of constituents, nutrients, phosphorus, Pfas, chemicals, etc. And there's a diversity of beneficiaries. So we're looking at values that might accrue to tribal communities, values that accrue to lakeshore property owners, drinking water consumers, recreationists, people who fish and hunt, a whole set of different beneficiaries. People do not have strong emotional connections with carbon, but they have incredibly strong emotional connections to water. And so I think we have to really take that into consideration when we think about water policy. Okay, so I'm not going to talk about hedonics and travel costs much because Sheila talked about it, but for the non-economists, there are a couple. I'm just going to review some of the main ways that we've been able to collect evidence on the value of clean water policies. So travel cost methods really look at people's behavior of where they recreate. So this is, I think, one of the best examples of this was done, and Dave was involved in this group as well at Iowa State, looking at surveys of recreationists. So they'd ask, how many lakes have you recreated in? Where did you go? How far did you travel? From people's travel behavior, it reveals the preferences they have for clean water. So people tend to travel further to go to clean lakes. They visit those lakes more often. And from that, we can infer that they value the value of water quality in their recreational behavior. And then similarly, in hedonic markets, we're looking at the impacts on property values of improved water quality. So those are some of the lines of evidence that we have to understand the value of clean water. The other big bucket are stated preference surveys. So these essentially ask people, one way or another, what are you willing to pay for clean water? So a couple of examples, we had a survey in Minnesota that's been broadly applied that asked, what would you be willing to pay for a 40% reduction in phosphorus loading to the Minnesota River? I'd be willing to pay $140 a year for my household to have that reduction. Some of the studies that have been really critical in evaluating the Clean Water Act and the latest economic analyses include studies that ask people about the value of wetland protection, because that's been a critical area. So you would show someone a photograph of a wetland type, in this case in Kentucky, and you would say, would you voluntarily contribute to a wetland protection fund that would preserve this wetland area? And the assumption is if it wasn't protected, it would be mined. So these are, I guess the other method I'll mention is that people use choice experiments. So they look at, here's some photos of a blue lake and a green lake and a blue-green lake. And you might ask people, okay, you're on a weekend trip and you have to figure out which lake to go to. Which lake are you going to go to? One is much further away than the other one. One has a smell and odor problem, the other one has a boat launch next to it, right? And so you say, okay, under those conditions, I would go to this lake, I would go to that lake, okay? From those statements, we can infer how much value people place on water quality. So there's some assumptions in this analysis. First is the assumption that values for clean water can be expressed through these kinds of consumer choice models. That we observe preferences at the level of the individual, at the margin. So we're asking people, would you be willing to pay this much more? If water's cleaner, how would your behavior change? So it's really sort of trying to simulate, to the extent, a market like we would if you're going to the grocery store and saying, would you pay more for free-trade coffee than for your regular coffee? We assume then that people are rational, right? That they have full information, and that they have well-formed preferences. And this relates to the overall theory that this fits into, which is about a definition of efficiency that asks us to maximize net social welfare. And in that definition, we assume those who gain could compensate the losers and still be better off. That's the Calder-Higgs criterion. So we're really trying to make the pie well-being as big as possible, and then not worrying so much about the distribution of that pie. And that would be the definition of efficiency that economists would typically use. So if we think about those assumptions as almost like a funnel of that big, complicated mess of water values, then there's some implications of that, right? So not all benefits are going to be valued. The preferences of the rich are going to receive more weight than the preferences of the poor. Historical and social contexts are not directly considered because we're often looking at a baseline and just the sort of marginal change. And also we're obviously missing other policy criteria like equity or fairness or feasibility. Okay, so quickly, I spent some time just reviewing some of the regulatory impact analyses and economic analyses that under the Clean Water Act. Here's just 3, and the highlighted are all things that say no benefits. No benefits. We could not figure out what the benefits were. All right, so this says missing, we can't figure it out, we don't know how to measure it, we couldn't quantify it, we couldn't analyze the benefits. So regardless of the administration, regardless of the year, there's just lots and lots of missing benefits when you look under the hood of these Clean Water Act economic analyses. I won't go into the details on this because that was actually really lovely and well articulated in the previous panel, but if you think about the stuff that economists can monetize, that's a lot of it comes to recreation and travel costs. There's big barriers to entry for those markets. You need to have a car and a boat if you're going to be a water recreationist. If you're going to value property values, you need to be a homeowner. This is a picture of an estate on Lake of the Isles in Minneapolis that's worth over $4 million. So if you were to use the hedonic analysis that says if you have a 0.1 meter increase in clarity that you would get a 1% increase in price, then we're talking about $40,000 worth of benefits for just that one household. I don't think that most of us would want to allocate the majority of our water quality dollars to improve property values of the highest value homes. Further, we know that wealth distribution and the majority of people's wealth is tied up in home ownership. In Minneapolis, like many other cities, because of decades of racially restrictive housing policies, we had huge disparities in home ownership. About 75% of white families in Minneapolis own their home, and about 25% of black families own their home. So there's clearly a bias here in terms of whose preferences are going to be expressed. And then finally, even with the stated preference approaches, if you're asking people for what their willingness to pay is a function of your ability to pay. So there's another case there where we're in a very unequal society as we have those consumer choice methods of eliciting value are going to bias the preferences of the rich over the preferences of the poor. Okay. I'll be really quick here. These are 2 law articles that I read in preparation for this panel that I found really interesting that basically make a case for the importance of historical context and how the Clean Water Act has been applied, in one case to tribal communities and then other into the Anacostia River as it compares to the Potomac in terms of what actually happened with the implementation of those policies. And pretty damning implications for inequitable application of the legal framework provided under the Clean Water Act. And of course, there are, as I mentioned, extremely deep cultural significance with water that we haven't fully talked about today. I come from, the Twin Cities, which is the ancestral and current homelands of the Dakota people. This is the confluence of the Minnesota and the Mississippi River. The origin story of the Dakota people is that they arose from this point in the river. They didn't come to Minnesota from elsewhere. And so you can imagine someone going in and being like, well, what are you willing to pay for your ancestral homelands? So we have big problems, I think, trying to apply some of these typical tools from economics to these places. Water is an incredibly sacred cultural value for a lot of communities. It's also the #1 value for environmental justice area groups. So this is a survey from the Midwest Environmental Justice Network that showed that water was the primary issue of concern for those groups. So if we listen to EJ groups, we have to focus on water. They're incredibly concerned about it. Okay, so here's the situation. We have a toolkit. We have this mandate from the federal government that we need to think about distributional benefits and benefits to disadvantaged communities. We need to move beyond efficiency. We know that different methods are going to reveal different values and therefore prioritize different types of decisions. We haven't done much, but need to do a lot more in thinking how we combine different disciplinary approaches to policy analysis to really understand the full breadth of impacts of environmental policies. And so here are some closing thoughts. One, we need to quantify more benefits. 2, we need to evaluate the impact of equity weights. We have, I think, more to do on that. I think we need to reflect on the value of technocracy versus democracy. So I just spent a week listening to the Society for Benefit Cost Analysis, which is very much came down to this debate about technocrats versus politicians and who should be deciding what we value and how to value things. I think if we've learned stuff from the environmental justice community, the focus needs to not just be on product, but on process. And I was intrigued by Elizabeth's comments on how EPA is embracing that. I think we need creative ways to deal with these really taboo trade-offs. This is something we have to think about with water that we don't necessarily have to think about in some other environmental contaminants. All methods are biased, some are useful. We should use all the ones at our disposal, but recognize that none of them are necessarily objective and some are less. Economists have not cornered the market on rigor, despite what they really like to believe. And therefore, we have to proceed with transparency and humility. Thanks.
Great. First of all, thank you so much for the opportunity to be here. It's a real honor to be a part of this group, so thank you. And it's also a real treat to be in the same session as Bonnie. And for the reason that I believe she already knows that, but she helped encourage and helped kind of energize and help motivate the research that I'm going to present today, which is joint with Tina and Darjay and Yang Ji. And just to provide a little bit of background for this, and Bonnie already went over a number of these things, so I'll try not to repeat myself here. But last year, Bonnie and I, as well as Sheila, who you heard from earlier, and a number of other individuals were engaged in a external review of the economic analyses that supported the Navigable Waters Protection Rule. And while we were doing that review, as Bonnie already pointed out, the Biden administration published this memo directing the Office of Management and Budget to think carefully through about modernizing the regulatory review process. And as Bonnie already mentioned, a key component of this memo was a real focus on thinking about the distributional consequences of regulations, and really ties in nicely with also EPA's big push on environmental justice issues. And so what we were interested in doing is trying to think a bit more broadly about also not just with WOTUS and water quality, but just more broadly, how can we think about modernizing regulatory review of the Clean Water Act, and also how can we think about actually starting to operationalize a new take on looking at the distributional consequences of water quality policy. And so a natural jumping off point for us was this paper that I recently, Bonnie mentioned this as well, but recently published with Joe Shapiro and Kathy Kling, where what we did was we looked through an analysis of the costs and benefits of major water quality policies and programs over the last several decades. And that really focused on the efficiency of these. So what are the benefits, the measured benefits and the measured costs of these policies. But what we missed out on and what we didn't consider were the potential distributional consequences of them. And one of the things that's kind of nice about starting with this list for us is that we looked at a number of effluent limitation guidelines and the analyses that were done for those, and EPA is required to also conduct an environmental justice analysis for those effluent limitation guidelines. So we started to dig in a little bit to see what they had to say. And this is a fairly new area for me, but one of the things that I thought was interesting is that for many of these effluent limitation guideline analyses, they kind of they took a very similar approach and kind of came to similar conclusions. So the Steam Electric Rule in 2015, what it states here is that EPA conducted two types of analyses. One analysis was to compare statistically how demographic characteristics of residents living near these facilities compared to national and state averages, and then two, for a limited subset of the benefits that they could measure, were there any kind of distributional considerations that EPA should be aware of. And what you see is similar tables to this, where this comes from this analysis, and it states that it shows the population living within a certain distance of a stream reach where one of these facilities was in, and the characteristics of the individuals that live within the close proximity to them. And what you see here is that within a close distance, the share of the population that is minority is actually below the United States average. But then when we look at the share of the population that's below the poverty level, it's above the United States average. And a similar table, I don't have it here in the slides, but a similar table was done for state averages as well. And what EPA ultimately concludes is that EPA determines that these final guidelines will not deny communities from the benefits of environmental improvements, basically because the individuals that are living in these areas are going to be at least somewhat similar to the national and state averages, or potentially that the benefits will accrue more to individuals that are communities of color, or communities that are living, say, below the poverty line. And you find this in similar kind of language and similar kind of analysis in some of these other effluent limitation guidelines analyses. This is from the Metal Products and Machinery, where they state again here they're comparing the socioeconomic characteristics of populations living in these counties, and they find that they're very similar to the state averages. And maybe we can save this for discussion at the end, but there's another type of analysis that's done here where this is for the meat and poultry products, and you see this in other similar kinds of analyses where they state they don't believe that this rulemaking will have a disproportionate effect on minority or low-income communities because the technology will be applied uniformly across the U.S. Now, to me, I'm not sure that's the criteria we want to think about using for analyzing environmental justice as it comes to water pollution, but this is the flavor, at least from my review of some of these analyses that were done, as to how EPA had been thinking about environmental justice as it relates to a certain part of the Clean Water Act. So what we wanted to do in this work was to think, well, how could we use some data and more broadly try to analyze to what extent our water pollution industry is correlated with things like race, poverty, and education. And this is the location of these facilities as well as the discharge of water pollution that's coming from these facilities. And do we see any correlation from this discharge with these same type of factors? And the reason why we're pursuing this is that although there's a very large environmental justice literature, to our, again, maybe limited understanding, we've seen that a lot of that is focused on air pollution and toxics, and the focus that has been on water has been focused on toxics. And again, I'm really happy if someone points out that we were wrong here, but we couldn't find a very large kind of comprehensive analysis to say what are, where are we most worried about environmental justice issues as it relates to water quality policies and programs. So we're also interested then in taking this data, trying to think about what are some key challenges to modernizing the regulatory review of the Clean Water Act. You could probably cross out the Clean Water Act and just say clean water policies more broadly. So the approach that we're going to take is we use data from about 100,000 outfalls across the United States on about 11 different industrial categories. We're going to combine that information on the location of the facility as well as the pollution that's coming out of the facility with information on race, poverty, and education from at census block group levels. This data is coming from 2 decennial censuses in 1990 and 2000, and then also information from the American Community Survey from the U.S. Census in 2013 and 2019. This is when we could get the information that we wanted on demographics. And then I will try not to bore you on some of the empirical approaches that we take, but essentially what we do is we construct what we call pseudo-Lorenz curves. Lorenz curves are oftentimes used to think about looking at income inequality. We borrow that approach a little bit to think about, can we see at least visually how water pollution is potentially correlated with these demographics. And then I won't spend a lot of time on it today, but hopefully it's coming later, but we also approach this with some different statistical techniques to see if there's correlation, again, between demographics and water pollution, not focusing, of course, on causality, but just focusing on correlation between these demographics and water pollution. So what we find is that water pollution is somewhat regressive for the population below the poverty threshold and below college education, or for communities that have a higher share of below college and above education. We find that it's somewhat, I'll say, progressive for population with higher share of non-white. And this is somewhat similar to the table that we just showed you for the steam electric rule. There is, though, some heterogeneity across industry, so as EPA starts to move forward and thinking about modernizing the regulatory review process for water, this might point out a couple of industries to perhaps start focusing on a little bit sooner than others. Now, what I'm going to show you is all about pollution. It has nothing to say currently about benefits or costs. And I do think that there will be some really potentially big hurdles, but also going forward trying to do this for benefits and costs. Okay, let's see here. So in terms of the data, what we have here is just really quickly, we split this up into 11 different industries. And the 4 biggest ones in terms of the presence of facilities include electric and gas, manufacturing, mining, and sanitation or sanitation services. And what we see is that these facilities across these major industries are located in about 3 to 10% of census block groups across the U.S. The share that is non-white tends to be below the national average. Again, something that we saw in that steam electric rule table. But where we see these industries tend to locate are in areas with a higher share of the population that does not have a college degree or higher. And it's also somewhat mixed, but also perhaps a little bit higher in areas with a higher share of the population that's below the poverty line. And then lastly, one of the things that we kind of encountered in doing this analysis, and something we knew a little bit going into beforehand as well, is that the data on water pollution, what's coming out of these facilities, we're a little bit worried about perhaps the quality of that data and the availability of that data. And what you see here is that for a measure of the water quality that we come up with, which is a kind of standard water quality index, the share of facilities that report the data that we can use is somewhat low compared to the total amount of facilities. So this is just to show you that we have pretty comprehensive coverage across the United States. These are the 4 primary industries. Okay, so I'll jump right into the results. I'll walk through this slide a little bit slower, because then I'll show you really quickly a bunch of other slides that look very similar to this. So these are these pseudo-Lorenz curves that I talked about before. On the x-axis, we're getting a normalized measure of the demographics that we're going to focus in on, and ranking a normalized ranking of census block groups based on certain demographics. And on the left, what you see is this is the share that is non-white. In the middle, this is the share below the poverty line. On the right, this is the share below college and above education. And on the y-axis, you could think of this as the normalized cumulative sum of the outcome that we're looking at here. So in this case, this is the count of facilities that fall within a certain industrial classification. For this one, this is manufacturing. And so what you have is a 45-degree, the green line is a 45-degree line. Anything to the upper left quadrant, you can think of this as somewhat progressive. Anything to the bottom right part of the green line, this is somewhat regressive. And so we're also plotting this for 1990, 2000, 2013, and 2019. One of the things to see is that those curves don't really move much over time. So this seems to be somewhat relatively stable over this time period. But again, we're seeing somewhat similar as what the summary statistics show and what the steam electric rule suggested. Again, that these facilities tend to be somewhat in locations that have a higher white share of the population that's white. They tend to be in areas with a higher share of the population that's below the poverty line, and really tend to locate in areas where the share of the population, there's a higher share of the population without a college or above degree. I know you can't see all of these pictures, and I apologize for the panelists up here because they really can't see it. But what this is trying to show you is this is across 11 different industries. And the main thing I want you to see is, are these curves up to the left of a 45-degree line? Are they below to the right? Or are they along that? And the key takeaway here is that this is the share on white, and across all of these 11 different industrial groups, we tend to see that this follows a similar pattern as the one that I've just talked about. When we look at this for the share below the poverty line, again, fairly similar kind of findings that we found before. So not a whole lot of heterogeneity across industries. Some industries a little bit better than other industries. And then we look for non-college, we're again seeing that this relationship tends to be, again, these industries tend to be located in these areas with, again, a higher share of the population that does not have a college degree. And this is just showing you electric and gas. So these, I showed you manufacturing, electric and gas follows a similar type of period, similar type of diagram, although a little bit more equally distributed in terms of non-share below the poverty line. This is mining. You see a little bit of a change, a bit more of a change over time for the mining category. Part of this, though, we were going to be a little hesitant to read too much into the 1990 line just because the data is a little bit more sparse. Unitary services. So, just for the sake of time, I know I'm running out of time. I'm gonna just go through this in 2 seconds for the water quality measures. By far, what they tend to show is that these are, you can think of these as these kind of icicle graphs, where the further down they are, the worse water pollution. I think one takeaway from this is that we have a lot less data in 1990 and 2000 as we do in 2013, 2019. They tend to support the same kind of picture that we get from the Lorenz curves, except for we're trying to figure out a puzzle as to why we get somewhat opposite results when we look at discharges for below the poverty line as we do for Lorenz curves, but again, we get a similar type of picture when we look at the share of the population below a college education. So I will just stop with, I know I'm out of time, I'll stop with this slide here, but again, just to reiterate, what we find here is somewhat regressive in terms of water pollution, industries, locations for population below the poverty threshold and below college education. The industries that we see really jumping out are that tend to not be as equally distributed across these demographics are mining, manufacturing, and wholesale trade, although these tend to be somewhat relatively stable over time. And I think that maybe I'll just leave it here as some questions for you all as well as the other panelists up here is that what do we do when we have missing data from EPA in terms of trying to think about doing these types of analyses? Some of the missing data might have to do with systematic missing data that's correlated with the demographics. So this type of analysis, if we want to use it for thinking about modernizing regulatory review, would be important to understanding what that missing data looks like and the pattern of that missing data before we draw too many hard conclusions off of this work. And then as we move forward to benefits, one of the things that I think is a really important but difficult thing to do in a space on water is to measure the benefits of water quality improvements. And so I think maybe a first step, if we want to try to operationalize modernizing regulatory review, is just to think about, well, where are these facilities located? What does the pollution look like? And then more likely than not, that may be correlated with benefits. There are certainly some caveats there, but as we move into measuring these benefits, can we do similar types of analyses to look for the distributional consequences of water quality policies? So thanks a lot. Really fun to be here, and I will pass it on.
All right, so we'll bring ours up. First, I just wanted to start by thanking Jonathan for inviting us. It's been a real delight to be among friends and colleagues. Again, what he didn't know is that this publication marks the 25th article or book that JD and I have written together. So it's a silver anniversary of sorts. So this is the photo that while we're all here, right? This is the signing of the Clean Water Act. But as Jonathan started off today's session showing us, there's more to here than meets the eye. So many of you may not know this. Nixon vetoed the Clean Water Act. And so even though he's smiling here, I think it's more of a grimace than it's amazing. It was passed, his veto was overridden, not unanimously, but I think close to it. I mean, it's hard to imagine that happening today. And so we're going to talk about 404, but not what is a wetland, but how do you try to conserve wetlands, because in a sense, when I teach the Clean Water Act, wetlands are kind of weird, right? 404 is kind of weird in the sense that you don't really think wetlands when you're thinking, discharge at effluent, the sort of Dickensian vision of pollution. So why do we care about wetlands in the Clean Water Act? Well, it's because of the ecosystem services that wetlands provide, right? In particular, water purification, but more generally, if you sort of think holistically, which is a word we thought about a lot today. It's sort of storing water, it's habitat, it's all these things that this slide shows very well. Now, it's interesting to note that the word wetland does not appear in the Clean Water Act, but it's equally interesting to note that the word bog, marsh, swamp doesn't appear in the Clean Water Act either. Wetlands really were not a focus when the Clean Water Act was passed. And in the paper that we provide with this, we're going to sort of go into more detail, but you really can think about the history of wetlands and wetland mitigation in three broad phases. So the first really is when the sort of in the lead up to the Clean Water Act in the first 5 years or so, where Section 404 wetlands really were thought of as part of the navigable waters part. So I was actually, Jonathan, sent out an email yesterday to the Environmental Profs listserv. I got an email immediately from Gus Speth, who is like this giant in the environmental law field, co-founder of NRDC, head of the Council on Environmental Quality, and he said, I litigated Callaway. So when he was a young lawyer at Natural Resource Defense Council, he was the one who actually brought this case, and I said, tell me what happened. And he said, basically, the court put out these rules saying they're only going to enforce 404 for dredging and filling of navigable waters that were really navigable. Right? They had a very narrow view. Gus and NRDC won that case, and basically they said, no, this is the whole water of the United States that we heard about earlier. By the time that you get to Riverside, Bayview, the notion, this very much goes into what Bob was talking about earlier, it's much of an ecological sense of what the waters are. And then mitigation takes over, which I'm going to talk about a bit more in detail, and then GD is going to take over the second half and talk more about the ecosystem services aspect of this. So what is 404 for those of you who are not Clean Water Act mavens? So basically it says that if you're going to dredge, dredging and filling navigable waters or filling navigable waters is prohibited unless you get a permit. The permit is under Section 404, that's why it's called a 404 permit. And there are a series of things you have to show in order to get one. I've always loved the fact that you have to say no statutory violations will occur. I always took that as a given. But anyway, Interestingly, it's primarily administered by the Corps of Engineers, right? Which is weird, right? Because the rest of EPA has a veto authority, and there's your typical ag lobby exemption for application. So we basically are in the late 1980s, and this is where the sort of wetlands mitigation banking story really starts. And it starts because of basically a campaign platform that George H.W. Bush announced. And he basically, this is a quote, it was a speech at Ducks Unlimited. And he basically said, whenever one thinks of the three keywords of the Bush administration, it's read my lips. But there was a second for environmentalists, which was no net loss. And so, what does no net loss mean for wetlands? And there are ways to avoid impacts, but the wetlands mitigation hierarchy that became important was mitigation banks. So what was happening was that the Corps was allowing destruction of dredging and filling of wetlands to take place so long as you mitigated right next to it by the permittee. It was in-kind, in-place mitigation. And the problem was it didn't work very well, and they were kind of postage stamp. And so a bunch of state highway departments who fill a lot of wetlands had this idea of a mitigation bank, where they basically, usually a farm, and basically replumb it to turn it into a restored wetland. And after the George H.W. Bush idea of no net loss, and the focus on the political property rights movement to really put wetlands protection in the crosshairs of regulatory programs that are under attack, in the 1990s you get an explosion of wetlands mitigation banking. So basically you get these private companies who come in and they construct a mitigation bank, and you have the developer who needs the permits, who needs the credits, I should say, and you've got a regulating agency. A few things to realize about this very quickly. This is a purely artificial market, right? So if Bonnie were to sell JB a bicycle, JB cares about the quality because he's paying for it, and Bonnie cares about the quality because she's trying to get the right price for it. That's not this deal, right? Neither Bonnie nor JB care. If Bonnie is the developer and JB is the banker, neither of them care about the quality. Right? Bonnie wants a permit, JB wants cash. The only person in this exchange who cares about quality is the regulator, and that was a big problem with the Corps in the first 10 years of this story. They've gotten better. Corps gotten better. This is sort of cares about quality question, but there's some issues. So JB and I wrote an article in 2001 that basically pointed out that the currency that was used for wetlands banking trades was acreage, which is, if you care about the ecosystem services provided, a terrible metric to measure this, right? So that became an issue. Where are the ecosystem services? Where's the value about this? The government did some studies following on this, and they basically said we have no idea if there's no net loss because we can't measure what we care about. No net loss of what? Sure, there's no net loss of acreage, but who cares about that if you really care about the services? We also did a paper together a few years later where we found in Florida there was a net migration of 15 miles from the impact site to the banking site. That might be fine if you care about habitat. It's not fine if you care about service provision like clean drinking water and things like that. And so JB and I became, in a sense, kind of the bad boys of the mitigation banking world, and there was a lot of we weren't the only people writing this. Dennis King was writing it from the economist side, Todd Bendor worked from the geography side, but there were a bunch of academics who were saying there's some real problems here. And that led to the Corps, in part, to revise its guidelines.
Yeah, so just a couple of thoughts before I jump back into the core regulation. As Jim pointed out, this is an artificial, it's a market created by a regulatory instrument. And the question from earlier today, should we be relying more on markets? On the one hand, it worked very elegantly to sort of create these banks. But the question is, well, what's in the market? Like, what does this market care about? And the whole point of this study and several others, Todd Bendor, there's about 15 that sort of came from the late 90s to the mid 2000s. Well, what about the ecosystem services, the actual economic benefits to humans that we derive from well-functioning ecosystems? The whole mindset behind 404 was focused on bugs and bugs, sort of the habitat, the benefits for the particular type of wetland ecosystem. So even if you accept that an average distance from impact site to bank of 15 miles, some as far as 80 miles away in the Florida study, is a net even for bugs and bunnies. It can't be for people. I mean, right, if the ecosystem services generally are local, obviously carbon is global, but all those, the water filtration, the water storage, then moving them 15 miles without accounting for that in this market could be problematic. And the EPA in particular responded to this research. And I mean, I wasn't inside the room, but my sense is that the EPA was pushing on the Corps to, in their joint compensatory mitigation rule, 2008, to integrate ecosystem services somehow. And this is the language that compensatory mitigation should be located where it is most likely to successfully replace lost functions and services. We're going to take this into account. Then they also, in this rule, pointed out, that's really hard. We don't know how to do that. And, in the history of sort of ecosystem services policy, this is the first embodiment of ecosystem services values in federal regulatory text. I mean, CFR. You got some agencies talking about it in guidance, etc. But now it's in hard law. But the law got a little bit ahead of science, I would say, in that we didn't have the science to account for ecosystem services losses and gains at that kind of granular in the field level. So they recognize that. The whole point of what Jim and I are hoping to do in this paper is now it's 2022. They said they were going to do this in 2008. What have they done? Where has this gone? Also want to point out that they were not alone soon after the Forest Service in their revamp in 2012 of their forest planning rule, integrated ecosystem services extensively, including creating methodology for assessment in forest planning, and they have a lot of research about the value of trees, and they're really out there assessing the ecosystem service values of the forests, national forests that they manage. Also, a very big development that kind of dropped out of the blue in the Obama administration was that OMB, and this goes to kind of the whole, how do we quantify these? So all those not monetized, no benefits. So OMB and CEQ issued a memo to all departments and agencies saying, look, we're tired of having this not monetized, no benefits to be calculated. Tell us how you are going to identify, describe, and quantify ecosystem services. How are you doing it now? How are you going to do it? And we're going to, in fact, give you guidance once we figure out what everyone's doing. Now, when OMB says jump, federal agencies jump. But we all know what happened. They had a big, handoff ready to go, and the administration that won wasn't interested. Now, fortunately, ecosystem services just kind of went dormant. It did not attract the unraveling. And so now we're in a position in the Biden administration to ask, what do we want to do now? Have the 2008 regs been implemented? How can we find out? Naively, Jim and I thought, we'll just go on the Corps of Engineers database, download, all the EISs and records of decisions for like 5 coastal cities, and we'll read through them and we'll code them. Well, there's one problem. You can't do that. The Corps does not have a database like that. You essentially have to hunt and peck through 3 different databases. Ribbits, the Corps Permit Finder. I thought, well, that's obvious. That's where I want to find these permits. It's just a list of permits. There's no links to anything external to this list. So you have to kind of guess and decide, well, this permit might be a kind of permit that would involve an ecosystem service analysis. And then you have to FOIA the Corps, and then you wait, and then you get either a letter saying you couldn't find anything, or here you go. And we did that as kind of a small test case and found very little useful. In some cases, it was clear that the permit activity probably didn't, have any ecosystem services trade-offs. In some where they did, I think, Jim, you found that it was sort of qualitative, just, no, don't worry, not a problem. So we also search, high and low for, is there internal policy? Do they have this kind of assessment methodology? Nothing. We still want to bottom all that out, but the bottom line is, if you wanted to find this out, you would have to, hire teams of RAs and just be FOIA, and construct the database in that sense versus having one available. But same findings, we still don't know really how compensatory mitigation is working, in particular when you take into account the ecosystem services impacts on people. So it's a potential doctoral thesis. If any of you have some PhD students who would like to join us. It's unclear whether this is intentional or just low priority, but it would be easy to fix. It's 2022. Okay, they have the documents. It's easy enough to put them into some kind of a database that find out. Now, why is that important? Well, first of all, they have the resources. They have the Institute for Water Research that does a tremendous amount of research on the civil works side of the Corps of Engineers, and we have Congress at Maryland, who's helping them think about ecosystem services impacts on that side of the Corps. There's just not the same, there's no corollary over on the 404 regulatory side that we can find. Now, why does this matter? There's a lot of research coming out about urban ecosystem services, how important they are, even junky ones. That was one of the criticisms that we had. Well, you guys are talking about urban wetland impacts and the banks around here in the rural areas where they're beautiful, and those are just junky wetlands. Well, they may be junky for bugs and bunnies. They're not beautiful, but they're serving local ecosystem services values, and it's going to be incredibly important, increasingly important with climate change. So these urban junky accidental wetlands are actually tremendously valuable to those urban populations. We see it as an environmental justice issue. They're going to become more important. And these trade-offs are being made by this market in which, the people who are being affected by the market aren't participating. They can't find out without, again, kind of research you'd expect in a doctoral dissertation. What is the impact? What's happening to our community as these wetlands are filled and the values are being transferred out to, 15 miles away? So we think greater public knowledge could at least impact site permitting and mitigation bank locations, but also inform urban populations about the effects of this regulatory market on their. We're done.
Okay, so we now have time for questions. Start with Professor Button.
This is probably mostly for JB, and first, all the presentations are great and fascinating, and I admire people who have actual methodological skills when they present. We law professors are famous for having no method, but a lot of opinions. But but for JB and Jim, under 404, the Army Corps has long had its public interest review. Have you thought of doing just a very focused FOIA request just to get any particular year's 404 public interest reviews to see if they do anything that would, because it would seem to logically fit there as part of a public interest review in 404 permitting? Because I think often with any of these agencies, you do a FOIA request, the problem is that it's a morass, and so the response is either nothing at all or they don't even know where to look, and so.
It's a good suggestion, and we didn't look at the public interest. I will say what we're looking for is something that's technical.
Looking for what?
Something that is technical. We want to know, did the Corps actually try to assess the services? There's actually, when the banks are permitted, mitigation banks, they actually do an analysis of the services that are provided by the bank. What's missing is what are the services that are provided at the development site, and how do those compare? They talk about them qualitatively, but there's no real sort of quantitative assessment. But we will look at the public interest part.
Yeah, just those factors, the public interest review factors, many of them match up kind of nicely with what could be called an ecosystem service. Some don't, but the full package of services really is not. The public interest review is really aimed right at that, nor is it aimed exactly at the question we were asking, which is the translocation of ecosystem services that's going on systematically from wetlands mitigation banking, the way it's practiced, is not really being captured.
My question is for David, I guess. Can you tell, you have some time series, but can you tell if the population came to the pollutant or the pollutant came to the population? Because that might matter, but is it possible to even tell?
That's a fabulous question, and I'd have to think through it a bit more, and there are other people that have given that a lot more thought than I have. That's probably really difficult to do from a statistical perspective, just because you have that, what Sheila talked about before, that endogeneity concern. So I can keep rambling, but no, I think that's a really tough, good question. There's maybe some new data sets now that are kind of, in some ways, scary in how much they track individuals and how they move and where they live and move over time. I've used that a little bit in some work of mine focused on Flint, but I think that maybe if there's certain unexpected shocks of industries being in certain locations, then we could possibly try to use that to then see how that changes demographics. So I'd say there's certainly the potential for it, and maybe others have already done it. I'm just not aware of it. But I think it's a really great question, but I think a tough one to answer.
I had a question. This is for Bonnie. So I was looking at the table. Actually, I guess both of you, because it's based on your research. Where you got all these projects that have been implemented. They don't do well in benefit cost ratio, which suggests to me, well, that's probably just, then why do we care about that measure if we know that it's probably wrong? I mean, one way to look at it is say, well, we can get it right. Another is to say, you're not going to be able to screw in a screw with a sponge, right? We're just using the wrong tool.
It's a great question. I mean, I think that why should we care from, I think it depends on what perspective you're also looking from. So, for full disclosure, I was working with a nonprofit that was interested in trying to understand a bit more about some economic analyses that EPA is thinking about for more full implementation guidelines. And one of the things that I've heard is that for a long time, some of the nonprofits didn't really care so much. Hopefully this isn't too much of a blanket statement. They didn't care so much about the benefit cost ratios. But what they found is that sometimes, and this is a non-lawyer speaking, is that courts do care about it. And so I think what this is suggesting, at least from what I try to suggest, is that this provides a very perplexing question and issue for us. So if we have these benefit cost ratios that are very low, is that indeed the case and maybe we should be pulling back? Or as what I think it is that it's a call for more research and better research that can try to measure the benefits of water pollution control. And my understanding is that kind of the air field ran into similar types of issues, but many decades ago, they're having also difficult times measuring some of the benefits. And so I think that from a researcher's perspective, I think we should care about it because it's suggesting that we need to do a better job, potentially better job, making sure we feel very confident in the methods that we're using to measure.
Hi, my question is for David Kaiser as well. I was wondering, can you, when you look at progressivity in the context of your study, can you explain that again? Generally in tax, when the rate increases with the income, that's progressive, and then when the rate increases with a decrease in income or the base, then that is regressive. And then the second question I have is, can you explain why you look at the non-white population only, and is that a percentage or a total or an aggregate number?
Sure, and great questions. First question, I actually, when I was on the plane here as well, thinking about these slides, this is the intimidating part of presenting in front of lawyers that are very particular and good about words and meanings. The meaning of those words. For economists, not so much so. At least for this economist, not so much so. So I don't know if progressive is the right term to use there. Honestly, what we were trying to think about is there a simple way that we can describe whether or not the measure of harm, in this case the presence of facility, tends to disproportionately impact communities that oftentimes are thought of as being disadvantaged in terms of communities, minority communities and communities below the poverty line. So that was what we were thinking about there. Sorry, your second question was?
So just based on what you said, the number of facilities that are near populations with less than college education is higher, and the number of facilities is higher where there's a greater poverty,
Yep.
and
Then they're lower in areas that are predominantly non.
So that non-white is a proportion, it's a percentage of the population, or is it an aggregate number?
So we look at a census block group and we look at the share of the population that is non-white. And when you ask about race, then that'll remind me of your second question. We have looked at a number of other, just for the sake of time today, we group this into a share non-white, but we have looked at similar kinds of analyses for the share Black or African American. We also look at a separate question that asks about the share that is Hispanic or Latino. And we find similar results, a little bit slightly different, but similar kind of results as when we kind of classify this as a share non-white.
Okay, great. Thanks a lot.
Yes, another question for Bonnie and David. Especially Bonnie, when you were presenting and describing some of the assumptions made in economic analysis, you talked about the Kaldor-Hicks criterion and how that assumption essentially assumes a theoretical lump sum compensation from the losers, let's say, of regulatory initiative or policy to the winners of the beneficiaries of such policy or regulation. Is Kaldor, in order to account for some distributive factors, would that require moving on from Kaldor-Hicks and that assumption? Or should Kaldor-Hicks somehow make that theoretical compensation a practical reality to other legal or program or framework, which that, in my mind, opens such a big can of worms. But whenever I'm talking about moving beyond Kaldor-Hicks criterion, something that comes to my mind is, for instance, the social welfare function protocol. I don't know if you're familiar with. It's a lost Adler brother that is not here, but it's essentially a theoretical that explores the mechanics of this framework. Do you have any impressions as to that model?
Yeah, it's a great question. So, this gets at what are the objectives of our policy analysis and the trade-offs associated with defining that in different ways. And so, one way is to say, let's make the pie as big as possible. Let's maximize net social welfare and not worry too much about how it's divided up. But if we can make it bigger, then that's better than not making it bigger, right? And then you could say, well, what are we going to do about the distributional impacts of that? So now if we've made the pie bigger, which is good, and we want to pick policies that make the pie as big as possible, do we also have a responsibility then to reallocate that to address those disparities? And so economists have backed away from that and been saying, that's not ours to evaluate. We just can tell you what the impacts on net social welfare are. We're not going to say this is how it should be distributed. So then there are other ways that people have talked about other frameworks of measuring well-being. You could think of a max-min approach. You could say let's have a criteria where we want to apply policies that raise benefits for the lowest income households, or we establish we want the benefits of policies to at least raise the minimum in addition to maximizing social welfare. Or you could use a Marchesson capabilities framework where you think about that's your criteria, and then you're trying to address people's a multiple criteria analysis for different capabilities, or you can look at the social welfare function that Matt Adler and others have written about. People have put ideas out there about these different aspects. I don't think there's been a lot of critical comparative work on what the practical implications of them are. We have this theory, and everybody's developed different theories, and then there's the theory and practice and what it actually looks like. And I would love to see more comparative work. There's a lot of theoretical critiques of economic analysis, but very little practical implementation of alternatives. And I think that means that we keep falling back on methods that we've got really, we're really well exercised in.
Professor Ryan, and then.
Thank you. So my question is probably most focused to Jim and JB, but maybe for the whole panel. And it's really about the intersection of the environmental justice concerns that Bonnie and David have talked about and the ecosystem services innovation that you guys have been at the forefront of. And I remember when it was happening, this wonderful idea of how to encapsulate some of the, how to maybe move towards quantifying and at least counting some of the benefits of keeping water in stream that had been missed in earlier cost-benefit analysis, made the ecosystem services model so powerful. But this panel is making me think about how we might disaggregate pieces of the ecosystem services panoply into parts that are more susceptible to environmental justice problems and less susceptible to environmental justice problems. And so the bugs and bunnies features seem to be less tied to environmental justice problems, but some of the recreational and scenic benefits that we associate with waterways seem to be more connected with potential environmental justice problems. And so I'm sure that I may be having this thought for the first time. I'm sure that there's a rich literature of people who have thought about this in much greater detail, probably the two of you. But I wonder how you would think about that. Do we need to be more precise and more discerning when we think about ecosystem services in this new conversation where we're going to do better, says EPA and the Biden administration, about thinking about environmental justice concerns?
Yeah, that's a great question. As I suggested in my half of the talk, there is an increasing attention to urban ecosystem services as both a climate change justice issue, and it's just basically an environmental justice issue. To your point, your specific question, actually Kalyani Robbins, a colleague, a law professor at Loyola Chicago, is presenting, I think she's one of the abstracts that we chose. If not, she's working on this very question, the environmental justice of ecosystem services, and are they, is our policy sort of thinking about that specifically versus just, and there are, their ecosystem services they vary tremendously. Like there's, carbon, we manage for carbon, we might not be really maximizing some of the local ecosystem services. So those are policy decisions we have to make as well.
I could just comment, and based on my experience working on urban ecosystem services, in many watersheds, they're not a term that resonates well with environmental justice communities. And in a lot of cases where we've come in with sort of this lead of nature-based solutions or the benefits of urban nature, what I have heard back from community members is, that sounds like gentrification and displacement to me. So I think we have to be really careful in how we take that term and apply it in an environmental justice framework. And it's not a term that I think resonates really well with the environmental justice community in my experience.
Professor Mendelson.
Thanks to all of you for great remarks today. My question, partly inspired by Dr. Keeler's presentation, is for Dr. Kaiser about your data. I'm just curious to know if can you hear me okay?
Yep.
I'm just curious to know if you took into account a couple of factors in your data. One is whether the distance from the facility, if you will, is sort of along the waterfront or away from the waterfront, inland. Because I wonder if that might affect some of your findings. And the other is essentially size of acreage. And I couldn't quite understand whether you were looking at your data based on poverty and non-white status based on kind of blocks of property owners or individual property owners. But I was curious to know if you looked at either of those, size of acreage of individual holdings and whether the location that you're measuring from is along the shoreline or inland.
Both excellent questions. We're still fairly kind of new into some of the data analysis. So we don't do this in terms of the distance along the waterfront. And some separate work, have a program that can help us search pretty nicely upstream and downstream from particular locations using a hydrologic map of the United States. It's something that we've thought about doing here. We don't have that currently. It's a great point. And then we don't consider the different, currently don't consider the different sizes of the census block groups themselves, but again, something that could potentially lead to some mismeasurement between the characteristics of the census block groups and the presence of facilities. So both excellent comments and things that I've jotted down that we need to do. So thank you.
This is a question that could perhaps equally well have been asked at this morning's second panel. Many of the considerations, the interventions associated with the Clean Water Act result in costs that tend to be borne early and benefits that tend to be strung out in time. And so the manner in which that disparity is handled quantitatively has or could have a considerable impact on findings. And that issue has sporadically been examined. Well, certainly there were in the Senate in 1952. So I mean, it's an issue that sporadically surfaces and garners attention essentially for most of your lives, not quite mine. The question is this: is there any state of the art that's generally accepted now as best practice?
I mean, so there's lots of environmental issues where the benefits and costs are disconnected in time. So climate change, I think, is another example where we're having to bear lots of costs right now, and the benefits may not be realized for into the future, maybe even future generations. Economists deal with that through discounting. And of course, there's a lot of normative assumptions based on how you value benefits that occur in the future relative to the present, especially when you're valuing impacts to future generations that aren't currently living. And so there's a whole kind of ethical and debate around what the appropriate discount rate is, but that's sort of the best attempt to try and internalize those benefits that happen in the future and put them in present terms. Water pollution is a whole nother deal though too, because there's lots of legacy, like phosphorus sticks around for a long time in sediments, and you could do something and not see the impacts for decades. And I think that's a real problem in terms of trying to also make a public case for the investments that we make in improving water quality. I can say in Minnesota, we've been dumping tons of water, tons of money into improving our waterways, and we're getting these like little tiny, incremental impacts that we may not really see for a long time.
Another way of viewing the question, and one of the things I find most interesting about thinking of the Clean Water Act and CIDWA, the Safe Drinking Water Act, you've got three very different possible funding sources. First, it could be the federal government, which loans or grants, and those are very different things. But in many respects, we haven't talked about it, in many respects, I think the most important impact of the Clean Water Act was the money that came in the first decade. I mean, if you really look at the difference it made, and that was basically, those are grants. You've got the polluters, right? You want the polluter to pay, but you've also got the users, right? And this is a big deal. We're not talking about the Safe Drinking Water Act in this conference, but that was why Nixon opposed the Safe Drinking Water Act, as he thought that the ratepayers should cover all the costs. And these issues are still very much in play 50 years on. Some questions down in front, down here.
Hello. I'm trying to understand
the context for the term urban ecosystem services, is that the Drinking Water Act? Or when you talk about Section 404, because I'm hearing this like juxtaposition between like animals and insects versus race and people, and it's getting confusing. So I'm just kind of wondering about that.
So when a teacher hears that, you think I did a bad job. It's basically a lot of things, which means we weren't clear in setting it out. So 404 is the permit program if you dredge and fill navigable waters, which in practice tends to be wetlands. What JB and I showed in our research and others did was that when these wetlands are being filled and the loss is being mitigated by basically cheap farmland somewhere else, you were generally losing the local services and they were being stored somewhere else, which means if the value that they're local, that's lost. A lot of places they were being lost were in urban areas. And so the urban ecosystem services, the loss of those is what we particularly care about right now. I hope that clears it up.
I guess I mean, one of the things I'm starting to see more as I read and learn more about environmental law is how things are connected, especially hydrologically. So, you know, you can't see the boundaries as much. So when you say urban ecosystem service, I'm like, how do you measure where the boundaries are in terms of, you know, we've lost the service. So if you have like habitat somewhere else and you have bees, they are providing food, urban agriculture somewhere else, you know, possibly. So I guess it's just, I'm trying to get that into context.
Yeah, I mean, so I think our focus on urban ecosystem services for this purpose is just to put a spotlight on the fact that there are what we might consider not pretty wetlands that are benefiting urban populations that are, you know, Section 404 allows them to be filled if you compensate for the loss. And that was, you know, wetlands mitigation banking sort of greased that wheel beautifully, but they wound up sticking the banks out in the middle of nowhere and only really considering the ecological value to nature in general versus the trade-off between people.
We should talk afterwards.
Yeah,
Economic benefit too to the urban area because you have
sure,
more people.
Of course, I mean, maybe they want a shopping center, but they're not given all the information that I would, you know, that you would normally want to have to make decisions like that, and they may be benefiting from the honey that's being, you know, sure, but all of those should go into the mix. We have a hole here. We've created a regulatory market that isn't taking into account everything that you would expect it to take into account in a well-functioning market.
To kind of concretize the question that she asked, do you guys have a good example of the kinds of things, the ways to mediate the problem of stormwater runoff, given the number of people who drowned in New York City with the recent excessive rainfall and in other cities? Like, what could have been done as an alternative in terms of ecosystem services to slow the water or prevent all of those basements from flooding so quickly and resulting in drowning? Are there techniques or ways of dealing with that in terms of ecosystem services in urban areas?
Yeah, absolutely. And I'll be brief because I see some other hands. Engineers always face the choice between nature-based solutions and green and gray infrastructure. Right in New York, you may have read stories about this, is basically creating these huge caverns where the stormwater is just going to drop down, and hopefully that will be enough. In many cases, a nature-based solution doesn't make sense, given the geography and the need. Sometimes it does. The Catskills, New York City water, it did. Other places it won't. One of the key focuses, foci, of the whole ecosystem service movement, I've been involved in it now for almost 25 years, is for engineers to at least consider that there's an option to a built infrastructure solution. And that, you know, Philadelphia has been a leader on this. I don't know about Cleveland, but, you know, a lot of cities are looking at it differently than they did 2 decades ago.
Thank you for these great presentations. And all three of them raise an issue that I've long found maddening about cost-benefit analysis in the environmental sphere, which is, you know, you have all these instances where it's known there's a benefit. The problem is we can't put a number on it. And that gets translated to zero. And that strikes me as there should be an intermediate step in there. And Justice Stevens had a great dissent in one of the cooling water intake cases where that's what was done in the cost-benefit analysis, is all that long list of benefits we knew were there got translated to zero because they couldn't be monetized. So my question is there a way to do a qualitative cost-benefit analysis, and why, if there is, why hasn't that been incorporated more?
Yeah, and there are lots of ways to measure these things. It's not that we don't have any idea what's going on if we can't put a number on it, right? And so I think part of the frustration is, how do you take those qualitative analyses? How do you take those descriptive analyses? How do you take things that are even in biophysical terms? Well, you can't put a dollar value on it, but it's still really important. And what happens in theory, like, there's no reason why we can't do that, right? The information is there, so let's put it together where it makes sense. In practice, when you try to put everything into a benefit cost ratio, you have to let all that go. And we don't necessarily have to, that's a choice that analysts make. It's a choice that policy analysts make. It's a choice I try to help my students navigate when you're thinking about what it is that what information are you gonna bring into decision making. I think we need we need better standards and examples of what a real pluralistic, comprehensive, multidimensional, qualitative and quantitative practice looks like for regulatory review. And it's something I want to see more examples of what that looks like.
Just one comment. I don't need the mic. Dr. Kaiser, you mentioned that you were looking for examples of environmental justice in the water industry. You were having luck finding them.
So not that they weren't examples, but a very large kind of comprehensive analysis that could say in what industries or what water quality policies would we think.
So I just wanted to mention if you haven't looked into it, then NACWA, National Association of Clean Water Agencies, just created an environmental justice committee, and they kicked that off. When was that? March. So you're right. Basically, there is a gap there, and that's being worked on. I guess it's one thing to mention. And then the other thing I want to give a shout out is, I just heard to talk about the EJ tool that EPA has. I don't know if you've checked that out, but that's pretty cool. The way they can take demographics, and it sounds like it's right up your alley. It's not my thing, but so like.
Thank you very much.
Yeah, sure. Just want to mention that.
So my question is for David Kaiser, and it kind of builds on Sheila Olmsted's presentation. And the question really is, why facilities? Because, as we've heard about today, those are probably the most effectively regulated sources out there. They seem like they might be pretty unlikely to correlate with severe water quality problems unless it's coming from something else. You said CAFOs, so maybe CAFOs are a different story, but, and I guess if the answer is, well, that's where the data are, that's fair enough. But is it possible to do something like what you're doing, where you look at actual water quality conditions rather than facilities, to get a clearer sense of where the EJ impacts might be?
Great question. Part of the answer is that's where the data are. But also another part of it is just so far a time constraint on the research. But I think that one thing that we've been thinking about is, well, where could we start looking elsewhere as well? So you could imagine, like what this misses is that we currently haven't looked at, the national wetland inventory and looking at demographics nearby that. You could think about adding that in with this as well. In terms of water quality itself, I've done a lot of work looking at impacts of policies on water quality outcomes. That could be a natural place to look, but I also felt like that if EPA is moving forward in terms of doing these analyses for particular industries as they get regulated over time, then it would be interesting to know, well, where would we kind of expect to see this EJ type of analysis be most useful and helpful?
just about out of time, so we can. Any parting words from the panel? Well, thank you very much. It was excellent.
We have our last break, so we'll reconvene at 5 on that clock for our last time.
Yeah, well, that's
circle back, I don't think copy it, I try to just let it ride.
Fantastic. Not a whole lot to add on everybody's stage. It really does.
We never met that guy before, but I guess it doesn't matter to us.
You like I think doing their catalog.
I was going to ask you a question. That's how she coached me. When I think about how do you enforce anything? How does law even come into? Why is law even applicable? We just have foreign countries coming in. It's like impossible to kind of go after those people.
Trying to pick out. Wildlife trafficking, there's some core person who's gone out and collected it and sold it on. Right. And so what we were looking for is Zoom, whoever it is, displaying
Yeah, we should maybe.
So this isn't even poaching. This is like
it's poaching.
It's collecting for zoos and stuff, which I guess could also be a concern.
Various kinds of things. And the other piece is this technology wanted to not conviction doesn't result in any deal with the harm.
The only place where I wish we had
they're all in danger.
Most of these zoos, like in Western countries,
we did this. We've been doing it aimed at my biodiversity.
Started, but there's some very large.
We should probably go in. You had a question.
Oh, sorry.
Alrighty, we are going to get started we are in the home stretch. Last panel of the day. So thank you all for sticking it out. Hopefully you've been enjoying this as much as I have. I'm going to turn it over to my colleague, Randy Lepla, who is the director of the new Environmental Law Clinic, which opens its doors this year here at the law school, which we're really excited about. And so it's great to be able to have Randy here as part of the program as she is putting together the clinic that students will begin to participate in starting in the fall semester. So, Randy.
Thank you, Professor Adler. So I'm glad to be here with you, everybody, for the fourth and final panel today. Last but not least, of course, and want to go ahead and start by introducing our esteemed panelists here. We have Professor Dave Owen with the UC Hastings School of Law. We have Professor Aaron Ryan, who's with Florida State University, and of course we have Professor and also brother Jonathan Adler down there from Ray Berry Case. So we're really, really excited to hear from all of you today. And with that, I will turn it over to you, Professor Owen.
All right, thank you so much. I've really enjoyed the panels today. I've learned a lot. This has been fascinating. And when I got the invitation to speak at this conference, I thought, okay, I'll talk about WOTUS. That's the biggest thing going. And then I thought, wait, everybody's going to talk about WOTUS. I'm tired of talking about WOTUS. So we're going on a field trip instead. And so this is a story about a strange and sometimes magical place where some of the problems that we've been talking about today with non-attention to point sources, they still exist, but they're fading. They don't exist to nearly the same extent. So I'll say a few words about the motivation for the project, why I'm looking at this area. Then we'll actually go on the field trip. I'll give you a little bit of the geographic setting, and I'll talk about some of the regulatory initiatives, and then a few lessons learned. So this is a story we've already heard a couple of times today, and it's how I think a lot of us would assess the Clean Water Act looking back at the past 50 years. We'd say we've done a really effective job, maybe almost from economic standpoint, too effective, at controlling pollutants from traditional point sources. We've done a miserable job controlling pollutants from non-point sources. And urban stormwater, which is a wonderful subject, but not what I'm going to talk about right now, is somewhere in between. And the reasons, I think, are also a fairly familiar story. The exclusion of ag sources from the definition of point sources, and therefore from the NIPTES program. Non-point source programs that largely leave implementation up to state discretion. And then, as we saw from Annie Brett's talk earlier, that discretion is often, as far as we can tell, not exercised in meaningful ways. So the question I was going to ask is, how might things be different? And we're already, I think, many of us familiar with some places where different approaches have been taken, so Chesapeake Bay, Lake Champlain. I could have put up Lake Tahoe here, but that would have looked like California snobbery, so I didn't do that, but I still got the line in anyway. But I am going to take us to a trip to the far northwestern corner of California. So California has an interesting Clean Water Act implementation structure. There's also a state statute called the Porter-Cologne Water Quality Control Act. People just call it Porter-Cologne, and that's how I'll refer to it as well. And then California subdelegates its implementation authority for water quality to regional boards that have permitting authority over different pieces of the state. So in another paper, I use the very catchy term cooperative subfederalism. I didn't really mean that was catchy, just to be clear. It's not catchy at all. To describe this situation. So we basically have two layers of delegation. And our focus is going to be on the North Coast Regional Water Quality Control Board, which is in the northwestern corner of California. So here's a map that shows you the area within the board's jurisdiction. It is a huge area. It is also a very sparsely populated area. The only city of any significant size is Santa Rosa, which is at the very southern edge of the area. Most of it is again, largely unsettled or very small population centers and some dispersed population. It's also a very wet region. This is the wettest part of California. And in some parts of it, the average precipitation in a year tops 100 or even 120 inches, or at least it used to. Things are changing. But it's also a Mediterranean climate, which means that almost all of this precipitation falls in winter months. In the summer, things are quite dry. And it's also, I didn't have a good slide for this, it's a very steep landscape in most of these areas with relatively young rock that erodes easily. So erosion, sediment are big issues in the region. It is stunningly beautiful. This is really just a tourist plug here. Go see it if you haven't been there. It's a spectacular area. And it's also, for the most part, heavily forested. So the map on the left there shows forested areas. The dark green are national forest areas. The light green are state or private forest. And again, the point here is just that there's a lot of forest, with the sole exception of the upper part of the Klamath River Basin that's within California. That's the northeastern portion of the area, which looks more like what you might expect from the plains of Montana with mountains interspersed between. Because it is a forested, wet coastal region, it has and historically had many more fish, particularly salmonids. And water quality concerns in this area are very heavily driven by the need of these fish for cold and clear water. So water quality in this area, there's an earlier question about what is water quality? How do we define it? In northwestern California, we define water quality primarily in terms of meeting the needs of migratory fish. It's also an area that's been very heavily impacted by historic human activities. And this is one example, so these two shots show the watershed of the Garcia River. And for those of you who teach environmental law or have taken courses, you've probably heard of the Garcia River. There's a very famous case called Pronsolino versus Nastri that appears in a lot of environmental law casebooks. And that case turns out to be a very big part of the story here today, although I won't spend too much time on it. But this is a piece of the Garcia River watershed, and you can see in 1952 on the left, it's basically intact, not really very many logging roads at all. That is a little bit anomalous because a lot of this watershed started getting trashed, along with a lot of the rest of the North Coast, by logging practices beginning as early as the 19th century with essentially no environmental controls at all. But here you can see just within a 10-year period, massive amounts of logging taking place with legacy effects that continue to the present day. And this chart gives you a sense of how prevalent these kinds of practices and impacts were throughout the region. It is also an inadvertent plug for taking tax law, a subject that I skipped in law school to my great regret, because you can see here that at a point when California changed its tax laws so that landowners were taxed on the value of standing timber, the level of logging skyrocketed. And when California got rid of that law and no longer taxed people on the value of standing timber, levels of logging dropped dramatically with huge water quality impacts. So a lot of the land is forest, but there is also agriculture throughout the area, often in discrete pockets where you have relatively flat valleys, which are not abundant in this region. So there's irrigated agriculture in the northeastern portion of the area, ranch lands dispersed around. 95% of the world's calla lilies are grown in one stream valley or one river valley up near the Oregon border. But by far the most important crops are, wait for it, mind-altering substances, yeah, marijuana on the left, grapes on the right. Okay. So here's the quick summary of the legal framework. We'll start with the Clean Water Act, which we've been talking about all day, and I'll assume some familiarity there. But we also have in California the Port of Cologne Water Quality Control Act. And Port of Cologne is interesting because it regulates discharges. And it doesn't, at least in some provisions, distinguish between point source and non-point source discharges. So it establishes, and has established for decades, a foundation for regulatory control over non-point source discharges. And for many years, California implemented these controls with just as much enthusiasm as other states, which is to say not at all. But that has been gradually changing over time. And Port of Cologne basically regulates non-point source discharges, or establishes a basic framework where you have what are called waste discharge requirements, which are essentially categorical and generalized prohibitions on discharge from certain types of activities. But then the regional boards can create waivers from these categorical prohibitions. And the waivers are generally also conditional. And the waivers can also be categorical, or they can be specific to particular sites, particular companies, particular industries. So it is somewhat analogous to what we would think of with general and specific permitting for stormwater or for stream and wetland fills. All right, so here's the quick summary of areas in which the North Coast Regional Water Quality Control Board has taken this basic framework and has applied it specifically to non-point sources. So there are also point source-based regulatory programs for some of these activities, at least for dairies, but it also has specific non-point source permitting programs in all of the different areas that we see here, with the exception of vineyards, where the program is a work in progress. Some of these programs have been around for a while. A lot of them are the last 10 or 15 years, so relatively recent. And I won't summarize all of them, but I'm going to zero in on just a couple of them in more detail. So first, and this follows up on Annie Brett's talk a little bit, we're going to talk about Garcia River TMDL implementation. So the Garcia River TMDL is the TMDL that was at issue in Pronsolino versus Nastri. And for those of you who have read the case, one thing you might remember is that the state of California did not voluntarily approve that TMDL. The North Coast Board wrote it, but the state, under Pete Wilson, who was a somewhat conservative governor, wouldn't approve it, and so EPA finally wound up doing so. But after even before the TMDL was approved, and then definitely afterwards, the state developed, or the North Coast Board developed, a pretty rigorous implementation program for the TMDL, And that program involves a couple of elements. Again, it involves generalized planning, and then the possibility of site-specific or company-specific exemptions that are conditional and that are designed to be tailored to specific locations. And North Coast Board staff have been monitoring implementation of this TMDL very carefully, and they think they are seeing significant improvements in water quality, particularly in the tributary streams, less so far in the main stem, but in both locations, and that they also think that massive amounts of sediment have been kept out of the watershed. The other example I will quickly give is with dairies. And here, again, the basic approach is general prohibitions on discharges that are essentially flat prohibitions implemented through best management practices, the same as happens with the Garcia River TMDL implementation program. And much as with industrial stormwater permits, dairy owner has to submit a notice of intent, has to monitor, has to report on both practices to implement and conditions near that dairy. So these, again, are just two examples. There are a whole bunch of others that I could go through, will go through in the written paper. But I'm just going to skip ahead and talk about some tentative lessons and themes that I'm drawing from the study. I say tentative because part of the research here has been interviewing people who were involved in this program, and I still have a lot of interviews to do. So I'm still at a somewhat early stage of the research, but it's enough for some tentative conclusions. So number one, non-point source regulation can happen. It exists, and it exists in what is actually in significant part, a pretty conservative part of California, and the world has not exploded. And I think sometimes it's been so long that we've had this division and we have not really had much effective non-point source regulation that we all get it in our heads that it could never, ever happen. But it could, it does, and again, the world didn't come to an end. Second interesting thing is that the Clean Water Act toolbox for non-point source regulation, which I think a lot of us have written negative things about, I certainly have, turned out to be a pretty useful foundation. Almost all of the local initiatives here are in some way built on a Clean Water Act requirement, whether it's area planning or TMDLs or some combination of both. Also a lot of use of 401 certifications, also a provision I had never heard about before but has been important, is Section 1323, which gives the state authority over water quality regulation on national forest lands, and the state uses that authority extensively. Lesson 3, this is not rocket science. Strikingly, there's not much in the regulatory models that the North Coast Board is using that strikes me as either a very innovative regulatory model, or when you look at the specific site-specific techniques, again, it's things like fences to keep cattle out of streams, buffer zones where people are logging along streams, avoiding logging on very steep slopes. Some of it is costly, some of it is not very costly at all, but it's not a new and highly innovative regulatory model. And similarly, the basic cooperative federalism structure that's being reproduced at the state level is again, it's just reproducing something we already do at the federal level. And so the takeaway from me is we don't need a completely new regulatory model to be invented in order to deal with non-point sources. It's more we just have to do it. Counterpoint here is that nobody is describing the work they're doing as easy. And the problems arise in large part because the sources are so geographically dispersed. There's a relatively small staff at this agency spread over a huge area. And relatedly, because so much of the regulation is done through BMPs, it's often difficult to monitor effectiveness. You don't have the same ability to actually monitor outfalls, with a very limited exception of some irrigation return flows in the northeastern part of the area. So again, nobody describes this as a simple or easy problem to solve. Lesson 5, it's not just the Clean Water Act and it's not just Port of Cologne. There are a lot of other complementary regulatory tools here that matter, including California's scheme for permitting forestry operations on private lands, water rights regulation, and then the restoration work and the land acquisition both involve the state and the feds and private entities throwing a lot of money around. And the money matters. It helps a lot if you go to a landowner and say, we're going to regulate you, but we'll also happily work with you on a grant application. That combination of things can make regulation a lot more palatable, particularly where it's new. Last lesson is that the existence of a non-point source program can be a matter of degree. So we often think, oh, it's going to be a binary switch where you have no non-point source regulation, then you might have a fully fledged program. That is not what's happening here. What I found instead is that the programs vary in their stringency. They vary in terms of the stringency of the default requirements they have. Like, do you have to submit a notice, or does the state come to you first? And they also are evolving over permit cycles. So the waivers have 5-year cycles, and the people at the state agency, or the local agency, have specifically said, well, in this first agency cycle, we just wanted to get a foothold. In the next one, now that we've established some credibility, some relationships, we're probably going to up the stringency a little bit, make the requirements more extensive. And so the larger lesson, and I think this is a lesson that, it's dangerous to try to generalize from California, particularly a very eccentric part of California. But I think the generalization we can draw from here is that other regions could ease their way into non-point source regulation and not have to tackle it all at once. That's all. Thank you.
Thank you, Dave. That's a really valuable project.
And also, Jonathan, for inviting me to this wonderful celebration of 50 years of this remarkable piece of environmental legislation. Am I not being amplified? Is that better?
Yeah, you were speaking in the middle of 2 mics.
I have trouble speaking while sitting. It's weird for me, and I feel really short. But I'll try to make up for that with interpretive dance. Anyway, I was thanking you, Jonathan, for inviting me to be part of this wonderful celebration of this landmark piece of environmental legislation. And my role in that celebration is to harp upon its flaws. Probably not as much as you will, Jonathan. I'm not sure I'm ready to say it's obsolete. But I'm going to talk about the limitations in the statute that have left waterways so vulnerable that environmental advocates are increasingly turning to other theories of environmental law in order to protect them. And I'm going to be talking about the public trust doctrine and the rights of nature movement as two recent comers to environmental litigation as ways of trying to protect these waterways unprotected by the Clean Water Act. I am drawing on some previously published work and my forthcoming book about the public trust doctrine and the Mono Lake story. And the story I want to tell is too long for 15 minutes, so I will be drawing on my native New Yorker skills as a speed talker, but I will also make sure to be as clear as I can, and this is my plan, what I'm going to try to do with my time today. I'm going to try to convince you that by its very success, the Clean Water Act has created such high expectations in the public that waterways, that U.S. waterways be drinkable, fishable, and swimmable, that we're therefore really disappointed and legitimately frustrated when these goals are undermined by the statutory focus of the Clean Water Act only on matters of water quality and not on protecting water quantity in sufficient quantities that waterways exist and be swimmable and fishable. So the advocates for ailing waterways that are left unprotected have turned to these additional legal tools. The ancient but evolving public trust doctrine, a common law doctrine that assigns certain public rights in navigable waterways and perhaps other resources, and increasingly the ancient but re-emerging rights of nature doctrine that sets forth legal rights in waterways themselves and other features of the natural environment in an effort to protect them. I'm going to talk a little bit about how, interestingly, these seem to be in opposition. They start from such contrasting environmental ethics, where the public trust doctrine, like the Clean Water Act, is unapologetically utilitarian or anthropocentric, focusing on the benefits that waterways and other natural features can confer on people. And the rights of nature movement rejects that wholly for an ecocentric, a biocentric, or an ecocentric perspective that considers these waterways and other natural features as valuable in and of themselves without reference to human needs. One of these has more traction in our legal system than the other, but we'll talk about the recent emergence of rights of nature movements nonetheless. Despite these differences, I'm going to talk about how there's this really interesting
parallelism as these two new approaches to environmental protection of waterways unfold in the way that they're differentiating jurisdictionally. So we see them not as a monolithic movement, but as a mosaic of sort of independently differentiating features along different legal axes involving the mechanisms, the legal mechanisms by which they operate, the resources that they protect, the values that they protect, and the underlying legal theories that give them meaning. So in the end, one thing is clear. Neither of them is trying to supplant the Clean Water Act. They both need the Clean Water Act to continue to do the work that it does. But they both highlight inadequacies of the existing means under environmental law to protect waterways. We blame the Clean Water Act the most because it promises so much. And interestingly also, they partner failures in litigation, they don't always succeed, with successes in political advocacy. They seem to be something emotionally, as we talked about earlier, there's something emotionally intuitive or appealing about some of these theories. The river belongs to everyone, or the river is valuable in and of itself, that motivate communities to act perhaps more effectively in the political sphere than in litigation. So, I'm going to talk about this almost not at all. You already know about the Clean Water Act. We've been talking about it all day. But I will just remind you that the plan was to restore the nation's waters for swimming, fishing, and drinking. And that this was to be accomplished by the regulation of water quality. The regulation of water quantity under state water law, water allocation law, remains mostly with the states. But as pressure on the water resource grows, the relationship between water quantity and water quality is becoming more intense. So here's the language. The objective of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters by regulating the discharge of pollutants with goals towards future water quality goals. But we've long heard the solution to pollution is dilution, meaning you need to have enough water in the waterway for inevitable pollutants to be to reach those water quality standards. Sediments, for example, are going to be there no matter what. And if we take it one step further, it's not just about pollution. If there's not enough water, if there's not enough quantity in the waterway, we're not doing much to protect the physical, biological, and chemical integrity of the water. I'm interpreting it here, as Bob Adler suggested, as a waterway. So we've talked about the tools of the Clean Water Act, discharge standards, performance standards, the NIMTs program. None of that is really going to help with quantity in waterways. Only maybe Section 404 is the part of the Clean Water Act that specifically speaks to a type of waterway, the wetland. But as we've been talking about all day, we don't really even know what a wetland is, let alone which ones are jurisdictional. I too thought about giving a WOTUS talk. I was like, everybody's going to do that. I'm with Dave, I'll do something different. Instead, I shall harbor planet's law. Or at least talk about the limitations of the statute. And as to review, the plan was to restore the integrity of the nation's waters, but we can't do it if there's no water in the waterway. And right now, population growth in urban areas, the increasing demands of industry on the water resource through, for example, the energy industry, fracking, cooling, and climate-related drought is just converging on this, the direness of the quantity problem. Quality has been the problem, and what we've heard today, it's still a problem, but the increasing pressure on quantity in waterways is really taking the headlines. So why don't we have a Clean Water Act approach to regulating water quantity? Well, one problem is that we don't really have a good model. The 50 states all have their own systems of water allocation law. They're really different, not just even east to west, but within these regions, they're really different. Congress and the Supreme Court doesn't even know how to resolve interstate water disputes. They hate to do it, they almost never do. It's a big project. So with federal solutions off the table under the Clean Water Act or elsewhere, advocates are shifting to these newer theories, filling this gap left unresolved by the Clean Water Act. So let me introduce you to the first of these, the public trust doctrine. This is an ancient common law doctrine with roots as far back as Roman common law, where the Institutes of Justinian framed it this way. By natural law, these things are the common property of all, the air, running water, the sea, and with it, the shores of the sea. And the U.S. received this doctrine through British common law and mostly applied it to navigable waters. The most classic statement of the doctrine comes from a 100-year-old Supreme Court case, more than 100 years old now, Illinois Central Railroad, where the court clarified that under common law, the state holds the title to the lands under navigable waters, entrusts to the people of the state that they may enjoy the navigation of the waters, carry on commerce over them, and have liberty of fishing therein freed from the obstruction or interference of private parties. And much of my own scholarship on the public trust doctrine has traced how this doctrine has evolved from one of a doctrine that's really about sovereign authority over submerged lands to a doctrine requiring sovereign protection of these submerged lands and increasingly environmental protection for environmental values. It also acts as a limit on sovereign power enforceable by the beneficiaries of the trust, the citizens, in court. And so, just to give you a sense of how that works, all the law professors know this case, but for everyone else in the room, I'll give you a 10-cent introduction to a really powerful example. The case from which I just drew that quote, Illinois Central. And I can give you the case in a nutshell. In 1869, the state legislators gave Chicago Harbor to a private railroad. The people were not delighted. The bums were thrown out of office. The new legislature promptly repealed the conveyance. And litigation ensued. And you can probably imagine what that looked like. The railroad said, no, you can't just give us this valuable natural resource and then take it back. There were all sorts of problems with that. And the state said something to the effect of, well, yes, I suppose that would have been a problem if we really had given that to you and then took it back. But that's not a problem because we never gave it to you. This is a navigable waterway protected by the public trust doctrine, so we didn't have the authority to give it to you. Those bums that we threw out, they may have acted like they were giving you something, but it didn't really happen. And the Supreme Court accepted that theory. And so that premise of state sovereign ownership and responsibility for navigable waterways is kind of the bedrock of the public trust doctrine across the 50 states. But from there, we see this remarkable differentiation of the public trust doctrine in all these different directions. And I'll very briefly touch on the different forms of law that operate to make the doctrine work, the different resources protected by the doctrine, the different values protected, and I won't have enough time to talk about this because I think it's so interesting, but the different legal theories about the nature of the doctrine. So first, really quickly, different forms of law. We've seen the common law version. That was one that was in operation in Illinois Central. Many states have constitutionalized the doctrine, and in doing so, changed it, expanded it. For example, here's Pennsylvania's Environmental Rights Amendment, which says the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. So that's a little bit broader than the Illinois Central version of the doctrine. We also see versions in statutory law, and I've given some examples from Minnesota and California. The different states protect different resources under the doctrine. They all start with the same doctrine of state ownership of submerged lands, but some states, like California, has recently extended it to groundwater resources. In Michigan, by the executive order, the Great Lakes water quality is protected. Other states have protected other resources, also susceptible to appropriation or monopoly, like the Pennsylvania Constitution that we just looked at protects all public natural resources. Virginia's Constitution adds cultural resources. California, in at least one case, suggests it applies to biodiversity. And the most famous extension of the doctrine is probably what we see in the Juliana case, the Atmospheric Trust Project that has attempted to allege violations of the doctrine for failure to regulate greenhouse gases of the air commons that Justinian included in the doctrine. The Juliana case has had mixed success in court. But in the political sphere, it has had some more success in terms of galvanizing and motivating interest groups. And I've given you the example of Massachusetts, where the same strategy resulted in the governor's executive order of an integrated climate change strategy. So perhaps more success politically. Different values are protected. Always start with traditional navigational values, transportation, commerce, fishing. Also, recreational and aesthetic values like swimming and kayaking and walking around the Great Lakes, recreational access, beauty. Also, cultural and historic values, I mentioned Virginia's Constitution, and increasingly environmental values. So Virginia, in addition to cultural values, protects the atmosphere. California, most famously, in the case that I love best, affirmed that the doctrine extends to ecological, habitat, and scientific values at Mono Lake. And I am legally obligated to always talk about Mono Lake when I talk about the public trust doctrine, because it is where I got my start in the field and led me to this moment here. But this is the case from 1983 where the California Supreme Court had to balance demands on the water resource by the city of Los Angeles and the ecosystem in the eastern watershed of Yosemite National Park, and ultimately concluded that the ecosystem had to be protected, but that there were still legitimate values that must be served down south. And this highlights the core challenge for the use of this doctrine in environmental protection, which is anthropocentrism. The doctrine protects values for the benefit of the people. If the people want to pave paradise and put up a parking lot, there's really not a lot to be said about that, which is where the rights of nature movement will pick up. Before I go to that, I will just acknowledge one of the more interesting places of development of the doctrine are the different legal theories of the trust across the states. Is it an ordinary common law doctrine susceptible to legislative abrogation as the state of Idaho thinks it is? Or is it a quasi-constitutional doctrine that the legislature can't touch, like California thinks it is? And there's a lot of movement about the public trust doctrine as a background principle of state law that can defend environmental regulation of waterways against takings challenges. We see some splits among the states there. But in my last few minutes, I want to turn to the biocentric alternative, the rights of nature movement, which rejects the anthropocentrism of the public trust doctrine and instead tries to think about environmental rights as inhering in nature itself. So instead of human rights to enjoy natural systems, this approach would protect the rights of ecosystems and their components to exist. And most often, those ecosystems are waterways. They're groundwater. The historical origins of the doctrines certainly have roots in indigenous cultures worldwide for countless generations. Here in the Western legal tradition that we're talking from, it probably starts with the Supreme Court's rejection of it in Sierra Club v. Morton in 1972, but that led to a raft of scholarship reviving whether it should play a role. And before we go further, I want to acknowledge the core challenge for this, the use of this doctrine in environmental protection is pragmatic. Who speaks for nature when nature can't talk? And what if the people who are talking don't always agree, which it turns out happens a lot. So to give you an idea of what this looks like, this is the Constitution of Ecuador, amended in 2008 to include a rights of nature provision. It's pretty straightforward. Nature has the right to integral respect for its existence and for the maintenance and regeneration of its life cycles, structure, functions, and evolutionary processes. All persons, communities, peoples, nations can call upon public authorities to protect it. And then it goes on to talk about what those rights look like, the right to be restored, the right to evolve. I don't have time to tell you about how much has happened worldwide with regard to the rights of nature, but there's actually been a lot. We see movement in Ecuador, New Zealand, Australia, India, Bangladesh, Bolivia, Colombia, and domestically as well. There's been a raft of, mostly at the municipal level, mostly ordinances passed in California, Pennsylvania, Ohio, Florida. In 2020 alone, there were 15 local rights of nature ordinances, all designed to protect waterways under threat, mostly of water bottling plant withdrawals. And so there's a lot going on. The state attempts to preempt them with the bill saying we're not going to acknowledge any of those local ordinances, and yet they still, after that preemption, there was a ballot initiative bringing them into force. So we see this sort of political sphere, legal sphere disjuncture. Perhaps the most important movements are happening at the level of North American tribes and First Nations. I've given a slide of some important tribal moves forward. But where I want to do two last things before I give up the floor. Obviously, I don't have time to talk about this in any detail, but I want to show the same axes of differentiation in the rights of nature context that I've mentioned in the public trust context. So across the world and across the states, we see different approaches to the answer to the question of what gets protection under the rights of nature. Is it all nature, like the Ecuador Constitution says? Is it specific ecosystems, like in Oceania, it's very much rivers? Is it supporting specific species, like a species of wild rice in Minnesota? Who speaks for rights holders that don't talk? Anyone, like in Ecuador? The specific local community with a relationship to the resource, which is the primary approach in the United States municipalities? Is it guardians appointed to the resource? What legal mechanisms vindicate it? The Constitution, legislative statute, local ordinances, judicial action, we see all of these. Finally, what rights are actually being protected? Many of these are framed as legal personhood. So rights, New Zealand has given a national park legal personhood the same rights as a person. But other approaches say there are all these rights that people can't actually have that we think nature should have. The right to evolve. It's not really something a person has. And in some places it looks more like a form of strong environmental protection. Australia requires a strategic plan to protect the Yarra River. So I'm going to conclude on this slide here. These things are differentiating in front of us as we speak. What's really remarkable is that the predominant focus of both contexts are waterways that are beyond the protection of the Clean Water Act And I think that reflects the centrality of water and waterways to nature and ecosystems and how important it is that we're not solving that. It reflects the shortcomings of conventional environmental legal protection, especially under the Clean Water Act, to do this job. As I mentioned, they both pack intuitive and emotional appeal to people that leverages, perhaps maximizes their effect in the political arena, even when they fail to produce results in court. And they both represent an argument of last resort. Everybody starts with the Clean Water Act. They only come here when the Clean Water Act is not getting the job done. And they voice, I think, the concerns underserved by conventional environmental law and systems vulnerable or unrepresented in traditional cost-benefit analysis for some of the reasons we talked about earlier. Now, if I had more time, I would remark on perhaps the false dichotomy of the anthropocentrism-ecocentrism divide, because we see the same people under both beliefs, the same movements using both beliefs, but I am past my time, so I will just end there and look forward to our Q&A.
Sorry, no slides, no pretty pictures, but hopefully you still can remember all of Dave's pretty pictures, and they will carry you through my remarks. I also was going to talk about Otis, but then I would have been arguing with Bill and Robin all the time, so not talking about Otis either. But I did want to talk about this question, which I've been thinking about in the context of environmental statutes more generally, and which I think is a question that our legal system is dealing with, and the court system is dealing with, which is a problem that some people would characterize as statutory obsolescence. And what is it, and what do we do about it? Erin, at the close of her, near the close of her remarks, said, folks are concerned that the Clean Water Act, whatever it was doing, isn't getting the job done. That the things that relate to water quality that we are most concerned about today aren't being addressed adequately. And one question I want to pose, and I'm trying to pose the question more than answer it. I have my own. I have an answer, I think, but I really think it's more useful to try and pose the question, is if we view the Clean Water Act as something that certainly did some very significant things, certainly helped improve water quality in this country over the last 50 years, particularly with regard to controlling point sources and funding treatment plants and the like, but isn't continuing to produce the type of progress that we want, that we demand, that we believe we should be able to have, is that a consequence of something we might characterize as statutory obsolescence? And if so, what then will we do about it? And we might think that the problem is statutory obsolescence for the simple reason that this is a law that was enacted 50 years ago. It hasn't meaningfully been, other than funding infrastructure projects and water projects, the regulatory aspects of the law have not been meaningfully altered in 35 years. The last time that was seriously proposed was in 1994, and progress or efforts to amend the bill were pulled from the floor or pulled from consideration because of fear of what the final bill would look like, and a desire not to let something pass that would not continue the legacy of the Clean Water Act, or at least what the supporters of reauthorization wanted. So we have a bill that's not been reauthorized. Its regulatory provisions have not been reauthorized in 35 years, have not been meaningfully changed, and I think it's worth at least asking the question, well, is it in some ways obsolete? And so what I want to say a little bit about is how we might think about statutory obsolescence, just kind of generally, like what causes it, how would we identify it? Because I do think it matters whether we think the problem is obsolescence as opposed to, say, poor drafting, or something that was based on mistaken premises, or something that has problems for lack of enforcement, lack of funding, right? There are plenty of statutes out there that don't do all the things we want them to do, and the problem is something else, right? Congress has a grand vision of what agencies are going to do and then never writes the checks to let agencies do it. That's another common problem we see in a lot of areas. And again, one of the reasons I'm interested in this is I do think we are at a particular moment where certainly the Supreme Court, the view of statutory obsolescence there is a particular view of statutory obsolescence, and the view that I think we get from the Supreme Court, and I think has been very clearly signaled this term, and will probably emphasized in June, is if a statute is obsolete, Congress has to do something about it. That agencies don't get to pour new wine out of old bottles. And if there are problems today that need to be addressed, agencies don't get to play the game of trying to repurpose statutory language and find dormant sources of authority to address those new problems. They instead have to go to Congress and say, please give us the authority to do it, right? That's the CDC eviction moratorium decision. That's the OSHA ETS decision. I suspect that will be the West Virginia versus EPA decision. And so that might be a way, something that should inform how we think about the Clean Water Act if we think the problem is obsolescence. So, and again, we might think it's obsolescence, we might think it's lack of follow-through by Congress, we might think it's something else. But I do think there is a general view that whatever we think the Clean Water Act accomplished, we're not satisfied with the current trajectory of what it is accomplishing now and what we think it's going to be accomplishing without some change. So what can make a statute obsolete? Well, the most obvious is the world changes, right? I mean, technology in particular. And if you're thinking about what makes a statute obsolete, one of my favorite examples is look at the telecom statutes, right? Telecommunications Act, relatively young compared to the Clean Water Act. It was significantly reformed in 1996. But think about all the companies in the tech space and in the telecommunications space that didn't exist in 1996. We're talking today about questions like net neutrality and whether or not what the rules should be about the relationships between internet service providers and content providers and so on. The authors of the 1996 reforms didn't even know those were questions. Right? The statute, the authorities that were given, the things that the Congress was thinking about at the time are completely different from the things we're concerned about now. And certainly we know that that's a problem in many areas of environmental law, right? Climate change being a big example, that we have lots of statutes that have not been meaningfully reformed in the 21st century that were focused on more traditional forms of air pollution, more traditional sorts of environmental concerns. The language might be repurposable, right? Might be capacious enough to address something like climate change, but we know that's not the focus it had when it was written, and it creates challenges, right? So the language is capacious enough in the Clean Air Act to encompass greenhouse gases in Massachusetts versus EPA, but then when you get to the UARD case, you go, well, we can't quite do all of it that way, so we let EPA do some of it, not others, and again, I suspect in West Virginia, we will see a more restrictive view. Statute may also be obsolete because it's a victim of its own success, right? Statute, there are a lot of water pollution problems. We are going to focus first and foremost on ensuring we get treatment and funding treatment plants so local communities get some help in that regard and really focus on point sources. And we've squeezed we've squeezed about as much out of that sponge as we can. Not completely, but we've gotten the bulk of that, and so the Act's done that, but we have other water quality concerns, and so that, as we talked about, the statute wasn't as focused on, and as Robin noted earlier, it wasn't people weren't aware of non-point sources, right? This wasn't a question of the statute drafters. Or today us being aware of problems that didn't exist at the time, but that's not where we decided to focus our efforts. And there are lots of reasons for that. The political challenges of saying the federal government's going to start regulating farmers, for example, being one of them. There's a lot of changed understanding, a lot of knowledge that is different. We know a lot more about water pollution. We know a lot more about what affects ecological systems and hydrological systems. We know a lot more about what the consequences are of different sorts of regulatory and policy strategies. Had that knowledge suggests that some of the things that the Clean Water Act did were a smart idea, and some of it says, oh, we could do it better if it was rewritten, right? That's another reason why a statute might become obsolete. It doesn't encompass itself a contemporary understanding of the nature of the problem and how we might do it. Our technical capacities vary, right? A lot of early environmental law, and I'm oversimplifying, was driven at times by, well, what can we actually do, right? In the water context, a point source is easy to identify, relatively. And it's, you know where it is, you can measure what's coming out of it, you can see if the person's complying, you can require a permit, you can check the permit, right? As we all know, yes, there are ways perhaps to try and avoid that or try to engage in subterfuge. In the Maui case, there was lots of discussion of how we define point source could affect folks trying to evade that. But today we know a lot more about how you could monitor. We have the ability to monitor and trace in ways that were kind of science fiction certainly in 1972 and to some degree in 1987. I don't think we've fully taken advantage of that, but there are things we could think about doing in terms of monitoring and enforcement that would have been fanciful 35 years ago. And so that might be a source of changed capabilities. Changed politics. The political consensus that led to the enactment of various environmental laws, is that the political consensus we have today? Right? I mean, in the 20th century, it was common for environmental laws to pass, with overwhelming majorities. Not all of them, but pretty common for that to happen. I don't, unless it's giving lots of money to state and local governments on a bipartisan basis, I don't think you can get that you can still get big bipartisan votes, right? We had that conservation bill a few years ago. We've seen with infrastructure and water resources. But when it comes to the regulatory stuff, the politics have changed. And so, that can be, we might think of that as a type of obsolescence, a statute not reflecting public consensus. And then change legal environment, as I've already mentioned. The jurisprudence of the current court is not the jurisprudence of the Supreme Court of the 1970s, of the 1980s, probably not of the 1990s. It's probably different than any of us remember. I say probably because, I say probably because I was thinking about what I was gonna say today before Wednesday's order, so I might have had to adjust it. But that matters, right? Because it's something that we should think about. And the fact that there are additional factors which really weren't at all on the minds of at least those focused on the Clean Water Act, like climate change, which matters for water, contaminants like Pfas and microplastics and the like. I mean, there are lots of things that we were not thinking about and focused on that we might lead us to think that the Act is obsolete. And there are some things, there's some things that are kind of obvious. As I mentioned, contaminants that we hadn't thought of. We have knowledge about the nature of cumulative and synergistic effects among pollutants that we didn't have 35 years ago. Our old-fashioned dose-response curves don't really capture what we care about in a lot of consequences. We've been talking a bunch today about environmental justice and about how some communities bear a disproportionate burden, and part of the concern that we are aware of today but have not always been aware of is that part of that concern is because of the cumulative nature of the burdens. So a lot of things that the Act doesn't address. Now, for much of the last 20, 30 years, because statutory obsolescence isn't unique to the environmental context. It's something that we see in other areas. The response to statutory obsolescence has been administrative creativity. Some of this goes by under the label of presidential administration, largely owing to a famous article by Justice Kagan when she was an academic about the executive branch taking more kind of control and ownership over administrative policy and directing agencies to act in ways that are consistent with the current administration's policy agenda and vision. And part of that is, in some respects, herding agencies along and helping them perhaps adapt or respond to changing circumstances. And that was something that the Clinton administration did in the environmental context when Congress wouldn't, for example, enact changes to laws governing various natural resources and federal lands. The Department of the Interior was, Bruce Babbitt and John Leslie were very creative in trying to figure out how to do administratively what Congress wouldn't authorize. The Bush administration, when Congress would not enact its proposed reforms to the Clean Air Act, largely because Congress wanted to include carbon dioxide, and the Bush administration decided it didn't want to include carbon dioxide. It tried to do that administratively by simply rewriting the regulations, and unlike with the Clinton administration's efforts, most of those efforts were thrown out in court. The Obama administration, under some laws, something similar, right? Much of climate policy is, at the EPA, was a response, at least in part, to the fact that Congress did not show an interest in climate legislation. But one thing that's certainly, I think, different now is those avenues of dealing with the problem of obsolescence, letting the updating occur within the administrative process, doesn't really look available. We seem to have a Supreme Court, at least, that isn't interested in that. That wants the agencies to go back to Congress. There may also be an interest in other sorts of constraints on agency action, which, in the context of the Clean Water Act, might also be a particular problem. That is, that we talked earlier today about U.S. versus AEP. I'm not sure the current court thinks that view of the Commerce Clause is the right view of the Commerce Clause. I'm not convinced they would adopt it as expansive a view as my brother Adler expounded earlier. Not sure about that, but I think there are hints of that. If we're talking about 404, I strongly suspect the court's view of when Section 404 might create takings is quite different than what lower courts have assumed for the past 30, 40 years. And there's also something else which I want to throw out, which I think fits into my theme, but I think it's particularly important just to note that is something that's changed in the legal environment that I don't think was thought about in the Clean Water Act, which is the way policy-driven litigation combined with jurisdiction shopping creates a particular challenge for trying to administer any sort of complex regulatory statute. And I think that's a particular problem for the Clean Water Act because unlike, say, the Clean Air Act, the allocation of which courts get to hear which sorts of cases makes no sense and makes certain types of reforms particularly vulnerable to attorneys general of the other party that want to make an administration's life miserable. So these are some things, this might lead us to, and I know I'm at my time, so let me say, if we think the Clean Water Act is obsolete, what do we do about it? Well, the administrative avenue might not be there. The easy answer is, well, Congress can just fix it, but we're not very optimistic about that. I mean, we can maybe hypothesize strategy. So I'm going to throw out an idea that I played with in a paper I co-authored with Chris Walker that was looking at the question of how does among other things, how does Congress make itself deal with statutory obsolescence by legislating on a more regular basis. And I throw this out because it's something that we've been toying with, and I'd love to see what would happen if someone takes this up. So, as I mentioned, the Clean Water Act has not been reauthorized since 1987. And in principle, agencies aren't allowed to spend money because Congress isn't allowed to appropriate money for unauthorized programs. Now, Congress can get around that because if no one raises a point of order, the appropriations bill passes and the checks get written and no one cares. But as I understand the way Congress's rule works, all it takes is a point of order. And you could tie up the money that enables the EPA to issue permits under the Clean Water Act. The prohibition doesn't need to be reauthorized, right? If Congress enacts something prohibiting something, you can't discharge a pollutant without a permit. That's the law until Congress changes it. But the agency action, which requires the expenditure of money from Congress, needs to be appropriated. And again, that money is supposed to be appropriated pursuant to a program that's been authorized. The reason we kind of threw this out is because we speculated that if the prohibitions remained, but the permits that allow folks to operate within those prohibitions were uncertain, that might be the sort of thing that might make Congress realize that it has to get back to the old-fashioned idea of legislating, which means you all get to sit down and you realize no one's going to get everything what they want, and you're going to have a compromise, and you're going to have to do something that updates the statute in a way that is livable, at least for those who want the statute to continue to improve water quality, but also to be not overly burdensome to the regulated community. Could that work? I don't know. If any of you have better ideas about how to deal with statutory obsolescence, I'd love to hear them. But I do think in the context of the Clean Water Act, like other statutes, that is something that we need to think about. And I apologize for going over, and I'll stop there.
Well, thank you to all of our panelists, and we will definitely take questions now, but I wanted to also give the three of you the opportunity, because there's been some very fresh and interesting ideas, including, forced compromise, which is a very novel concept these days. But if either of you want to comment on anyone else's presentation, I want to make sure you guys have the opportunity to do that before we turn to questions.
So, Jonathan, is the essence of your argument that the Clean Water Act is obsolete because
No, I think the statute might be obsolete. I think if it is obsolete, the consequences of its obsolescence are greater because the ways we have dealt with obsolescence are less available. That is to say, if the problem of obsolescence is a lack of updating, a lack of keeping something contemporary and up to date.
But that's my question. Is it out of date because the viewpoints of our is obsolete because the problem that it sought to solve is solved or can't be solved by
Maybe all of the above. I mean, right? Because point sources largely solved. Certainly, but not right. Non-point sources not solved. Can it be solved? Well, if every state, if the rest, all the country becomes like that part of California, solved. Otherwise, not solved.
Not solved, just progress.
Okay, so or closer to being solved. And is Congress different? Well, sure, yes. Is in statutory obsolescence, I would argue, is always first and foremost a consequence of Congress not doing its job. And we may say it's not doing its job because they don't want to do their job. They don't. I mean, we can attribute that to whatever we want. But certainly, my view is that that's always the first order reason that the reason why environmental statutes were subject to reauthorization in part was because, hey, we're going to have to revisit this and they just stopped.
I think that's a really valid point. I think it's really important that you raise this point. And the only thing I would add is if we apply that test to the Clean Water Act, how many other bedrock legal acts would we also undo by that same logic?
There might be a lot.
I think
Yeah.
so. And so it sort of raises the question, and I think it's a legitimate theoretical question about, some states like mine, Florida, require us to do a constitutional revision every so often. Some, Jefferson thought that was the way to go federally. But I don't have an answer to this question as much as to raise it. I think your point really raises important questions about, is there some reason for slowing down the winds? I don't know. Is there some reason to have a bicameral system to sort of slow down fast changes? I don't know the answer. I think it's a really important question that you raised. I just would question how far that should go.
Well, I know we have several questions, so we'll start over here.
So earlier talked about the various parts of the statute and language that can be read different ways, use of different words, everything. What about using other statutes to inform or direct what should be done? For instance, Section 102(1) of the National Environmental Policy Act, which says that it directs all the agencies of the federal government to interpret public laws and regulations to effectuate the goals set out in NEPA, which include protection for generations to come, public trust, all of that. So, certainly it seems to be where the Biden administration has stated its general policy. But thoughts on whether the courts are going to look favorably on that at all?
I'm not leading with that in any of my briefs. I think as we all know, like, broad sweeping language, even within the statute that is being interpreted, doesn't carry a whole lot of weight with the courts generally, and particularly I think with the Supreme Court when it's sort of sweeping public interest oriented language. So I think just as a matter of tactics, importing language from another statute that I don't think the courts particularly like and using it to sort of add some muscle to the Clean Water Act it doesn't seem promising.
I might actually disagree with that a little. So if we assume Chevron's not going to be overturned, and I actually don't think it will be, I think the Supreme Court will continue to ignore it, other than the occasional concurrence or dissent that complains about it, and but it will be left around for lower courts to use. And there's a lot of empirical work now about the effect that it has. And so in that context, for example, an executive order reminding all of every federal agency, this is how they should be interpreting their authority, i.e. this is how they should be using their, what I wouldn't call interpretive authority, but it's really policy discretion, right? What is the definition of a source was not a question of semantic meaning, it was a question of policy choice. That can have an effect. And outside of at least of one federal district court in Louisiana, that sort of executive order shouldn't cause a legal problem. I'm referring to the social cost of carbon decision for folks that missed the reference, where a court declared an executive order unlawful even without pretending it wasn't what it was doing, and made a mess of like 2/3 of the administrative law syllabus. But if you're doing that and you're focusing on policy discretion, I think there's a lot of room. I think the problem is where what it looks like the agency is doing is more. That's when you're waving the red flag in front of the courts, right? And the problem in a lot of contexts is the phrase I keep using is new wine out of old bottles. And if you go back and listen to the oral arguments in the two COVID cases, and then you look at those decisions are sparse. There's not a lot there to get out of them, but it's pretty clear that's a motivating thing, and that's what you have to be worried about. But saying, hey, interpret your authority to advance this goal that Congress endorsed, that would seem to be relatively safe in terms of some of the things we're talking about.
I have two questions. The first is for both Professor Aaron Ryan and Professor Jonathan Adler. The first is whether one of the sources of ossification in the Clean Water Act is our system of cooperative federalism. When that is combined with public choice dilemmas, doesn't that drive the lack of success of Clean Water Act? And I'm speaking from someone who lives in Alabama, where you have one political party that's functioning, state judges who are elected, no fourth state to speak of, and then an agency that broadly favors industry. My second question is, given the extent to which Congress holds the federal government and the economy hostage with the debt limit and failure to pass a budget, is the use of appropriations really the best response, given our experience in that arena, in getting Congress to update the statute? And that's for Jonathan.
I do think cooperative federalism can be a problem, probably for somewhat different reasons. And I have what's probably a minority view that I think part of the big problem there is that it for all but the experts, it diffuses accountability because it's not clear to everyone who's responsible for what, and blurring of those boundaries increases the costs of monitoring and enforcement and holding policymakers accountable. And in areas where you see less of a federal presence, there is evidence, it's not overwhelming, but there is certainly suggestive evidence that in areas where the federal government is less involved, you do see greater levels of state innovation and you see greater levels of states copying successes. Why that is I mean, there have been various papers trying to give an explanatory account about why that is, and I know the ones that I find personally convincing, but I don't think empirically we can say this account is the reason more than the other. But I also suspect that in our current political environment, one factor is that if the federal government's involved, things are polarized in a way. It's not solving a local problem in your local community. It's now something that where a red team versus blue team gets involved. But so I definitely think the way we allocate responsibility between state governments and the federal government in environmental policy is not always helpful. On the other one, I would just simply say that if Congress feels or wants to spend money or feels it needs to spend money, that does seem to motivate them more than other things. And the other thing that motivates them is some clear need that is felt by constituents that don't have a clear partisan valence. So, you look at things like how quickly Congress moved when there was a big concern about the VA, right? Congress is capable of doing it. And my point is simply that while we may not like kind of debt limit dynamics, action is better than inaction, and if replicating that sort of dynamic is what forces congressional action, well, then maybe we need that. And there are contexts where we do that in a less high-stakes way. The Base Closing Commission, the way we do fast track for trade negotiations, there are a bunch of areas where Congress structures the way it can make choices. So it has to make choices within a certain time frame, but it cuts off what its options are. And those are all done kind of with an awareness, Congress's awareness of its own limitations and the way politics will get in the way if the decision-making structure isn't designed with that in mind ahead of time. I don't think we're in the position to be kind of designing the full decision-making structure because that would require proactive legislating. I'm kind of proposing the last-ditch thing in the sense of, okay, well, you haven't done that, but there are levers that you might pull that could force Congress to do what it was supposed to be doing anyway, and what's the alternative? Right? Last example I gave in the paper I did with Chris, we talked, for example, about ag programs. You may like them, you may hate them. They get reauthorized, and we know why they get reauthorized because the default, the way the statutes are structured is that if they don't get reauthorized, they revert to these like Depression era defaults that would wreak havoc. It kind of operates like the hammer provision in RCRA, right? Where if certain things don't happen, the default is sufficiently unpalatable that people that otherwise do not share interests will come to the table. And in an area where kind of the ability to work across partisan lines isn't otherwise available, you probably need something like that. And it's not ideal, but I think it's better than kind of waiting around for them to suddenly reach consensus.
I'll just give a very quick rejoinder on the cooperative federalism issue because I know we have other questions. My very quick rejoinder is just that I'll identify it's from the perspective of someone who tends to worry more about the underprotection of environmental values and the overprotection. I feel probably wishing that there was somehow a bigger federal force to overcome what you see as underprotection of environmental values in Alabama. But I will just say that from that perspective of worrying about environmental underprotection more than overprotection, I have never been more thankful for the cooperative federalism model in environmental law than I was between approximately 2016 and 20. So I think that that's a value that both sides of that issue can feel, which is all the eggs are really in one basket, and then you end up not liking anybody who has any of those eggs. You really, it's a problem. So I think that the cooperative federalism model does a flawed but better than alternative job at managing the plurality, the pluralism, and the pluralism of values.
We have a burning question up top.
Thanks. It's nice to hear from three very skilled presenters. So quick question for each of you. So for Dave, you were talking about the difficulty in the monitoring and such, but I was wondering, with the advances in remote sensing, is that really still the case? For Aaron, I've been hearing all kinds of stuff about rights of nature. About a decade ago, I heard all kinds of stuff about the public trust. I'm just wondering if there are these sort of moments where something's possible or something's not. And Jonathan, I'm puzzled by your use of the term obsolescence or obsolete. I mean, if you took if the Clean Water Act disappeared tomorrow, there would be changes. I mean, it seems to me it's like saying the speed limits are obsolete because they've been around for a long time and they're working. We've got self-driving cars, so there are new issues. So maybe it's inadequate or it's insufficient. But the term obsolescence, the way you're using it, doesn't jive with my understanding of the idea of obsolescence.
Yeah, so if we're going in order, from the conversations I've had, technological evolution makes a difference. And so some aspects of monitoring are either getting easier or potentially getting easier. So to give a very concrete example, if one of your BMPs is to have cattle fencing areas or in remote areas to have buffer zones along streams, you can potentially monitor with drones, and the agency is thinking about getting them. And you can imagine how that's going to go over in an area where marijuana growing and gun ownership are both through the roof. But seriously, no, technology is evolving, but still what I was hearing was it's partly a monitoring challenge, but it's also a talking challenge. Like if you're going to regulate in rural communities that traditionally have not been regulated, you need to sit your butt down in a chair and talk to people and couple that with the monitoring, and that's hard to do over large geographic regions.
Your question to me was about whether the public trust doctrine and the rights of nature movement are just having moments in time and whether they're passing. Flashes in the pan, I think, is the gist of your question. And I think I can speak more confidently on the first part. No, I don't think the public trust doctrine was a flash in the pan. But what I think it did was instantiate itself maybe in other parts of the sort of tripartite system of lawmaking that we have. And so in litigation, and Dave, you've written about this really persuasively, for example, in the California example, the example of California, where it may have been that the public trust doctrine was taken out of the courts and put into the administrative state. Where, for example, in California, it's a very important part of administrative procedural decision-making environmental matters, and I think that's true not just in California. So I definitely don't think it was a flash in the pan, although it may be that people try it out for new things, like let's try it out for biodiversity, and California had one case that said yes and then tries to pretend like it never had that case. So there may be things that look like flash in the pan. With rights of nature, I think it's too early to tell, but I think it's probably wrong to frame it as a flash in the pan when it has had so much rhetorical power internationally and domestically, and the question is whether it's going to function again in litigation, and my guess is probably not so much. That's a different environmental ethic from the rest of our system of laws, and it fits ill in the Western tradition, although maybe more so in indigenous courts. I think what it's doing is something that the public trust doctrine also did that was really important. I'm writing about this in the book right now, which is that it has this power to shift the conversation, even if it fails in court. One of the functions that the court serves for the public is it's a place where you can go and air your grievances. And even if you lose in court, like Juliana will probably do at this point, they manage to get their message out to leverage the other branches of government to think about these issues, like happened in Massachusetts in the government I mentioned. So we have to remember that it's kind of a conversation between all three branches of government. And so things that don't succeed judicially don't mean that they're ineffective. It may just be that they're having their effect by leveraging the power available to litigants, citizens as litigants, to communicate with these other branches of government.
So, I mean, in part, if obsolescence means no utility whatsoever, well then no. But I view obsolescence more as a question of being outdated in a way that severely hampers contemporary effectiveness. So, the the giant tube-based TV that I had when I got married, that like that was like the most awesome TV I ever imagined having when I got it in like, I don't know, like the 90s or something. You know, when I got married and my wife and I were figuring out what we're doing, you know, we realized that was kind of an obsolete TV. It wasn't cable ready or whatever. You know, I mean, but I could still watch TV on it. It was better than nothing up until the point we were moving in together and figuring out what was going where. I didn't want to get rid of it, but it was obsolete, right? The computer I have that won't run Windows, I don't know, 8 or whatever, I can do stuff on it, but it's obsolete. I mean, I think that's a fair use of the word. And the point I mean, the reason for using it is because I do think we're at a moment where this idea that laws, particularly in the regulatory context, are not being kept contemporary or up to date, and that is something that across a wide range of areas creates a certain set of problems that come to court, makes it worth thinking about in this context, because I think it's something that in technology-dependent spaces, it's particularly important. And I think telecom and environment are there. So I mean, you know, but if there's a better word, you know, outdated doesn't have the same rhetorical.
So I'm just going to follow up here to partially disagree, I think, with one of the premises of this conversation. I think we, as law professors, tend to evaluate statutory and legal regime change by asking if the statute is being updated and if major rulemakings are happening. And this is a permitting statute. And what I have learned through the research projects I've done on the Clean Water Act is that it is evolving constantly in implementation through permitting. And these are 5-year permits in many cases. So there are constant cycles. The next permit is different from the last one in some ways. And so I think in some areas it is probably not evolving as much as it should, in others maybe more so. There is a need, I think, for legislative updates and rulemaking and things like that. But I think it's a mistake to think that things are static out there when changes on the ground through permitting have been significant and really in many cases incremental and steady over long periods of time.
Go ahead.
Oh,
I'm sorry, go ahead. You have the mic.
So I have a normative claim I want you guys to maybe get at, and then, well, a descriptive one, and then see if it extends to a normative claim, which is when the Clean Water Act was passed, right, I think either at the time or over time became one of those super statutes, right, that we've had described by the court, either having some kind of super statutory effect or some sort of quasi-constitutional effect, which extended into the broader administrative state, right? When we talk about the administrative state, I think most people are really thinking about environmental regulation writ large in that context. If that's sort of the case, then these developments like the public trust doctrine and maybe even the rights of nature seem to be less to be supplements than to be sort of substrata, right? Sort of the reasons for the existence of such regulation and justifications for that regulation rather than necessarily interpretation of that regulation. And I'm curious, which direction do you think that pulls, right? Does that pull us to therefore seeking to do more of this kind of statutory centralization, maybe even cooperative at that sort of super statutory level? Or should that push us to do more devolution, right? In the sense that let's get it all the way down to these smaller regional units, which are more capable of doing this kind of, sub-level work at implementing that particular set of rights and ideas.
Yeah, so the first part of your question was, is public trust, rights of nature, are they like the reasons for the Clean Water Act? And therefore, does that say something, does that change something about the relationship between the doctrines and which becomes more important? Is that
Yeah, I think the descriptive claim is that these are not just normal statutes, right? They have a power both as a function of organizing society, organizing business, organizing behavior that goes beyond what we think of normal statutes doing, almost to the level of sort of a kind of constitutional framework, right, around them. And the question is, if that's something that we think has happened with that and the broader administrative state. Questions are which direction should we go then, right? Do we go further to further constitutionalize that work, or do we sort of adopt the movement that's happening right now, which is to devolve and get away from constitutionalization and superstatutory work on environmental?
I understand. I'm going to leave to my colleagues whether we should see the Clean Water Act as a constitutional kind of a feature. I'll just, because you started with public trust and rights of nature, I'll start by saying I think you're right to notice that the premises of the public trust doctrine, to the extent that the premise of the public trust doctrine is that waterways belong to everyone has an interest in them, and to the extent that the rights of nature movement says waterways deserve to be protected because they are worthy of protection, even independently of their utilitarian functions. Therefore, we should have a Clean Water Act that makes us clean them up. That's part of the way we protect them. I mean, I think that's a legitimate way of ordering the concerns. As a legal mechanism, the public trust doctrine and the rights of nature movement are so weak by comparison to the remedies that are available within the Clean Water Act that they are functioning as they may be the reason for the Clean Water Act, but they don't exist, in most cases, they don't exist with the legal remedial force that the Clean Water Act has. That's why I've characterized them as kind of last resort doctrines, where you go in as a gap filler because you're trying to do something that the statutory laws don't quite get to. But it's so much easier to just get a result, and the law tells you what that result should be in many cases with these super statutory approaches like the Clean Water Act. So I don't know whether I would not vote for getting rid of any of them, but I would vote for the Clean Water. It's not up to me. But if it were, I would think that the Clean Water Act in its less obsolete version could maybe do more to correct the central flaw of American water law that we've recognized for a long time, which is this artificial separation of regulating water quality and regulating water quantity when you can't really do it. So, the Clean Water Act next version, should do better to correct some of the failures that set us up to needing rights of nature and public trust doctrine. But I wouldn't get rid of any of them for the same reason that I think that these doctrines do work in my conversation with Jim Salzman. That these doctrines are doing work by being like backstops to one another. That, we never get it all the way right. So we have a number of different approaches to try to kind of enter the fray and try to correct these problems.
I'm going to talk sideways from your question to make a couple of short claims. They're somewhat responsive. One, I know as academics we like thinking about certain statutes and super statutes and kind of the quasi-constitutional aspects of the administrative state. If that was ever true, as just a matter of kind of where the courts are now, no. And with Clean Water Act context in particular, right? We keep talking about the order from Wednesday. I mean, whatever one thinks about how states were or were not taking advantage of Section 401, I mean, the Clean Water Act, Section 401 of the Clean Water Act had been applied pretty consistently pursuant to a Supreme Court opinion for, 30 years? And the Biden administration wants to go back to that position, and the Supreme Court's kind of saying no, or it could say no to the court staying the Trump rule that the Biden administration wants. I mean, so that's kind of, at best, that's just, it's basic administrative law. We have a rule. It has not been withdrawn. Until it is withdrawn, it's not just going to get blown up by a court that hasn't. I mean, that's kind of the way the Supreme Court's looking at it. It's one descriptive claim. The other one I'd say is, there are two stories we can tell, or there's a story we can tell about environmental law. I'm not sure it's true, but it's a story that I think is appealing, right? Which is one of the reasons we have a lot of environmental law, is because there was a systemic failure of existing legal and political institutions to protect rights when those rights were violated in what we would characterize as environmental harms. And I'm not sure that's entirely true as a historical matter. Maybe something of a fable, but I do think that story has normative force, right? That even folks that tend to, when people are critical of environmental law, they talk about the bureaucratic aspects of it. They talk about the red tape. They talk about the Sackett not being able to build a home. They don't talk about a company dumping stuff into someone else's backyard or poisoning their children. And I think that's why, right? Because there is this kind of conception of what environmental law at least might be about, which isn't rooted so much in rights of nature and public trust and so on, but is actually rooted in a very kind of, traditional liberal notion of rights and that the state exists to protect against harms. And if the trespasses are occurring through pollution, they are just as deserving as control of as if it's if it's the mobile home that's driven across your field, your snow-covered field. For those of you that have read the Meryl Smith casebook. I mean, again, I'm not sure that's. I like that account. I'm not sure it's actually what happened, but those sorts of accounts do help us understand kind of what purpose the law should be performing in this space, and maybe give us a metric for deciding whether or not we like what it's doing. That's kind of an answer.
Sure. Coming up on time, but we've got a couple more.
Go ahead.
Well, okay, thanks. A quick question for Dave, Owen, and then maybe a longer one for Jonathan. I don't know how much time we have.
It'll come out of my closing remarks, so it's fine.
Okay, I'll leave that up to you then. All right, so Dave, the question really just is about the successes that you talk about treating non-point sources in Northern California. How much of that is attributable to basically easy requirements in your experience? I'm just wondering if there's been a high level of acceptance because they're really not being asked to do very much at this point. So that's just one question. And for Jonathan, I can't disagree that there's some obsolescence in the law. For 100 years, we had a law in the books in Michigan that banned swearing in public places. Definitely obsolete and finally repealed. And I'm the only one in my room in my lecture class this semester who still has a landline. So federal law governing landlines are going to get less and less relevant. But Congress isn't sunsetting this legislation, and it seems to me that the big problem here is that. Or not really the problem, but Congress is overwhelmed. There are tremendous obstacles to actually getting legislation enacted. So Congress is making a strategic choice, which is to legislate broadly. We have other means of legal change, and there's a lot of acquiescence built into the system. So the vast majority of executive efforts go unchecked in court. Professor Dave Owen mentioned that the law is evolving constantly through permitting. Things aren't static. Nobody's raising a point of order. Nobody's passing a Congressional Review Act resolution. So shouldn't we instead see this as sort of an uneasy modern compromise where Congress is, legislating broadly and muddling through with a fair amount of acquiescence? And wouldn't it be a problem to basically force Congress to effectively sunset a whole lot of these laws? And just to make it a little more provocative, maybe the problem is really the court, and the solution to the court getting frustrated with what it sees as this uneasy modern compromise. The solution is, 15-year terms for Supreme Court justices. Okay, I'll leave it there. Thanks.
So my answer to your second question is yes. My answer to the question you actually asked me is it's complicated, but there are some pretty demanding requirements. And just to give you one example, again, I'll come back to the Pronsolino versus Nastri case, just because I think it may be familiar to some of you. If you read the fine print of that case, the Pronsolinos claimed expenses of about $1 million from the regulations that were imposed on them. Larry, I think Maillard is how the guy's name is pronounced, who's another landowner, claimed expenses of about $11 million. And I did have a student who once said, yeah, well, he owns all of Sonoma County, so no big deal to him. But still, if you are telling logging companies or individual landowners, you need to preserve buffer zones along streams, which in a redwood forest is where the trees grow the fastest, and you're also saying you need to stay off or limit your harvests on steep slopes. It's all steep slopes in a lot of these areas. Those are demanding requirements. Similarly, I think the requirements that were imposed on dairies, less demanding, putting fences, but the margins of these businesses are tiny. And regulators told me, we're conscious that we are coming out here with regulations for a bunch of 70-year-old dudes who are barely making it as it is. So there were legitimate regulatory requirements in some places. In other places, they're easing in and taking it fairly soft. And I think it definitely matters also that they could go out and say, you know, we're regulating you and you need to fix your roads so they're not eroding. Oh no, by the way, it's going to save you money also to have a road that isn't eroding, or to go into landowners and say, we can get some grant funding because this protects salmon, or in some cases to say there's a nonprofit that would actually just like to buy your land and then you don't have to deal with being regulated. So there's a whole package of reasons why they are able to make inroads, but they are doing things that impose real changes in some circumstances.
So I took the court as a given. We could have a conversation what the court should or should not be doing. I'm sure we won't agree. But from the standpoint of thinking about the Clean Water Act, my view is that the court, if you're working at the EPA, if you're in Congress and you care about water pollution control, what the courts will not accept is a constraint you care about. And so I think it's a relevant constraint to think about. I do think Congress, having the rules it has about authorization, and up until 1994, reauthorizing environmental statutes pretty regularly, is an indication that they kind of did sunset those portions of the laws, right? They didn't sunset the prohibitions, so it's different than what you see in a lot of state sunset laws, where actually the whole program, including prohibitions, have to be renewed in some cases. Where some states have sunset laws like that. But that was kind of the premise upon which Congress enacted the statutes, right? And what happened in 1994 was that the congressional leadership decided that it didn't like what the laws were going to look like if they were reauthorized, so they decided not to reauthorize them. And then Congress never came back to the table. Well, they did for the Safe Drinking Water Act, but I think not for pretty much the rest. And I do think that creates an opportunity if one thinks that there are things you could do in the Clean Water Act that would make it more effective if you could get everyone to the table. Now, maybe I'm wrong about that premise, but if I'm right that there are things that if you could get everyone to the table and get them to take a vote on it, that there are things that would make the law better able to address the sorts of problems we deal with today, then I think thinking about what gets you to that point is useful. Thank my co-panelists. Thank all of you for being here all day. Thanks to our speakers and our moderators. The papers from this will be published in a volume of the Case Western Missouri Law Review, so thanks to the Law Review students that helped us out and whose work on this is just beginning. We can't do this without a lot of other help, as I mentioned this morning. Rob, who's hiding back there, helping us with the AV and getting Sheila Olmsted to be with us on the fly. Patty and Eric, who are outside, who do so much for the center and for all the centers to be able to do programs like this. Neither of my deans could be here today, but I certainly appreciate the support they give to programs like this. And as I mentioned this morning, I always think it's important to remember Coley Burke, who made this possible. So thank you all. Thanks for being here. Thanks for being part of what I certainly found to be an enjoyable conversation and an illuminating one and a provocative one. And I look forward to our being able to have more such conversations in the future. So have a good weekend, safe travels home to wherever that will be, and I look forward to seeing all of you again soon.